Thank you. Good morning, all. This trial is in the matter of CFI 034-2022 and is being held by way of video conference before Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the court or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Stevenson Harwood Middle East. Lead counsel is Mr. Mark Lakin. The defendant is represented by Baker Tilly Law Corporation for Legal Consultancy. Lead counsel is Mr. P.V. Shaheen. Thank you, Your Honor.
Thank you very much. Mr. Lincoln. Hello? Is it Mr. Lincoln for the claimant?
Yes, Your Honor. I believe there might be ongoing technical difficulties.
Can I have this on this screen as well? It's not working.
We can hear you now, Mr. Lakin.
My lord, apologies. We're having a few technical gremlins. Hopefully we'll work them through very shortly. Apologies.
Right, well, let's see how we get on. You're for the claimant, I think.
Yes.
Do you want 5 minutes to sort out your problems, or will they be better sorted out in real life?
Yes, my lord, if you wouldn't mind, that would be good. We're almost there. We're better than we were. I can hear you, which is a positive. So hopefully we'll be sorted out shortly.
Hello there, this is the court reporter. Just to reiterate that I can hear Lord Glennie perfectly well and Mr. Lakin perfectly well when he's coming through, but Mr. Shaheen is still muffled. I'm wondering if there's a way to move to the laptop microphone rather than the external microphone that you're using, sir.
I have put an additional microphone now and I hope I'm audible. It's better now.
It's not better now, sir. It's still muffled in comparison. But is it possible to go through your laptop audio?
I really don't know how to do that.
My lord, we should now have sorted our technical difficulties out. Can I just check that you can hear me?
I can hear you, thank you. Yes, I think we're waiting to solve Mr. Shaheen's problem. So if you can just hold on for a moment, Mr. Is it Lakin?
Hello, excuse me. Am I better now?
Yes, my lord, Lakin.
Mr. Shaheen, when you speak a few words, it's a little bit harder to tell, but your audio is coming through more muffled than the others. The others are crystal clear. I think because they're using a laptop audio method.
No, I'm not using a laptop audio. I'm using a separate mic and everything is separate. Only the laptop is there for connection.
Yes, I think that's why I was wondering if you could switch to the laptop microphone, because I think that would be potentially clearer. You are a little muffled coming through, and I'm here taking down everything for the transcript. If there's a way you could try your laptop audio.
Can you hear me better now? Some adjustments are done.
No, actually, it's worse now. Sorry, there was some static behind that. Oh no! Now we've lost you altogether.
Now is it better now? Going back to the...
No, it's not. It's not clear.
Would it be better if Mr. Shaheen went out and came back in again and just see if that works? Just on your laptop.
I'll try that, Your Lordship. Yes, Your Lordship, I have done that. I've exited and come back. Hope it's better now.
You are audible, sir, but less clear. So if we'll try, if you could please speak very slowly and clearly today.
Sure. I'll try my best.
Well, shall we, is that all right for the transcribers? You've got enough clarity, do you think?
Well, you're very clear, sir, as is Mr. Lakin, but Mr. Shaheen is coming through more muffled. So that's why I was trying to see if there was a way we could perhaps switch him to his laptop audio, because that seems to be clearer generally.
I think he is on his laptop audio though.
I think he said it was an external mic. Is that correct, sir?
Yes, madam. I am using an external mic to enhance the voice. And it is the same set I always use in this code. Didn't change anything today.
I wonder if it'd be better getting rid of the external mic for the moment and just trying on the laptop. You're muted.
Is it audible now, Your Lordship?
I can hear you, but it's more the court transcribers.
You're audible, sir, but muffled.
I think I'm lost with options. I don't have anything more to try.
Well, if I can ask the transcribers, do you have enough audibility to continue, or do you want us to stop for 5 or 10 minutes?
I'm currently getting some feedback and can't hear you, sir.
Can you hear me now?
Yes, I can hear you now.
I was asking whether you have enough audibility with Mr. Shaheen, or whether you need to break for 5 minutes while we try and sort something out.
It's muffled. I'm not sure I will be able to get every word clearly. So the transcript would have inaudible when I cannot hear him, which is why I was trying to see if I could do anything beforehand.
It is sort of 1 word in 10 or whole passages?
I cannot tell really until we go ahead, because so far I've only heard a few words.
Well,
Madam, I checked with my other colleagues who are joining from different locations. All of them are saying that I'm audible very clear. And I'll try my best to be loud, clear, and slow during my presentations, because I don't have anything more to try here. We have tried all options.
it helps. I can say I can hear Mr. Shaheen very well.
I can also hear, just then I could hear Mr. Sheehan well, yes.
Thank you.
Well, shall we proceed? But if it becomes a real problem for the transcribers, can you don't hesitate to interrupt and say that it's not working.
Thank you, sir.
Right. Well, let's start. And it's Mr. Lakin. You're for the claimant.
Thank you, my lord. I act for ICICI Bank DIFC Branch Limited in these proceedings, and my learned friend, Mr. Shaheen, represents Dr. B.R. Shetty. Mr. Shaheen is a Baker Tilly. Before we begin, please can I check that you've received the relevant bundles of documents? First, do you have the main electronic hearing bundle that was sent to the court on the 5th of September?
I have the one that's on the court website. I'm not sure what date it was sent to the court, but I have it. If there's anything come in the last day or so, I haven't seen that, but it will probably be on the system.
So the system didn't allow us to. So that's right. The main bundle is the one on the court website. That's the main bundle we'll be referring to for most of the hearing. For the claimant's part, 2 additional bundles have been sent this morning to the registry. One is an updated authorities bundle, and the other is a supplementary bundle with some additional documents in it. I don't know whether the so it has Mr. Albar's second report, It has a few documents in it that should have been included in the main bundle, but weren't. Principally the exhibits to Miss Radley's first report. And it also has a few pieces of intersolicitor correspondence that should have been included in the first bundle.
Right. Is there any objection to those, Mr. Shaheen?
I had a chance to review that. It was submitted today morning only, just a few minutes back. But
Okay.
if it is same things what my learned friend is submitting as the documents presented along with the experts' reports, I do not have any objection, Your Lordship, provided it is the same document.
Well, I'll tell you what we'll do. We'll proceed on that basis for the moment. But if by the end of the break you have any points you want to make, then you can feel free to make them.
Thanks, Your Lordship.
Yes.
It may be helpful if the registry could forward those two bundles on to you, my lords. In particular, I think we may need to refer to Mr. Albar's second report as one of the preliminary matters we need to deal with.
Can we have it? Can we have it put on this in the right place on the system? For example, the expert reports are in section I. Can Mr. Albar's report go into that?
I understand it's quite difficult to edit the bundle once it's been uploaded onto the court system, which is why we've sent it through as an addition. I don't know if the registry can upload these two bundles as additional bundles on the court website.
This can be done from the parties side by way of an electronic filing cover sheet. But just to say that we have already forwarded these by way of email to the judge earlier this morning.
I see. I haven't picked that up yet. Do you want me to open them now?
Just that maybe we can proceed without them for now. I'll give you the bundle references in those two bundles when I refer to something. There is one judgment that in the authorities bundle that I was going to take you to when we discuss one of the preliminary matters. So
right.
if you could open the authoritities bundle,
give me a second. I'll just need to open my email. Hayley, which was it my personal email or my court email?
Alia, can you please confirm?
I can confirm that this was the court email, Your Honor.
Court email, right, I'll try that. Supplementary case bundle and legal authorities. Give me a second. Right now, if I close this, I'll probably end up cutting you off. But hello? Can anyone hear me?
I can hear you, my lord. Have you been able to download those two bundles?
Well, I've got them on my. Which one do you want me to open?
Nothing at the moment, my lord, but
Mhm.
we'll come to them as we
Yeah.
go along. There's
Yeah.
one set of documents that I also wanted to check that you've received, and that was with the defendant skeleton argument. A fairly substantial exhibit was also sent with that document. I just wanted to check you also had that.
I'm not aware of that. That came what? That came when?
I won't be referring to that in my openings.
I'll tell you what.
So we might.
If someone can send that to me again during the course of the openings, I'll download it at the break.
Those are the four bundle, the main bundle, our supplemental bundle, the authorities bundle, and the respondents exhibit that was served with the skeleton should be the only four things you need to open during the course of the hearing.
So that's what say those again.
So there's the main bundle that's on the court website.
Yeah.
There's a supplemental evidence bundle from the claimant.
Yeah.
And a supplemental authorities bundle from the claimant. Those are the two documents we've just opened. Yeah. And there's an exhibit to the defendant's skeleton argument. And that's quite a substantial set of documents and and cases as well.
I don't think I have that. So, Mr. Shaheen, could you get someone to resend just that bundle which was attached apparently to your skeleton argument?
Yes, Your Lordship, will do that.
Nothing else, please. Otherwise, it'll cause confusion. Thank you. If that can be done during the course of the morning.
Sorry, Your Lordship.
I'm sorry, I cannot hear you at all really now, Mr. Shaheen.
Can you try that again, Mr. Shaheen? Slower.
I mean, the defendant's skeleton arguments and the exhibits enclosed with that. I will send them again now.
No, don't send the skeleton argument. Just send the exhibits.
Okay, Your Lordship. Only the exhibits, skeleton arguments.
I have the skeleton argument, and I've read that, but I haven't read the exhibits.
Yes, Your Lordship. We'll do that.
Thank you. Okay.
Thank you.
And that was the last thing I was going to check that you had received. You've received both the claimant and the defendant skeleton arguments.
Yes, I have. Thank you.
Thank you, my lord. Paragraph 5 of my skeleton. Some suggested pre-reading for the court. That included the pleadings, the facility agreements, personal guarantees in question, the trial witness statements, the two expert reports of Miss Radley, who's the claimant's expert, the first report of Mr. Albar, and some of the a selection of some of the disclosure that's being given. Can I check whether you've been able to read some or all of those documents?
I've read some, but to put a list of desired reading, which basically covers almost everything that's been lodged, is not the most helpful.
But I do appreciate that.
I've read the statement of case, the skeleton arguments, some of the agreements, all the witness statements, and I've skim read the expert reports.
Excellent, thank you, Mel. That's helpful to know. So I think with that out of the way, preliminary points that we need to address before we move on to the openings. The first is the admissibility of Mr. Albar's supplemental report, and the second is a number of arguments that are detailed at grounds 5 to 10, my learned friend's skeleton, that were raised for the first time with the skeleton argument and are not pleaded. I propose we deal with Mr. Albar's report first.
Yes, where do I find that?
To the pleadings point. So the claimant has considered this in quite a bit of detail over the weekend. It's suboptimal. We would normally take the approach to try to accommodate these kind of things, but we are going to take a point on the admissibility of Mr. Albar's second report. I have a number of submission.
Where do I find his second report? In a
So
supplement.
Mr. Albar's second report is in our supplement,
Yeah.
and that is at page 610. Or this will take you to the beginning of this report.
Hang
Um, so it's at 586 to 641.
on. Wait a sec. I'm trying to move it onto a different screen. Right, 586, you say?
Sorry, 585.
Yep. I have it.
So we would take a number of points here. First, it's incredibly late. In your order of the 30th of May, 2024, that's at page 86 of the main electronic bundle. I don't think we need to turn that up.
Okay.
That required supplemental expert reports to be served on the 14th of August. The claimant complied with this direction, and Ms. Radley's supplemental report was served on that day. The respondent did not comply. You may recall at the PTR, the reconvened PTR that we had at the same time, no proper explanation was provided by Mr. Shaheen as to why a supplemental report had not been served. At that hearing, you said to Mr. Shaheen, if he wished to adduce a further expert report, he should make an application very swiftly. Nothing was then heard for 2 weeks, and the application to adduce Mr. Albar's second report was made on the 27th of August. Again, in that application, no proper reason was provided for the failure to adduce a supplemental expert report. You may recall that Mr. Shaheen relied upon what he said was a failure to disclose 11 original documents by the claimant, and an understanding that a supplemental report should have been adduced to deal with those 11 documents. That clearly evinced a complete misunderstanding of what an expert supplemental report is meant to do. And a misunderstanding of the rules of the Dubai court isn't a good reason why the defendant should be permitted to adduce an expert report now. The expert report was then filed on the 18th of September. We've had very limited time to consider that report.
That was Thursday, was it?
That was on Thursday, my lord, yes.
Oh.
This is despite that report clearly having been well in train in the intervening 2 weeks from the PTR, if not before. And a draft at least could have been provided to us so that we could have started to consider it. But no, we've received that on Thursday, so 1 working day before this hearing. We would also take issue with how Mr. Albar has gone about preparing his supplemental report. First, he comments at a number of junctures, and I'll just give you a bundle reference. That's page 595 of the supplemental bundle we're in. He comments on a number of junctures on both Ms. Radley's first expert report and her second expert report, her supplemental report. So we're in a position where the claimants served both of its expert reports, and the defendant's expert has then had the opportunity to comment not just on the first report, but on the second report. So there's a degree of unfairness here. But we would also say more seriously, the supplemental expert report's incredibly long and also raises a number of difficult points that we haven't been able to properly consider. So the first of those, if I could take you to page 610, supplemental bundle.
Mr. Lakin, you've become inaudible.
He's not talking.
I'm sorry. If I can ask you, my lord, to turn to page
apologies.
610 of the supplemental bundle.
Yeah. Yes, I have it.
There we go. So So here he alleges that certain pen and ink signatures, which Miss Radley has identified on one of the personal guarantees that are in question. He looks at those personal guarantees and then goes through them and relies upon other documents, which if you then go on to page 611, he says that a number of pen and ink documents, which he says are the blue ones, page 112 and 9, the document in question, have been signed in pen and ink, and the rest are photocopies. However, Miss Radley says this is certainly not the case. She's exhibited some pen and ink signatures from pages 6 and 7 of this document, and they're shown at page 1034 of her supplemental report, which is in the main electronic bundle. I don't think we need to turn it up for these purposes. However, we're in a position now where Mr. Albar is putting in new evidence that appears to contradict the documents that Miss Radley herself has considered and taken photographs of and has exhibited in her expert report. And it seems to us difficult to see how we're going to get to the bottom of that point now when we're in the trial itself. We'd say there's a similar issue. So if I can ask you to turn back to page 595, the supplemental bundle. There's a very similar issue with 2 pages of the, well, not just 2 pages. So this is Mr. Albar considering the supplementary and amendment letter to the first facility, which was dated 24th of December 2012.
So is this the page that begins? Is this the page?
Sorry,
that begins, sorry. If you look at me, I'll try and indicate when I want to interrupt. Is this the page that begins? We observe that the plaintiff's expert.
Sorry, what was that, my lord?
Is this the page that begins? We observe that the plaintiff's expert.
Oh, sorry, 596.
Oh, you said 595.
So apologies, 596.
Below
here we have another document that the defendant's expert has considered. And Ms. Radley has commented on that in her report and said that she thinks the document is a consecutive document because of a printing defect. You'll see there's a light line on the left-hand side of the page on those 2 documents. And she subjected it to microscopic analysis and says there's no difference on the toner clarity of the 16 different pages of this document. And Mr. Albar has produced here 2 what we think might be photographs of that document to try to make good his point that they are different. However, from the documents Miss Radley has examined, this cannot be the case, and she is concerned he's been looking at different documents to the ones that she examined. That can't be the case because the original documents that were used by both experts were sent first to Mr. Albar and were then sent to Miss Radley. So we would say that Mr. Albar's supplemental report not only is very, very late, it also raises a number of issues that we're going to struggle to get to the bottom of whilst we're going through this hearing. And in those circumstances, we'd say it's unfair for the claimant to have to deal with those this report at this very, very late stage, and we would say it should be declared inadmissible by the court.
Right. Mr. Shaheen, what do you say about this?
Your Lordship, I would prefer to restrict my comments on the experts' reports to the closing submissions after examining the experts.
Well, the trouble is that Mr. Lakin basically is saying we don't have sufficient notice to examine on these points, to cross-examine on these points at such short notice, because this should have all been lodged, filed some time ago, when it would have been possible to resolve these matters, or at least to investigate them properly. So if you leave it till closing submissions, it's too late.
About the timing of submitting the supplemental report, we have already stated in our applications, and it was ruled that it is accepted. So I believe whatever gone before the system.
Mr. Shaheen, I didn't rule it as accepted. I ruled that you should lodge it by a certain time, file it by a certain time, and I reserved the question of admissibility and other things like that.
Yes, Your Lordship. There was a time, and we took for an extension. We submitted an application, and we explained the reasons in the application for extension of time, because the purpose of the supplemental expert report was different from what was covered in Ms. Redley's report. There were no additional information. There were no additional documents submitted. Ms. Redley took upon the task of commenting upon the other party's expert report in a supplemental report, which is not expected according to the RDC rules. We pointed out that in our application for extension of time.
I ruled against you on that.
And one more submission, Your Lordship. And as part of that, our request was either discard Ms. Redley's expert report, supplemental expert report also, or allow us condone.
I'm sorry, sir. I'm struggling to hear you. Can you move closer to the microphone?
Condone the delay and accept our supplementary expert report also. These were the two alternate prayers that we made in our application. And I believe in all fairness, there is no reason to shut evidence. Why is the bank afraid of proper evidence coming before the court?
Mr. Shaheen, there's no one is trying to exclude proper evidence. Not simply because it is evidence. What is the problem is that lodging a document of this detail so late is said to cause prejudice because they can't investigate the points.
It's no new point, no new document, nothing has been covered in the supplemental expert report, sir. It's only explanation to the critics made by Ms. Redley in her supplemental expert report. It's just explaining the correct position, because she took upon the task of criticizing the other experts' report without a meeting, without anything in common.
Why couldn't you produce this report two or 3 weeks ago?
We never expected the other side to come with a supplementary expert report, since there was no additional information,
Mr. Shaheen, that's not right. At the pre-trial review, the supplemental report for the other side had just been lodged, I think.
On the previous day, it was lodged, Your Lordship.
You've had all the time since then. Why have you left it till now?
Immediately, we approached the expert, engaged him, and got the supplementary expert report prepared and submitted it on the same day when we received it.
Why did you not take steps to prepare a supplementary report well before that?
It was our bona fide belief, as per the RDC, there is no additional information, there is no additional documents, there is no scope for a supplementary expert report, there was no discussion between the experts, no developments at all. It is just criticizing the other expert, what Ms. Redley did in her supplementary expert report, to our complete surprise. It is not according to RDC. So
the case management order made it clear there were supplementary reports to be lodged if you wanted to. Anyway,
1 second, Your Lordship.
Yes.
The case management conference definitely stated the supplementary expert reports are to be lodged, but I would add within brackets, if any, because supplementary expert report also is submitted for a purpose, and that purpose was missing. It was not there.
Well, Mr. Lakin, the difficulty the court has is that the court doesn't like to exclude proper information which is relevant to the issues. And the other point that occurs to me is that we've only got so far on the timetable 2 hours set aside for the examination of each expert. If what you're saying is right, I'm not suggesting, I don't know, of course, either way, but if what you're saying is right, that there are fundamental issues here that need time to explore, 2 hours isn't going to be enough, is it, for each expert? You're mute.
Sorry about it will be tight with this additional report from Mr. Albar, but I think we'll still be able to make it work.
Are you saying that you can deal with this material?
It's difficult. We had some initial comments over the weekend from Ms. Radley on it. It's suboptimal given the current position. If the court decides to allow it in, we will try our best to deal with it.
But the court's decision will depend upon, to some extent, upon whether you say there is real prejudice. And if there is real prejudice, that can be cured by an extension of time. For
additional time.
For example, it occurs to me that although we want to use the time we've got, if there is a genuine difficulty in dealing with this new material at this stage, we could fix a one-day continuation hearing just to deal with expert reports and deal with all the other matters, including legal submissions and so on, at this hearing.
I think that would be workable, my lord. Yes, I mean that would alleviate the prejudice to an extent. It doesn't excuse the breaches, and it doesn't.
We can deal with that on the question of costs.
And indeed, it may sound in costs. But yes, I think if we were to have the extra time, perhaps later on, if we were to identify points we still need more detailed input on in order to further cross-examine Mr. Albar on them, then that could work. Like I say, we may be able to get through it in the time we have allotted. It very much depends on Mr. Albar's responses to a lot of this. Like he seems to be relying on different documents than the ones that Miss Radley's relied upon, which is confusing. But we may get to the bottom of that in cross-examination quickly.
But you will have had your expert having given evidence by then.
We will have done, yes.
Which doesn't mean, it means that if you need to ask her about matters that he talks about, it'll be too late by the time he's being cross-examined.
It will, yes, that's correct. It will cause us some difficulties, yes. Obviously, if it's let in, we will try to get as much input as possible prior to Miss Radley being cross-examined. Another thing that occurs to me now is potentially having Miss Radley put in a further very short and purely responsive report, so some clarity can be obtained here.
Can she do that by tomorrow?
We can certainly check, and perhaps we can revert after lunch on that.
Well, let's leave this discussion open for the moment. If you revert after lunch on basis of what you want to do, I'm sympathetic to the difficulty you're in, but I'm also sympathetic to the idea that the court should have all the material that's relevant before it. So yes. If after lunch you can come back having spoken to Miss Radley and maybe spoken to Mr. Shaheen and see whether there's a way forward. The court will, if necessary, if the court's persuaded that it's in the interest of justice to fix a further day, a few weeks on, to deal with this expert evidence in a more coherent way, then the court will be willing, subject to the availability of a date that suits everyone. But I'm not going to make an order to that extent until I know what the result of your consideration over lunch is.
Understand. As I say, if Ms. Bradley feels she can deal with this within the time and capably by Tuesday, that should mean everything is settled in advance of their cross-examinations, which begin on Wednesday. But as I say, we'll speak to her and let the court know our position after lunch.
Yeah. So Mr. Shaheen, you understand I'm going to come back to this after lunch.
Yes, Your Lordship, understood.
Thank you.
The second preliminary matter, which is, we would say, more serious, is the arguments taken in my learned friend's skeleton.
Yeah.
Perhaps we could bring that up.
But I read the skeleton and I wondered, because these are points that you don't touch upon in yours at all. I presume you're meaning the points of Dubai onshore law and so on.
Unfortunately, not, my lord. These are the first time these points have been raised. So I think we can say grounds, well, Mr. Sheen has called grounds 5 to 10 of his skeleton argument.
What page?
Starts from paragraph 39, which is page 11 of his skeleton, and then goes to page page 21, which is paragraph 68 of his skeleton argument. These are all novel points that are not encapsulated in any of the pleadings. They have never been raised before by the defendant and are entirely new. They are predominantly arguments based on UAE law regarding the validity of the personal guarantees that have been given. They do not feature in the defence or rejoinder. They do not feature in the agreed list of issues. No application has been made to amend the defence to plead these additional grounds. So the claimant is therefore seeking clarity from the court and an order that the defendant is not permitted to advance these arguments, these grounds 5 through 10 at this hearing. It would be impossible to deal with those grounds in the time we have available to us today. We think it would be helpful in the additional authorities bundle. If I could ask that you turn up the Dayar case.
That's it. That's in what, in the
This is in the authorities bundle we circulated this morning.
Yeah.
It's at page 504 of the
Dayar.
authorities bundle. Dayar Development PGASC versus Talim PGSC. It's a decision of this court.
Hang on. For some reason, it has come out incredibly small. That's it. Okay, they are, yeah.
So this is a decision of the, well, sorry, not this court, the Court of Appeal and the DIFC courts. And if I could ask you to turn to paragraph 90 and 91, which is at page 519 of the authorities bundle.
Sorry, page
Mr.
one.
Lakin, I'm sorry to interrupt you. You're cutting
Sorry,
in and out. I think it would be
page
better
5.
if you could face towards the laptop.
Sorry, is this better when I'm facing?
That is better. It does cut out just a little bit, but it's better when you're facing. Thank you very much.
Sorry, it might be when I'm turning to look at documents. I'll try to speak to the microphone.
What page do you want me to go to?
So 519, please. And if
Hold on. Yeah.
And here, Dayar had essentially said that Talim had taken a point at trial and the case was decided on a point that hadn't been pleaded in the pleadings. And if I could just ask you that you read paragraphs 90 and 91, essentially the DIFC Court of Appeal adopts what was said in the Three Rivers case.
Right, give me a second. 89 and 90 or 91 as well?
I think 91 is helpful as well. It deals with the El Madani case, which was cited by Daya. But I think it does also give some helpful background.
Give me a second. Yep.
And we would say here in circumstances where all 5 of these points have never been pleaded before and never raised with the claimant, there can be no question that they can be advanced here at trial. As was said in the Three Rivers case, the basic purpose of pleadings is to enable the opposing party to know what case is being made in sufficient detail to enable the party properly to prepare to answer it. We cannot, on the eve of trial, face 5 brand new arguments that are of UAE law and be expected to deal with them here today. They're all points that the claimant would have to obtain detailed advice on from Emirati co-counsel. Indeed, I may well have sought to appoint a Emirati co-counsel in this case so that they could properly advise on these points. There are certain issues of fact that have been raised, in, for example, the actual indebtedness of NMC to the claimant, which had.
Sorry, had that previously been accepted?
In the list of issues, it's one of the accepted issues, and it's not an issue in dispute. That's obviously an issue of fact, and the status of the current status of the administration proceedings. None of those have been raised before, and would be very difficult for us to obtain evidence on now. The trial has begun. The other points are primarily ones of UAE law that go to the validity of the guarantees, which Mr. Shaheen says vitiates them as effective documents. As we'll go on to in the law, we don't disagree. UAE law is the starting point for the validity of the documents, but none of these points have been raised before. They're all complex issues. They all would require significant submissions, potentially expert evidence from a UAE law expert, and would significantly increase the length of this trial. So we would say it's clear that these points should all be shut out from the beginning.
What would you say about that, Mr. Shaheen?
Questions of law. I'm thankful to my learned friend. It's admitted that the personal guarantees, all of them are disputed, but all the personal guarantees contain a specific provision. It's all governed by UAE law. I'm sorry, Your Lordship, I'm raising my voice.
Mr. Shaheen, if you talk a bit slower as well, I think it might help the transcriber.
Sure, Your Lordship. I was about to say, if my voice is too loud, please excuse me. I'm trying to be as loud as possible. It's not that I'm...
Yes, this is the court reporter. You're still very muffled. I'm wondering if in the next break you're able to try to use your laptop audio. It's very challenging to hear you for the...
Sorry, I cannot change the system now. I've tried all my options and everybody else is able to hear it properly. I checked with many people who are in audience. So I'm sorry for the trouble. Apologies, please accept.
Well, can I just say that when I'm getting every word verbatim, it's a little bit different from other people that are listening to hearing, and I like to get a very good transcript. So you're not as clear as everybody else. It's challenging to get every word that you're saying because you're going through an external mic. From my experience, I found that laptop microphones are often better. So I was just wondering if that was a possibility in the next break for you to switch to your laptop microphone.
We tried all those options, madam, and we'll still try up during the break to improve the quality. Whatever is possible, we will try our best.
Mr. Shaheen, I'm concerned that we should have a proper record of this conversation, because if this matter goes further, the appeal court would want to know what the arguments were. And so should we just stop for 5 minutes while you try once more?
5 minutes may not be helpful for me, Your Lordship. We tried everything possible here.
Okay, well, just make sure you speak slowly. And
I will, Your Lordship. So,
Your
Lordship,
yeah.
Sorry for the trouble. Your Lordship, all the guarantees, all of them are disputed guarantees. Despite that, all the guarantees clearly say it's governed by UAE law. There is no dispute about that. And my learned friend has just now accepted that there is no dispute on that. Now, when to plead the defenses based on UAE law? My understanding, all over the world, the principles of law, questions of law can be pleaded anytime. There's no need to plead it in the statement of defense. Here, once a document is governed by UAE law, all the legal principles apply. Even if it is not pleaded, it can be raised at any moment. Even at the review stage of a judgment, the questions of law are raised. And we have raised these points, which are very valid points, questioning the validity of the document itself. And since it's all legal issues, none of them are based on facts. It's all legal issues what we have raised. It's certainly admissible. If my learned friend wants further time, I leave it to the Honorable Court to decide whether to grant further time on that. But as regards admissibility of the legal issues which I have raised, I don't have any doubt, Your Lordship. They are all admissible at any stage of the proceedings, is my humble submission.
Tell me this, Mr. Shaheen, has there been any occasion until your skeleton argument came in where these where points on Dubai law have been raised? I'm using that expression, points on Dubai law, as a summary, as a shorthand for grounds 5 to 10, I think. I don't think it was raised at the case management conference or in the case memorandum or anything of that sort.
The application of UAE law, Your Lordship, is an admitted fact. It's in all the document. Even now,
Mr. Shaheen, that's not my question. I know it's accepted that the application of UAE law is the UAE law applies to these documents. That's accepted. But the points on the UAE law, the feature in grounds 5 to 10, have they ever been mentioned before your skeleton argument?
I will review again, Your Lordship, but my submission here is that these are questions of law, not something to be pleaded, Your Lordship.
Mr. Shaheen, just answer my question, please.
I will verify during the hearing. I'll verify and come back if I have.
No, I need to make a ruling about these matters. My impression is, from having read the case memorandum and the case management order, that there's been no hint of any of these points of UAE law in your in the dispute between the parties.
It's not stated, Your Lordship. I could not find it.
No. Why have these points only been raised now for the first time?
On the understanding that questions of law need not be pleaded. It can be raised any moment.
Where do you get that from?
It's a generally accepted principle of a trial, Your Lordship. Every lawyer is supposed to know the law, and we need not plead the law to the Honorable Court. The questions of law can be raised at argument stage, even at review revision stage. Law remains, whether I plead it or not, the point of law remains, Your Lordship. Whether the guarantee is governed by UAE law or not is a question of fact.
That's not an issue.
Yeah, that's what I'm saying, Your Honorship. That fact is admitted. Once that fact is admitted, everybody in this trial knew that from the beginning, this is going to be a trial according to UAE law, because only the defendant is being sued here. And therefore, all questions of law should be expected from day one until final conclusion of this trial.
Yeah, but it's a principle of fair notice that you identify the points in general terms, at least, before you get to the hearing. Otherwise, for example, you may raise a question of UAE law, and there may be an answer to it based on fact. You don't know.
Anything where there is a mixture of fact, I agree with Your Lordship, but I beg to differ if it's purely a question of law on limitation, validity, etc. There is no need for pleading, Your Lordship. That's my humble submission. There's no need for pleading at all.
For example, in one of your grounds, I think it's ground 5, validity of electronic signatures. You refer to UAE law, but it raises questions about the circumstances in which the electronic signature was used. Those are questions of fact.
Yes, Your Lordship, and the electronic signature issue came up only when the expert reports were submitted, which is copy-pasted. Copy-paste is not the way electronic signatures are validated. So I had to plead it at that stage.
That's the very point. If you had pleaded this point earlier, people would know that there was an issue to discover the circumstances in which electronic signatures might have been used.
Your Lordship, the question of law is arising from a finding on the fact, and the finding on the fact happened when the expert reports were submitted. Soon after that, the only opportunity was the skeleton arguments. We have pleaded. Immediately, we have mentioned that this is the position. Electronic signature, copy-paste signatures are not equivalent to electronic signatures which are certified or validated. There are certain requirements for that. So we had to point out this question of law, this legal provision under the UAE law, which governs the personal guarantees. But we wouldn't know that these were copy-pasted or this could be equated to electronic signatures as Ms. Rayleigh tried to make it appear. And therefore, after the expert reports were submitted, the only submission to the Honorable Court from our side was a skeleton argument where we have clearly stated that this is the correct position under the UAE law, which we are all bound when we are looking into examining a document under the UAE law. Whether I plead it or not, we are all bound by that law in determining the fate of that document, Your Lordship.
Wait a moment, please. What is the position in DIFC about pleading and proving foreign law? There are some questions.
Off the top of my head, my lord, it's same as English law. So DIFC law is the starting point unless it's proved otherwise.
And does foreign law have to be proved as a question of fact, or is it assumed that the parties just treat it as something to argue about?
I would have to check that, my lord. I don't know whether it would also be we don't accept the defendant's position that's been advanced that you can raise any point of law on the eve of trial. For example, one of the grounds is a substantive time bar defense. which would obviously have to be pleaded. That's ground 10.
Okay.
Just taking the example we were looking at, which is
10.
ground.
Hang on. Yes, I'm not sure I read that in detail. Yep.
Maybe just using the example we were using, which is ground 5, the validity of electronic signatures.
Yeah.
In the brief time we have had, I understand the position under the 2006 law. Under Article 18 sets out potential circumstances when it might be reasonable to rely upon an electronic signature. And those, if I just read a few of those grounds out, the grounds are the nature of the underlying transaction, which was intended to be supported by the electronic signature, the value or importance of the transaction, whether the reliant party in respect to the electronic signature has taken appropriate steps to determine the reliability of the electronic signature, whether the reliant party took reasonable steps to verify the electronic signature, whether the reliant party in respect to the electronic signature knew or ought to have known the electronic signature had been compromised or revoked, any agreement or course of dealings between the originator and the relying party, and any other relevant factors. So if we take this one example alone, the law itself brings in a whole host of potential factual issues that would arise if one were to rely upon it. So it's simply not the case that we can deal with this now. And it's clearly the case that this should have all been pleaded.
If I may.
Wait a second.
Yes, sir.
Yes, Mr. Shaheen, you wanted to say something.
Regarding the pleading, regarding the signature, it was definitely pleaded in clear, unambiguous language that Dr. Shetty is denying all those signatures, and he did not rule out the possibility somebody from the borrower's office could have done the forgery, could have tampered the documents. So pleading was definitely there regarding the fact the signatures are denied. Then comes the expert report, which identified that this could have been electronically copy-pasted, in a way trying to equate it to an electronic signature. So when we have to check the validity of the electronic signature, it is imperative that we go back to the UAE law, the relevant law, which governs the guarantees, to check how a signature can be accepted as electronic signature. That's what we have done in this case, Your Lordship.
I think if you look at the rule, court practice, do you have a copy there?
Yes, Your Lordship.
And you look at Rule 29.131. As I understand, I think there's another passage somewhere else, but I can't find it. But there is basically anyone seeking to raise a point of non-DIFC law must give the other party notice of his intention, if you look at 29.133 and so on.
29.33.
29.133, 134, 135.
if there are to be witness statements, this is 29,134.
Yeah.
He must give notice if there are to be witness statements not later than the latest date for serving them, or otherwise not less than 21 days before the hearing.
Yes.
Is that the one, Your Lordship?
No, the previous one, 29,133.
He must give any other party notice of his intention
To rely on non-DIFC law.
Non-DIFC law means any law other than DIFC law or any other law enforced in the DIFC. The law of here, it's an admitted fact, Your Lordship. It's the UAE law which governs. So that I don't have to give notice because admitted fact need not be proven. Everyone accepts that it is UAE law.
Mr. Shaheen, you argue that you don't need to plead law. You don't need to plead detailed law, but you've got to give a notice of the line of argument you are likely to be running, and there's no hint of that in this case. So
Your Lordship,
my ruling at the moment would be to exclude those arguments.
Your Lordship, may I make a submission here? The
Yes.
question of fact is which law applies to this case?
Yes.
And the clear answer is it is UAE law, which is
Yes.
admitted by all parties. No need to plead or prove that because admitted fact need not be proved. Once UAE law is applied, all those questions of law are automatically attracted. And the question of electronic signature came for consideration for the first time when the expert submitted the report. Copy pasted to electronic means.
Mr. Shaheen, it's not only electronic signatures, there's many other points of, for example, the uncertain amount, and which is ground, can't remember which ground it is, but your argument that as to the validity of the guarantee when the amount is uncertain, for example.
Yes, Your Lordship. Your Lordship's judgment is there, already there. A guarantee which is not certain about the amount is not valid, cannot be enforced.
Mr. Shaheen, I'm not asking you to argue the point. I know that I understand the point, but you've given no notice of this. And we may disagree, but I'm the judge here. And as far as I'm concerned, your pleadings are meant to give notice of the line of defense you're taking.
I may explain it
Sorry?
In one more way, I may explain it, Your Lordship. Initially, when the case came up, it was all about total denial about the signature or knowledge about these facility agreements or the personal guarantees.
Yeah.
That was the primary point. And Dr. Shetty reserved his position, even in his witness statement and the statement of depending on the expert's reports, he may amend the pleading, he may amend his position according to that. So initially, going into details was not the position, Your Lordship. It was a total denial. I don't know what is this facility. I don't know what is this personal guarantee you're talking about. Afterwards.
Mr. Shaheen, I understand that. But it's very, very common to plead two defenses. One, I don't know what you're talking about. These are not my signatures. But two, even if they are my signatures, you're not liable because A, B, C, D, E. And you didn't do that.
I agree with Your Lordship because the defense is always allowed to take even inconsistent alternate pleas is the accepted position.
Yeah.
But just by not doing that and keeping it for a later stage, I should not lose a legal protection, Your Lordship.
Well,
that's too much of a punishment for that.
I agree. It's a very serious punishment to lose the chance of arguing those points. But the solution may be to apply late to amend, to take the points, and we can deal with it on that basis.
Yes, Your Lordship, I can do that, Your Lordship.
Then we'd have to consider delay, costs, and all that.
Yes, Your Lordship.
Right.
Because it's so important for me to have all those questions of law to be decided by the Honorable Court.
Mr. Lakin, I'm sympathetic to your argument. I'm not making any ruling at the moment. To your point that there has been no notice at all of about 5 or 6 different lines of UAE law. And whatever Mr. Shaheen says, I take the view that there ought to be in the pleadings some joinder of issue on those points, even in the most skeleton form, so the parties know what case they're meeting, and it may give rise, one doesn't know, to additional factual disputes that we until we go into the points, we don't know whether it does or not. But one is on the subject of electronic signatures and the circumstances in which they can be used. There may be others. On the other hand, this is a large claim, and the defendant shouldn't be shut out through the failure to take pleading points. And even if the point arises on the first day of the trial, the court has to do justice between the parties. Now, one solution would be Mr. Shaheen has indicated he'd like to amend if necessary. He doesn't want to, but he would like to, if that's the only way he will be able to address these points. That seems to me would involve a process both of simplified pleading, but also you would need time to deal with these points by consulting UAE lawyers or however you would wish to deal with it. That can't be done by Thursday when we're finishing this trial. It can only be done with an adjournment. I haven't heard Mr. Shaheen on this, but my inclination would be, if there was an adjournment, it would have to be at the expense of the defendant. What do you say? Sorry, if I can just add one point. It needn't be an adjournment of everything. We've got fact witnesses here, and they could be accommodated. We might or might not want to deal with the experts because it may be that if one's a journey on the legal points, then it gives the experts more time to give a coherent answer to each other. But that can be a separate point. So what is your position in regard to that?
My lord, from the claimant's position, that would be entirely unacceptable. It would involve significant cost. Mr. Shetty won't pay those costs. It will put the hearing off, I would say, at least another 6 months. It's entirely unacceptable.
Why couldn't it be fitted in within a month?
Presumably, we'll have to take UAE law advice. We will have to look into the factual. As I say, these all appear to us, from the little time we've had, mixed questions of law and fact. And it's simply, we will have to repeat the disclosure exercise again. We will have to repeat the witness evidence phase again.
Hang on, why?
It seems entirely disproportionate and incredibly unfair on the
one point at a time. Why would you have to repeat the witness evidence?
I mean, as I said, I'm working a bit at a disadvantage here, but just on the electronic signatures point, there was a wide array of factual areas where the reliance upon an electronic signature would be reasonable. We would want to address that in witness evidence, and we would also want witness evidence from Mr. Shetty on it. We would also want disclosure on those points. We would likely have to adduce additional documents from our side, and we would be seeking disclosure from Mr. Shetty of documents from his side. I mean, they wouldn't be forthcoming because he's disclosed nothing in these proceedings, but we would want disclosure on those points. Again, the experts may need to, I don't know, but the experts may need to look at things again, afresh in light of these 5 additional points that have been raised. There'd have to be evidence in terms of where the administration was at. It would involve a wholesale moving of the case for another year. It would be entirely unacceptable, unfair to my client. Costs cannot remedy this because Mr. Shetty will not pay those costs. He's not paid the $100 million. He owes the bank. He's not going to pay the cost order that you would make, however large and on whatever basis it was ordered. It is not, but choosing between shutting out these arguments that were made on Thursday, which should have been pleaded, should have at least been flagged a month ago. Take Mr. Shaheen's point about the electronic signatures. The experts found there were electronic signatures 3 months ago in their first round of reports. It would be entirely disproportionate and unfair on the claimant in these proceedings for us to have to put off the case by a significant amount of time and incur exceedingly high costs. The costs to date are about $400,000. The area of factual inquiry that these 5 new grounds require would require even probably the same all over again, if not more, because they raise additional areas of factual inquiry, in addition to expert areas of UAE law that we would have to adduce evidence on. It simply is not the fair decision.
It hasn't been a decision yet.
It would be the unfair decision if it were decided to permit Mr. Shaheen to make these arguments. I fully appreciate the court's job is to do justice between the parties, but justice in these circumstances clearly weighs in favor of shutting these arguments out. The pleadings are there for a reason. The procedure is there for a reason. And simply to chuck it all out because Mr. Shaheen's come up with a few points on Thursday it is completely unjust.
Well, there's two points one might make in response to that. First, if you are going to deal with the points raised by the UAE law issues, if you're going to investigate the factual material relating to that, then that would have been the case if the points had been raised, say, 2 or 3 months ago by an amendment process. So that's not a consequence of the lateness. It's the need to investigate is not a consequence of lateness. The delay would be a consequence of lateness. But secondly, your other point that Mr. Shaheen, that the defendant would not pay the costs of the adjournment, and that can be built into a court order. That, for example, I'm not making an order in this term, but it could be that the case is adjourned until a certain date, provided that by a certain date, the defendant puts up security for the costs in a certain form, costs of the adjournment in a certain amount in a certain form, and failing that, judgment is entered against him. That would seem to. I agree there's an element of delay involved, a large element of delay, but I'm not sure myself that it necessarily means you'd have to go do the full disclosure of documents exercise again, nor do I think it impossible that the matter could be fixed for the late November, if we go ahead with the evidence at the moment, for 2 days in late November.
I'm instructed to raise one further point. In late October, I think, I don't have the exact date, that there is the hearing of the freezing order that the Indian courts have granted in support of these proceedings. The final hearing of that matter.
Sorry, what date is that?
That has been. I don't think it's in the bundles at all. It may well be somewhere.
No, tell me
it's not an issue not a particular issue it hadn't been a particular issue for this hearing. So a freezing order has been granted by the.
Am I hearing sorry, am I hearing this? Is this a case before me?
No. The freezing order has been issued by the Indian courts in support of these proceedings against Mr. Shetty's assets in India. The final trial of that hearing has been structured so that this hearing will have taken place first, and then there'll be the hearing of the freezing order. Now, obviously, it might be the case that judgment hasn't been issued here, but we are in a very difficult position.
What do you say there to the 2 points I made?
In terms of costs, yes, that could well be remedied by an order that requires significant security for costs to be posted by Mr. Shetty, failing which judgment will be entered against him. My Lord, apology, your first point was?
Simply to say that I wonder whether, in fact, looking at the various UAE law points, it would be necessary to have a full rehash of all the factual evidence. I suspect, although there's something about the electronic signatures, I suspect the rest of them are probably legal points.
I think on the first sorry, going reverse on the ground 10, which is a time bar claim, my lord, you'll be familiar that those tend to be very fact sensitive in terms of examining what was done facing modular in the 6 months that followed, the various defaults. In terms of whether or not at ground 8, the liability and debt owed by NMC and modular, that requires significant evidence in terms of where we're at in the administration proceedings, which has not been an issue between the parties to date. So we do say there are, and as I say, the electronic signatures, one is an example of mixed issues of law and fact. The others may well be such issues. I mean, I haven't had time to take proper advice on all of this.
No.
At one point, I would say to your point that some of this could have been done by way of an amendment application 2 or 3 months ago, which is the point I raised in terms of the experts having identified it. I mean, that application would have been hotly contested at the time if it had been made by the claimant, but it wasn't made. There were no application to amend was made 3 months ago. We're in a very unsatisfactory position. It may be with safeguards built in, the trial could have been preserved if an application had been made 3 months ago to raise these points, and we'd had some expedited additional witness evidence and expedited expert evidence. But none of that was done. So I struggle to see how the claimant should suffer for that.
Yes. Mr. Shaheen, anything you want to say? Anything new?
There was a reference made to 1092 UAE law, civil transaction law, regarding limitation period. That article is there in the guarantee itself. The 3 of the 4 guarantees produced, that article is already there. In one guarantee, that article is not there. So that's what we pointed out. Why modular alone we are pleading the limitation period? Why we are not pleading limitation period in NMC? Because all the NMC guarantees produced, whatever be the legal validity of it, it contains a reference to Article 1092. Like this, I can explain, Your Lordship, but the fact of the matter is that after the expert report, the only submission made from the defendant side was the skeleton arguments, in that we have mentioned it also before the trial started, although it was very close to the trial. I agree on that point. It was not just Thursday, few days back we have submitted, and then we had to cut down the number of pages. So that is why he's probably saying Thursday. And after that also, Your Lordship, even now, there's nothing new. We would expect a governing law is UAE law. So it need not even be treated as a foreign law. So governing law is UAE law, and the counsels appearing for a case where the governing law is UAE law is expected to know UAE law. It's as simple as that, Your Lordship. It's not something that we are importing a law from a different country altogether. It is the claimant's document, which is disputed by the defendant, which says UAE law, and it's an admitted fact, Your Lordship. So the question of pleading, we did not go so harsh on it about the pleading each and every article of UAE law I need to plead. It's not necessary, Your Lordship. Electronic signatures, as Your Lordship rightly understood, it came up in the expert report. The first submission from the defendant after that was the skeleton arguments. We have mentioned it there. 1092 limitation period, it is there in the guarantees produced, the personal guarantee forms produced by the claimant himself. So there's nothing new. It's not that we have imported a law from a different country, which is no way anybody could have contemplated while arguing this case or representing a party in this case. It's all known facts, supposed to be known laws also. So even the cost is exorbitant, my learned friend is saying. What is the claim amount? Is it not exorbitant? $130 million on a party who says, I'm not aware of this facility, I have not signed any of these personal guarantees, and compelling evidence from experts have come. 3 out of 4 personal guarantees doesn't contain a signature other than a copy paste. Only one, and that is also, I'm not going into the merits, but I'm expressing the concerns of the defendant. When it's compared to $130 million, these costs are not so exorbitant. And the costs are to be borne by the party who loses the case. That's the position, Your Lordship.
The costs of an adjournment would normally be costs payable by the party causing the adjournment.
But I'm still worried, Your Lordship. Am I the party? Did I plead something new? Did I say something new? If the other counsel is ignorant of UAE laws, it's not my problem, Your Lordship.
Mr. Shaheen, let's be realistic. You've put in grounds 5 to 10, which raise points for the first time of UAE law.
UAE law has already been there, Your Lordship. I only explained that. That's all.
Mr. Shaheen, you're being deliberately obtuse, I think. It may be accepted that UAE law applies, but we are in a DIFC court, and the question is whether you should give notice of the points of law. My ruling is yes, you should give notice. You should have given notice. If you want to amend, we can consider that in a moment. But at the moment, as I see it, you cannot run points 5 to 10, grounds 5 to 10, because they involve points that have not been, of which no notice has been given, and which would cause prejudice if the defendant had to go straight on with them. So I would not allow that. The question then would be, do you want to apply to amend? If you do, if you do, then we can consider the terms. The starting point would be that it's your application because you're in default.
I respect Your Lordship's decision, though I have a different view. I respect Your Lordship's decision on this.
So the question would be, what application are you making? And I haven't decided you should have an adjournment, but this is the structure, it seems to me, that if I rule against you on the admissibility of these grounds 5 to 10, as at present, you might want to make an application to amend. And if you make an application to amend, that would be resisted, and we'd have to consider adjournment, which would be your application for an adjournment.
Yes, Your Lordship, I can do that.
Now, do you want to argue that now, or do you want me to give you 5 or 10 minutes and I'll rise for a few minutes?
Yes, Your Lordship, that will be preferred.
Because we're talking, as I think I mentioned, that if you do go into the question of adjournment, I know it would be opposed, but the question would be what security your client could give for paying the cost of the adjournment and so on. But we can discuss that in a moment. Shall I give you 10 minutes?
Yes, Your Lordship.
Or 15 minutes, would that be more sensible?
Yes, Your Lordship.
Okay, Mr. Lakin, I'm going to do it in that way. And I know we've run out, we're way off the timetable, but we'll deal with that somehow. But we'll allow 15 minutes at the moment, and I'll come back at 9:34, 10 to 10 UK time, which is 10 to 3 UAE time.
10 to 1?
10 to 1, sorry. I was thinking of 13. 10 to 1 UAE time. Okay,
yes.
Thank you.
Thank you.
Yes, I'm sorry to have kept you waiting longer than planned.
No problem. Should I start, Your Lordship?
If you wait 1 second, Ali, are you there?
Yes, Your Honor.
Is Haley around?
Yes, I've just asked her to contact you.
Yeah, Mr. Shaheen, if you can just give me a moment longer, I want to talk to the court staff. Thank you. Yes, I'm sorry, Mr. Shaheen. I wanted to talk to the court staff. Thank you. Right, Mr. Shaheen, what do you want to do? Not what you want to do. What are you going to do?
I will submit an application, Your Lordship, to amend the pleadings.
Right.
As directed by Your Lordship.
Right, and how long do you want for that?
I leave it to the Honorable Court to decide.
In 3 days, 5 days?
Yes, it's fine. 5 days will be more than enough.
And that would carry with it the right of the other side to respond to that.
I
Okay.
hope my learned friend will answer.
But I'm dealing with you at the moment, Mr. Shaheen.
Yes,
So,
sir.
but does that carry with it an implication that you are planning also to adjourn?
Yes, we'll have to do that, Your Lordship. We'll submit an application to adjourn the hearing and also to amend the pleadings to include the questions of law raised in the skeleton.
Right. And what do you say about the costs of adjourning,
We'll give an undertaking, Your Lordship.
which will be fortified by a deposit in court?
May not be possible, Your Lordship, because the defendant is facing a lot of restrictive orders. He cannot do that.
Or why should I make an order for adjournment if you can't pay the cost of it?
We will not be able to pay it immediately, Your Lordship. It can be adjusted at the final cost, but we'll give an undertaking to bear the cost. This is what I discussed.
But Mr. Shaheen, we're in the real world. An undertaking to pay the cost accounts for nothing unless it's fortified by a deposit in court or something of that sort.
Because the situation of the defendant is very peculiar, Your Lordship, in this case. He has got freezing orders, he has got various restrictive orders against him. So he's not able to raise a bank guarantee or approach a bank to raise the money. That's a real life difficulty I'm submitting, Your Lordship.
Right. Well, if you can't raise security for payment of costs, why should I allow an adjournment which will cost the other side a lot of money?
It's the amount involved is $130 million, Your Lordship.
I'm sorry, I have to stop you for the moment. There is some background noise, movement and static, and I can't hear what you're saying.
Me?
Yes, it's, I think, have you put a microphone maybe? Did you put one on your tie? Oh, is it the paper on top of the microphone?
Okay, I removed the paper from there.
Thank you very much.
What was the question, Your Lordship?
The question was why should why should the other side have to suffer financially because of your failure to plead the points you want to raise?
It was all, I don't want to keep justifying it again and again, Your Lordship, but...
Okay. Because you think you don't have to plead. Right. Let me hear what Mr. Lakin says. Sorry,
my lord,
just before I go to Mr. Lakin, how long would you need an adjournment for? Mr. Shavin, how long would you need an adjournment for?
Me, Your Lordship, we agreed 5 days.
No. How long would you need when could we refix the hearing?
At the court's convenience, Your Lordship, we will look at the dates.
You could make the week of the 11th November, for example.
11th November, I'll just... Anything?
Or the 18th.
11th November, no issue, Your Lordship. 18th also, we are fine.
Right. Right, Mr. Lakin. I know this is not where you want to be, but let's hear what submissions you have to make about this.
Yes, my lord, thank you. During the break, you passed a judgment that I wish to hand up on this point. It's one by Mrs. Justice Carr, Qui Su Ling versus Goldman Sachs.
Where do I find it?
It's a fresh judgment we sent during the break. I don't know if the registry has been able to send it over to you.
I'll see.
Your Honor, yes, I have sent it to you via email.
Right, give me a moment then, please.
Mr. Lakin, could I please remind you to face your direct your voice towards your microphone?
Yes, of course.
Thank you.
Right, I have the judgment here.
My lord, if I could ask that you turn to paragraph 38, I think of page 9. It's Mrs. Justice Carr, as she then was. Here she considers the principles to be applied for late amendments.
Yeah.
Paragraph 37, she cites the authorities that she's considered.
Yeah.
And if I could invite the court to read all of paragraph 38.
Yeah, give me a second. Was this, just before I read this, was this an application to amend on the facts, or was it a legal point?
This was certain facts, I believe,
Yeah.
a slightly alternative case.
39. No, correct.
Okay, let me just read it then. Yeah.
And if it helps, my lord, if you go back up to paragraph 35, there's quite a helpful summary of the proposed amendments in that case. You'll see they're a mixture of further pleas as to the terms of the contract, statutory duties that it's pleaded exist and have been breached, certain new facts, and allegations of breach of contract. So a mixture of factual and legal points.
Okay, give me one second. Yeah.
And then just one more part of the judgment, I draw your attention to, that's paragraph 96.
96.
Which is at the end of the judgment, where
Yeah, let me read it.
Carr summarizes the position that very late applications for permission to amend in circumstances where there is no good reason for the delay, and B, the amendment would result in real disruption or prejudice to the parties and or the court, are unlikely to be allowed, irrespective of the merits of the proposed amendment. And that's what she held in that particular case. I would say that this current case falls within that. No good reason has been given for the delay. We haven't even delved into the merits, but no matter how strong they are, we said they're not, but no matter how strong they are, we're in that category. If we go back to some of the factors at paragraph 38, Mrs. Justice Carr says a heavy burden lies on a party seeking a very late amendment to show the strength of the new case and why justice to him, his opponent, and other court users requires him to be able to pursue it. Mr. Shaheen hasn't even started to do that in his application. He's not mentioned it at all. As Mrs. Justice Carr says at 38B of her judgment, the risk to a trial date may mean that the lateness of the application to amend will of itself cause the balance to be loaded heavily against the grant of permission. And I think it's also important to flag 38E. Gone are the days when it was sufficient that the amending party to argue that no prejudice had been suffered save as to costs. In the modern era, it is more readily recognised that the payment of costs may not be adequate compensation. On that point, I would specifically go back to what Mr. Shaheen has confirmed, that Mr. Shetty will not provide security for the amendment. And in the claimant's submission, that should be fatal to the application. It should be a prerequisite. If we do get there, we were going to ask that payment of the costs of the adjournment be provisionally assessed and payment be made in short order with a significant payment of security for costs into court thereafter. But given Mr. Shaheen,
what sort of figure would we be talking about?
Well, our costs incurred to date are around the $500,000 mark. If one were to, it's hard at the back of a napkin to figure out what the costs thrown away from today would be, but we would say they would be between $50,000 and $100,000 at the minimum. So we would have envisaged a payment of around $100,000 to the claimant's lawyers in short order, a significant payment of security for costs that would be made shortly thereafter. However, I don't think we should go there because, as Mr. Shaheen has said, that will not be done. So there's no point in making orders that Mr. Shetty says he will not comply with. And it can't be the case that a simple undertaking to pay the costs arising from the adjournment is going to be sufficient in these circumstances. So for those reasons, and in light of the very clear guidance given by Mrs. Justice Carr and how these types of applications should be approached, the claimant's position is that the application to amend and adjourn should be rejected.
Yes, what date was that? 2015. Has that case been followed regularly?
So you appreciate, my lord, this is the best we've been able to come up with in 10 minutes during the break. But it certainly hasn't been overturned by the Court of Appeal or subject to any, as far as we can tell, any significant negative treatment. The principles she sets out seem fairly sound and in line with the general approach of the commercial court.
Yeah. Mr. Shaheen, do you want to respond to that?
Your Lordship, we have just received the judgment and we have time to review all of that. I have read what my learned friend has said before, Your Honor, and I agree whatever is stated is there in the judgment. So I leave it to the Honorable Court to decide. But one thing is very sure, Your Lordship, not able to make a payment, not able to give a bank guarantee also. It's only a letter of undertaking that is possible. If that is not acceptable anyway, Your Lordship may take appropriate decision whether those pleadings, which I believe are questions of law, should be allowed or not. And I'm ready to continue with the trial.
Well, having regard to the authority I've been shown, which is...
Sorry, my lord, my apologies for interrupting. There was one other point I was going to point you to, which I missed in my submissions. That's part, just so you have the statutory the RDC basis for dealing with this application. That's at 18.15 of the rules of the DIC courts, and that states late amendments should be
I'm so
avoided.
sorry, sir. I
and
need you to face the
Oh,
laptop because I lose your
apologies.
voice when you're moving away. Could you move your document screen in a different direction potentially?
I will. Late amendments should be avoided and may be disallowed.
1815.
1815.
I notice in the notes to 17.4 in the DIFC courts practice, an example where pleading was required of some statutory provision being relied on. If it wasn't pleaded, the court wouldn't allow the argument to be advanced. Yeah. Okay. Thank you. Is there anything else you want to add before I turn finally to Mr. Shaheen again?
Nothing further from the claimant.
Mr. Shaheen, you've read the judgment or bits of the judgment of Mrs. Justice Carr as she was. As I see it at the moment, you are unable to make any offer that is satisfactory in terms of the legal expenses thrown away by an adjournment. It's not your fault personally, but and it may or may not be your client's fault, I don't know. But the fact is he can't put any security up for the costs of the adjournment, and it's not for me to inquire as to the reasons for that. I know that orders have been made against him, and whether they are justified or not will appear in due course. But it seems to me that on that basis, the prejudice to the claimant of allowing these points to be raised at this late stage or to adjourn to deal with them is such that taking all those factors into account that listed by Mrs. Justice Carr, I should refuse the application to amend and should proceed. Now, I'm saying that as my provisional view, but if you want to add anything to your argument, now is the time, or I'll make an order.
Understood, Your Lordship. Only thing is, when I read the judgment quickly here and there, what I read is that if you are putting any additional claim by amendment of the pleading, this is not an additional claim that we are putting. This is just the questions of law. Again, I may be repeating the same thing what I initially stated, but that's the only distinction I could make between this judgment and why we are amending the plain. And it was, to my surprise, maybe my understanding was that, or a difference of understanding, that it was not necessary to be pleaded. So only today I'm given the opportunity. I requested Your Lordship, I contacted the client also, but paying the money or creating a bank guarantee or deposit for that purpose is impossible, is what I'm told, Your Lordship. So Your Lordship may pass appropriate orders.
No, that's very, very fair of you. I'm going to refuse the application to amend, largely for the grounds identified by Mrs. Justice Carr. It seems to me that the matters of Dubai onshore law should have been pleaded. They should have been notice should have been given of a case to be advanced on those lines to allow a proper investigation, both of the law and any facts relevant to that. It seems to me that to grant an adjournment to run those points, to allow an amendment so as to be able to run those points, it is inherently unfair if there's no satisfactory basis for believing that the costs of the adjournment, the wasted costs of the adjournment, will be met in due course by the defaulting party, in this case the defendant. So for those reasons in brief, and I'll give more reasons later if I'm requested to, I will refuse the adjournment and the application to, I refuse the application to amend, and would then proceed with the trial. Thank you. Yes, Mr. Levine. Lakin.
Thank you, my lord. It's 1:30 here in Dubai now. Would you prefer we break for lunch before I open the case, or would you like me to at least make a start and then? I appreciate we've just had a relatively recently had a 10-15 minute break, so hopefully, Madam Transcriber is okay.
If the transcriber is okay, I think we ought to do our best to catch up and maybe reduce the break in the middle of the day to 3/4 of an hour rather than an hour, unless that is difficult for the transcriber, because I'm conscious it's a big effort to keep up with a whole day's worth of proceedings. Madam Transcriber, are you happy with that approach?
Excuse me, I think my microphone muted because I was unsure as to how we were going ahead. I can hear Mr. Lakin okay, unless he turns his head towards the other screen he's looking at. But in the break, I really would request that Mr. Shaheen tries to use his laptop microphone because it's very challenging to hear him. Yeah, thank you.
But in terms of, Madam Transcriber, in terms of timing, are you content to go on a little bit past the original scheduled time and maybe reduce the lunch break or the midday break to 3/4 of an hour rather than an hour?
I would request an hour if possible. I can sit later than the original time.
We'll keep to an hour, but if we can maybe, what time is it now? We're due to break at 11 o'clock. If we go until 11:15, would that be all right?
Yes, that's fine. Yes.
Shall we do that then, Mr. Lakin, and see whether you can complete your opening in that time?
Yes, my lord. I'm afraid I may take slightly longer than that, but I will try my best to get through it as quickly as possible. So, my lord, in opening, I intend to give a very brief introduction to the case, much of it which you will have picked up from the skeleton argument, so I won't spend a huge amount of time on that. I'll then briefly consider the law and then move on to the evidence. I will spend most of my time in opening looking at some of the main documents and where we're at in terms of the expert evidence, because I think that would be the most productive use of that time. So we're all familiar with those documents at the beginning of the case and where we are, the expert evidence. This is the trial of ICICI Bank's claims against Dr. Shetty. The total around $130 million, the principal and interest that is accrued under those facilities. These sums were owed by NMC Healthcare LLC and Modular Concepts LLC under 4 separate facility agreements granted by the claimant. Dr. Shetty is
very sorry to
liable
keep interrupting. I'm so sorry. You are cutting in and out. The audio isn't very clear. I don't know if there's anything you can do to improve it. And I will have to request to slow down because the audio is unclear and I need to get a transcript.
Apologies.
If the audio is clearer, I can cope with the speed. That's not the problem. You're cutting in and out and it's just not perfect.
Is that any better?
It's hard to tell when you just say a few words. I think as you're moving, it seems to cut in and out a bit. So if I could just request you, I'm really sorry. If I can just request you to try to stay still but slow down a little bit, please, so that I can get the transcript. Thank you very much.
Mr. Lakin, are you reading from a screen which is separate from your microphone?
I have one screen with the hearing bundle. and I have one screen with the screen with all of us on it. I've moved my microphone, so hopefully that's remedied the problem with that.
Okay, but let's see how we go. Thank you.
Yes, thank you. The audio is a bit clearer now. Thank you.
The claimant's case is Dr. Shetty is personally liable for those sums because he signed 4 personal guarantees in respect of each of those facility agreements. The claimant is the second largest bank in India. It was formed in 1955 and it established its ICICI branch office in 2005. The defendant is Dr. Shetty. He is an Indian national and was the founder of NMC Healthcare. Dr. Shetty established NMC in Abu Dhabi in the 1970s as a provider of independent healthcare services. He grew that business significantly throughout the 1970s and 80s, and it culminated in the successful IPO of the business on the London Stock Exchange in 2012.
I'm so sorry.
ICICI.
It's cutting. You're cutting in and out again. I'm not sure why. I'm losing words. I think if you were able to slow down, I can still try to get everything you're saying, but with the speed and the cutting in and out, it's not possible. So I have to request you to slow down so that then I can probably manage.
Mr. Shaheen,
very clearly. That's what I'm surprised.
you can hear clearly, so can I. But the important person is the transcriber there.
Yes, that's what I mean to say.
Yeah.
And I can understand my learned friend's position when he's cut in the between, when he's presenting a case. It could be he will lose the flow. It will be very disturbing also. With all due respect to Madam, I'm not blaming her, but
Well, I think
I'll endeavour to go
the best we can. Yeah, thank you.
Well, it's certainly the claimant's case that ICICI and NMC have had a long relationship. That started in 2011, and during that period, hundreds of millions of dollars were lent and repaid by the claimant and were repaid by NMC. There are three facilities that are in question, and there were an additional number of term loans, 4 term loans that were given from time to time and were repaid. The first facility in question that we will be considering today is a working capital facility that was entered into in 2011 and was subsequently amended and restated in 2012. That is when the claimant says the first personal guarantee was given by Dr. Shetty, which is also dated in 2012. The second facility was entered into in 2013, and a third facility, which is a term loan facility, was entered into 2019. The claimant in this case is Dr. Shetty provided personal guarantees in respect of all of these facilities. ICICI also made a further loan to a company called Modular Concepts LLC. The claimant's understanding is that Modular was a company that was owned and promoted by a Mr. Kukinder Pradeep Kumar, who is understood to be a relative of Dr. Shetty. It's the claimant's case that Dr. Shetty also personally guaranteed that facility agreement. In December 2019, the short seller Muddy Waters published a report that questioned NMC's accounts, which were obviously publicly available, being a listed UK company. They had concerns that NMC had manipulated its balance sheet in order to understate its debt. On the 8th of April 2020, the UK listed parent company went into administration, and following that, the UAE subsidiaries were subject to a range of legal proceedings that culminated in a long-running administration proceedings that are being held before the ADGM courts. Dr. Shetty now denies that he signed the 4 personal guarantees in question. Indeed, it is now clear that Dr. Shetty says that he did not sign a single one of the facility documents, the related documents to the facilities, and the personal guarantees. That is hundreds of documents that bear Dr. Shetty's signature. It is the claimant's case that this is patently false. It is fanciful to suggest that Dr. Shetty, who as we will see was heavily involved in the management of NMC throughout this period, was not aware of the agreements with ICICI, and he did in fact sign all of the personal guarantees, whether in pen or by way of an electronic signature. The expert evidence is strongly supportive of this case and will be an important evidence as this hearing progresses. On the law, the claimant's position is, as we've briefly canvassed already, whether or not the personal guarantees are valid is a question of UAE law. The guarantees themselves contain UAE law governing clauses. The reference for the 3 NMC guarantees in question at page 458 of the bundle, main electronic bundle, page 481, and page 523. I don't think there's any need for us to turn those up, but they're the governing law clauses. For the modular guarantee, that's page 435 of the bundle. However, when considering whether or not Dr. Shetty's signature on the personal guarantees and any other documents have been forged, the DIFC court should approach this question as a matter of DIFC law, being the law of the forum. This also appears to be common ground between us and the defendant has relied heavily on the St. Petersburg case, which I'm sure we will turn to when looking at where the balance of probabilities lie when considering allegations of fraud and dishonesty. The claimant's position is that it is Dr. Shetty who must prove that he has been subject to a significant fraud by others within NMC who have forged his signature on a wide array of documents and have kept him in the dark about the ICICI facilities and his liabilities that he's been signed up to under the personal guarantees for well over 10 years. It's well established when alleging fraud or other discreditable conduct that cogent evidence is required. We would point the court to the paragraph 1438 of the Fiona Trust case. Again, I don't think there's any need for us to turn that up, but that is at page 470 of the claimant's supplemental authorities bundle. The claimant does not say that there is a special burden of proof where fraud or discreditable. Yes, my lord.
What paragraph was it? And what case was it?
That was the Fiona Trust versus Privalov case. And it's the relevant paragraph which considers allegations of fraud or discreditable conduct is at paragraph 1438, which is at page 470 of the claimant's supplemental authorities bundle.
Yeah, thank you.
Contrary to what the defendant has alleged in, which Mr. Shaheen's alleged in his skeleton, there is no special burden of proof. We're not alleging that there's some sort of special burden of proof where fraud or discreditable conduct is alleged. It's common ground that the standard to be applied by the DIFC court is the balance of probabilities. But if I could ask you to turn to page 550 of the claimant's authorities bundle.
The new one.
This is the new authorities bundle, yeah.
Right, let me find it again. Yeah. Page 550.
550. This is the St. Petersburg case that the defendant relies upon.
Yeah. Yeah.
And if I could ask that you read paragraph 44, I think Lady Justice Hale's judgment there summarizes the position nicely. It's not that there's a different balance of probabilities for these allegations. It just it is that the allegations, depending on the particular allegations themselves, it goes to the inherent likelihood whether or not it's happened or not. So maybe if I just let you read paragraph 44, quoting the judgment of Lady Justice Hale in Re B.
Yeah.
As we said, it's Dr. Shetty who has to prove on the balance of probabilities that he was subject to a long-running fraud at NMC, where individuals were utilizing his signature to sign off on very significant lending from ICICI to NMC that he was entirely unaware of. The claimant's position is that the inherent probabilities of him having not done so, to have remained unaware as he claims, and to have not signed these documents is inherently implausible. Given that he was heavily involved in the running, as we will see during the course of this trial, he was heavily involved in the running and operation of NMC at least until 2017, when he remained until that point the CEO. And as will be explored in the evidence following 2017, after he stood down as the CEO, the claimant's case is that he was still heavily involved in the running of the business. Turning to the evidence that is before the court, see Dr. Shetty's evidence and the claimant's witnesses will be tested in cross-examination. There are a few initial points that we would flag to the court at this stage to be borne in mind whilst the cross-examination is taking place. If I could ask that you turn to page 906 of the main bundle. This is Dr. Shetty's witness statement.
Yeah.
And if I could ask,
Is it his first
that
witness
you
or second? His first or second?
This is his first statement. If I could ask that you read paragraph 11.
Yeah.
And this is all we have from Dr. Shetty on the key question in this case, whether or not he signed the personal guarantees, the extent to which he was aware of the lending that ICICI had made to NMC and Modular. And we would say that this amounts simply to a bare denial. It will make cross-examining him very difficult. There is no proper factual evidence given by Dr. Shetty as to his involvement in the business, what was happening around the relevant times that the personal guarantees and relevant facility agreements were entered into. It is incredibly suboptimal. What little is said at paragraph 11 is notable, though. First, Dr. Shetty does not Dr. Shetty says that he does not know who has committed this vast fraud against him. He says it could have been people at NMC. Those people are not named or identified and never have been in this case. That in of itself is bizarre, but we are now 4 years on from when NMC collapsed and went into administration. If what Dr. Shetty was saying is true, within that 4-year period, one would have imagined he could have, to some extent, discovered what he says happened and how this has happened to him. No attempt to do so in his witness evidence has been made. There's also another notable part in this paragraph of his statement. In the middle of his statement, he says, I have not been part of the day-to-day management and was never, apologies a bit further, since at least 2017, when I stepped down from the position of Chief Executive Officer of the NMC Group. I have not been part of the day-to-day management and was never made aware of any of the arrangements that gave rise to the facilities or the personal guarantee and any other documents upon which the claimant relies. This is a complete non sequitur. It makes no sense. The two of the facility agreements that debts are owed under and which this claim relates to were entered into in 2011 and 2013. So even if there was any merit in what Dr. Shetty says, which we will explore, there is not. This defense simply does not make sense. We'd add that the 2011 and 2013 facilities have been amended and restated a number of times. And as we will see, it's common ground that at least on some of the documents related to those facilities, Dr. Shetty's pen and ink signature confirmed to match to his signature are on those documents. It's also notable, I don't think there's any need to go to it, but Dr. Shetty's reply statement, it really functions as a pleading. Various points of law are taken in his reply statement. He criticizes essentially the case that the claimant's witnesses have put, but does not really properly engage with his knowledge of those individuals. There is, however, one point that we would flag at this stage, which again is just simply does not make any sense. And if I could ask that you turn to page 915 of the electronic bundle.
Yeah.
And read paragraphs 37, and then go over the page and read paragraph 38 of Dr. Shetty's reply statement.
37 and 38.
37 and 38, please.
Yeah.
So Dr. Shetty accepts that he met Mr. Sharma, who was the most senior individual from the bank in the UAE between 2015 and 2020 on multiple occasions, alongside the chairman and CEO of ICICI, who would have been based in India. Mr. Sharma's evidence is those meetings happened on roughly an annual basis between 2015 and 2020. So Dr. Shetty accepts that he had these meetings with all of these very senior people at ICICI, but he doesn't say what was, and we say, evidently, what was discussed at those meetings was the significant lending that was taking place to NMC and Dr. Shetty's involvement in all of that. Dr. Shetty doesn't say, he says, well, no, we didn't discuss the NMC facility agreements, the NMC personal guarantees, but what on earth was he doing? Admittedly regularly meeting with senior members of ICICI's management on an annual basis, if not but to discuss the financing that had been availed, very significant financing that had been availed to NMC. So we see even on the limited evidence that Dr. Shetty's put before this court, the gaps are staggering. I would also say at this stage that Dr. Shetty's evidence must be treated with a significant degree of caution due to previous findings of this court against Dr. Shetty. And if I could ask you to turn to page 2 of the claimant's first additional authorities bundle.
Page 2. Punjab National Bank.
Yes, this is a case that was brought by Punjab National Bank DIFC branch against various NMC entities, and as you'll see on page 3 at the top, also against Dr. Shetty, who was the person who was the personal guarantor of one of the facilities that, in this case, Punjab National Bank had granted two facilities. One was to NMC and one was to UAE Exchange. That was another entity that Dr. Shetty owned. And if I could ask that you turn to page 9 of the authorities bundle.
Yeah.
And read from paragraph 51 and 52, you will see Mr. Shetty's primary defense is that he did not sign the NMC guarantee. And Justice René Lamiere held in that case that there was overwhelming evidence that he did.
Yeah.
That evidence is considered from paragraph 53 onwards in the judgment to the factual evidence is considered down to 70. I don't propose to go through that now, but it is an important factor that this court has already dismissed similar allegations of Dr. Shetty that he hadn't signed the personal guarantee. This was a case that Mr. Shaheen was also representing Dr. Shetty. Another point I would flag at this early stage is Mr. Albar, who is the defendant's expert, was also instructed by Dr. Shetty in that case. And paragraphs 72 to 86 of that judgment consider Mr. Albar's evidence.
72 to 86.
72 to 86. I don't propose we delay matters now with reading that, but I would request that the court take that into the rather damning judgment on Mr. Albar's evidence that was produced into consideration as well, and considering the expert evidence. If I could ask
what is the basis upon which it is right for one court to take account of a finding by a judge in another case on different facts? It ends up surely just that judge's opinion on the particular facts, rather than some general statement that the man is unreliable, untrustworthy, a liar, or whatever.
I think it does go slightly further here. We have parallel facts. We have a personal guarantee that Dr. Shetty is saying he did not sign, and that evidence was not accepted by the court. And I think we can go further in that this wasn't a case. This is where you say I didn't sign something, and the court doesn't believe you. That's quite different from a different recollection of a meeting or a different another element of factual dispute between the parties' witnesses. The positive assertion that I did not sign this document and the fact that the court did not believe Dr. Shetty and found serious issues with the expert evidence that he had used, we would say it is a factor that the court should take into consideration. We don't say it's determinative in any way or binding in any way. What we say is that it should inform your approach to the evidence that Dr. Shetty gives. Simply, the caution should be applied when approaching his evidence.
Yep.
If I could then ask that you turn to the Barclays Bank case that's in this bundle, and if we go to that starts at page 34 of the bundle.
34.
Yeah.
Yeah.
And this was a judgment of Justice Wayne Martin, as he then was, that was made in favour of Barclays Bank against Dr. Shetty. Again, similar circumstances. Dr. Shetty was the personal guarantor, I think this time under certain ISDA transactions. And Dr. Shetty's initial case was that he had not signed the personal guarantee in question here. We go to page 39 of the bundle. and look at paragraph 30. And if I could ask that you read paragraph 32 of the judgment.
Yeah. Yeah.
And again, we don't say this is in any way determinative, but the fact that Dr. Shetty had alleged up until the hearing of the summary judgment immediate judgment application in the Barclays case, had alleged that he had not signed the personal guarantee, but hadn't pursued that argument in his skeleton for that hearing, is again another matter that the court should take into consideration when assessing, when approaching Dr. Shetty's evidence that he will give during the course of this trial.
Yeah.
As to the claimant's witnesses, I don't propose to go through their evidence in any particular detail now. They will obviously be cross-examined by Mr. Shaheen, hopefully shortly, unless the court would like any detail going through those statements. Although I think in paragraphs 36 to 41 of my skeleton, I've set out a summary of who is who and their respective roles and time periods during the bank. Would the court be assisted with?
No, I've read the statements, albeit quickly, and no doubt I'll be taken to relevant parts by Mr. Shaheen when he's cross-examined.
I would just ask that Mr. Sharma's evidence is briefly looked at in opening. If I could ask you to go back to the main hearing bundle, to Mr. Sharma's statement, and if we could go to page 877.
Yeah.
And Mr. Sharma's evidence is particularly important because he's the only remaining member, employee of the bank who is available to give witness evidence, who had actually met Dr. Shetty on a number of occasions. So we place particular reliance on his witness evidence. I've already discussed paragraphs 38 and 39 of Mr. Sharma's statement, where he talks about the annual meetings that were held in Abu Dhabi with Dr. Shetty and other senior members.
So Mr. Sharma's statement runs to 18 paragraphs. Or are we talking about a different one?
Yeah, Mr. Sharma's statement. So I said paragraph 8. Did I say I meant paragraph 8?
Sorry, you said 38.
Sorry, maybe I meant paragraph 8 and paragraph 9. Yeah. So that's at bottom of page 877.
I have that.
And the top of page 878.
Yeah.
That's the evidence of the regular meetings, and that's corroborated by various Mr. Parek and Mr. Juneja, who talk about the arranging the meetings in their statements.
Yeah.
The other important point on Mr. Sharma's evidence is the meeting that was held at the Taj Hotel on around the 5th or 6th of March. That's detailed at pages 11 to 17 of his statement. And just to summarize what happened there. Oh, sorry.
You said 11 to 17. His statement begins on 15. Do you mean paragraphs 11?
Paragraph, yes. Apologies. Paragraphs 11 to 17. That's pages 878 to 879. of the electronic bundle,
Yeah.
where Mr. Sharma talks about the meeting that he'd been desperately trying to arrange with Dr. Shetty following the Muddy Waters report and the various reports in the press. So this is in between the press reports in December 2019, when the Muddy Waters report comes out. Obviously, there's then severe issues for NMC, but before the parent company in London goes into administration in April 2020. And the only points I wanted to make on this meeting now, I'm sure it'll be explored in cross-examination, are that Dr. Shetty does not dispute this meeting took place in Bangalore, and simply to submit, again, this is another nonsensical part of Dr. Shetty's evidence. He says they didn't really discuss his liability under the personal guarantees or much about what was about NMC's financings. But again, it begs the question, why was he meeting with the DIFC branch's most senior banking executive in India during this period of intense issues for NMC, but to discuss the indebtedness of the business and his liability thereunder. They're the only points I wanted to make on the witness evidence at the beginning. A brief word on disclosure. I've covered this in quite a bit of detail in my skeleton argument, but just to recap where we got to with disclosure from the defendant. The claimant essentially asked in its Redfern schedule for all of the documentation in Dr. Shetty's possession between NMC and ICICI and himself, and also documents relating to Dr. Shetty's management of NMC after 2017. These are the two main requests that were made in the Redfern schedule to Dr. Shetty. In response to those requests, if I could ask you to go to page 3334 of the main bundle.
3334.
Right at the back in the intersolicitor correspondence.
Hold on.
And I do think it's a very important email. So if I could ask that you read that in full.
Wait a second, it's taking time to. Right, yeah. You want me to read the whole email?
Yes. Certainly the first 3 paragraphs or 4 paragraphs.
Yeah.
Nothing was ever disclosed, despite recognizing there's 150,000 potentially relevant documents, despite repeated chases from the claimant's solicitors. So I should, none of these documents closed. There was limited disclosure of a handful of flight tickets. They are in the bundle, the relevance of which has never been explained. But apart from that, there has been no disclosure.
Did you get an order?
We didn't get an order. As I said, we were hoping for disclosure in July. Nothing came. It would have been possible to have applied at that point to seek an order for disclosure. There were concerns on this side, prescient perhaps, that if we were to go into a heavily contested disclosure application, which would result in disclosure at that point of very significant volumes of documents, if it was complied with, that could then impact upon the hearing dates now in September.
Yeah.
But my lord is quite right. There was no application made. We would also flag attempts were made by the claimant to obtain evidence from other sources. I won't take you to it, but at page 650, there is the culmination of a number of exchanges that took place between this firm and Quinn Emanuel, who represent the administrators in the ADGM proceedings. Similar requests were put to them. They confirmed that they had around 11,000 documents that were responsive to the requests that were made, and but they said in the interests of all of the creditors, it would be a disproportionate exercise for them to go through those documents and disclose them to us. It's important to flag in terms of disclosure, because as we've said, and it appears to be common ground, the burden of proof is on the defendant to positively show that he was the subject of a fraud. The fact that he has chosen not to disclose any of thousands and thousands of documents that relate to this period of time is a material fact that the court should take into consideration. My learned friend that is...
Sorry, you've said a few times now the burden's on the defendant to show he was the victim of a fraud. Isn't the real question simply, are they his signature? Did he sign the documents? And as part of that, he says he was a victim of a fraud. But the ultimate burden is on you to prove he signed the documents, isn't it? It may not be very difficult to
I think
the burden may shift from time to time, evidentially, but the legal burden's on you.
I think, my lord, the burden, we produced documents that show that the guarantees signed by Dr. Shetty. There's the legal presumption that they were duly executed, and it's for Dr. Shetty to show that both that he didn't sign those guarantees, and more broadly, this is an allegation that there's been some it's not just I didn't sign this one document, in which case we would say, well, we've got a duly executed document, then you would have an argument about it. Dr. Shetty is alleging a massive conspiracy against him over a period of 10 years, where thousands of documents were signed without his knowledge. So the burden is on him squarely to prove that.
Okay. There may be argument about that. No, because the simple point is that it's for you to prove that he signed the documents. You then go into the even if, for example, his case on fraud failed, you still have to prove that he signed the documents. It may not be very difficult in those circumstances if no explanation is given, but the legal burden's on you.
The legal burden's on us to show that these guarantees we can rely upon these guarantees. We'd say we get over that burden initially, that there are signatures of Dr. Shetty on these documents, and that the legal presumption of due execution would work in our favour there to say, well,
I see.
Okay. And also the expert evidence does align. Both experts agree that the actual signatures are Dr. Shetty's. There's no dispute over that. There's not been some bad attempt at a forgery in the sense of someone trying to copy his signature. The dispute is over whether or not well, as you say, it's very difficult to see actually what the argument is when we get into it. Because some of them have actually been signed by him, and the experts agree. But we'll get to that in a little bit.
We can come back to that at the end. Yeah.
Just to wrap up this point on disclosure, my learned friend at paragraph 69H of his skeleton says that the documents haven't been disclosed because of collateral use restrictions. That's not a point that's ever been raised in correspondence with the defendant's solicitors. Well, again, it doesn't really seem to make much sense. Collateral use is a restriction on documents that a party has received during the course of legal proceedings. and that's a restriction on using those documents in other legal proceedings. What we were requesting Dr. Shetty to disclose were his documents, and our understanding is the emails from Baker Tilly concerning this matter were about his documents. Even if there were, which we can't understand how, but even if there were some sort of collateral use restrictions, as I'm sure your lordship is aware, there are ways of getting around that and making the relevant applications to whichever court you're before, so that you can use documents that have been disclosed in those proceedings in other proceedings.
Yeah.
So again, the overall picture on disclosure, we say, is an important one. Turning to the documents and where we're at in terms of the expert evidence, what I propose to is quickly go through at least the first two facilities and where we're at with the expert evidence on those, because I think they make some quite startling points, which should be borne in mind when we're going through the evidence on cross-examination. So if I could just ask that you turn up the first facility agreement, the 2011 one, that's at page 80 of your electronic bundle.
80.
80.
Yeah.
So this is the very first loan agreement entered into between NMC and ICICI Bank. Originally, I think the facility was for $5,000. If I can ask that you turn to page 131
Give me a moment to
of the bundle.
The thing is taking a bit of time to catch up.
Oh, sorry, it's quite a big document.
It's not even getting the document yet. Give me a moment. So it's still waiting for it to load.
Okay.
How long are you going to be on this point? You talked about carrying on till 11:15. Is it sensible to do this after we had our break, or would it be a 5-minute break?
I think I may be another half an hour or so. So I do think it might be a good point to break, and then I can go through the documents. Again, I'm going to try to be as quick as possible, but
Yes,
I think at least another half an hour.
You allowed yourself an hour. You've now been 40 minutes, so 20 minutes would be your limit.
Okay, I'll go swiftly as possible through. Would you like me to try to finish now?
No, I think for the transcriber, probably sensible if we stop now for an hour and resume at 13 minutes past 2 your time. Yeah.
3.
Past 3, 30 minutes past 3. Okay. Right. We'll adjourn at this stage. Thank you. Are we all ready? Can I just check that the transcriber is ready? Madam Transcriber, are you there? Ali, are you there?
Yes, Your Honor, I'm here.
Do you know what's, oh, I think the transcriber is present now, is that right?
Yes, I'm here. Sorry, I was on mute. Sorry.
Don't worry. Right, are you ready to begin?
I am, my lord. Sorry.
Yep.
Yes, so there were just two preliminary points before I continue with openings. One, on Miss we've managed to get some feedback from Miss Radley. She confirms that she'll be in a position to serve a further supplemental report and have that prepared. She has flagged there's a slight disadvantage in that she doesn't have access to the original documents. The original documents are currently in our offices. And so she will have to rely upon us to send photographs and scans to her if she needs to make certain points. But subject to that,
where is she based?
She's in London, just
Right.
outside. But subject to that one point, which will obviously be mentioned in her further report, she's confirmed she'll be able to prepare something for close of business at London tomorrow.
Right.
So on that basis, on the basis that the claimant's permitted to file that further report from Miss Radley, we would then be amenable to Mr. Albar's supplementary report being admitted.
And this will simply be responsive to new points.
Purely responsive to the points raised in Mr. Albar's supplemental report.
Yes, not a repetition of previous points. Yep.
No. Ms. Radley understands, and she's
yep.
Sure.
What was your second point?
Second point, in terms of the running order for the witnesses once closings have finished, I just wanted to briefly flag that might have to change given we're running a bit late. Mr. Sharma, who was scheduled to go at 5 p.m., he's obviously quite a senior member of the bank. He'd like to keep his scheduled evidence at 5 p.m., which will then mean adjusting the evidence of Mr. Gupta, Mr. Parekh, and Mr. Juneja. They'll stay in that order, but that will mean that Mr. Gupta will give evidence at 6 p.m. He's in Hong Kong, so I think that will be 9 p.m. for him. And then Mr. Parekh will give evidence from Shanghai. That will be 11 p.m. I think for him. And then Mr. Juneja is here in Dubai and will be giving evidence from a separate room from our offices. So as long as everybody is amenable to that, that's how we propose we deal with the.
I'm not sure what I'm not sure what your planning is in terms of finishing time. Each witness has got an hour allowed on the schedule. Sorry, Karen.
We were scheduled to finish at 6 p.m. This would have us finishing at 9 p.m., which is obviously not ideal.
It's not practical.
UAE time, not practical UAE time.
Quite apart from that, we can't have more than 3 hours at a stretch in the afternoon.
Yes,
maybe we can slip by a quarter of an hour or so, but we can't. The transcriber has to have a break, and we all have limited time.
Yes, that's quite right. Maybe if Mr. Shaheen could give an indication whether he plans to use the full hour for each witness.
I suppose he knows.
Yes. It may only exceed. It will not be less than that.
I can't hear you, sir.
Sorry.
It may exceed 1 hour. It will not be less than 1 hour for sure.
Well, I think this has been agreed on the basis that these times are going to be kept to. So we can't exceed 1 hour, can it?
I'll try my best to finish it within 1 hour, Your Lordship.
Yeah, okay. Well, Let's not waste time now, but if you can bear
Okay.
in mind with your scheduling of witnesses that we can't, we can accommodate court for an hour, so I'm sure the transcriber won't mind that, but we can't go on for hours uninterrupted.
Yes, my lord. Well, it may be the case we just have Mr. Sharma then today, who keeps his appointment at 5 Dubai time, and then we'll have to deal with the rest tomorrow on Tuesday.
Well, see, let's not waste time in the middle. Yeah.
Okay.
Okay.
So my lord, continuing from my openings, we were at page 131 of the main bundle.
Yep.
We were looking at the original facility agreement that was entered into by NMC and ICICI in 2011. At page 131, you will see the agreement was on the execution page was said to be by Dr. B.R. Shetty. There's a signature on the right-hand side and a seal of NMC Healthcare on the right-hand side. Ms. Radley has considered this document. I'm going to make several references as I go to both parties' expert reports. I don't propose to take you to each of those as we're going, but I will give you the page references and paragraph references of the reports as I go for the transcript.
Yeah.
So Ms. Radley has considered this document. That's at paragraph 159 of her first expert report. That's at 957 of the electronic bundle. She confirms that this has been signed in a black non-ballpoint pen and ink. At paragraph 166 of her report, which is at 958 of the electronic bundle, she confirms that there is very strong evidence to support the proposition that Dr. Shetty wrote this signature after doing a comparative analysis to the examples of Dr. Shetty's signature that have been given. Mr. Al-Bar agrees with this assessment. He confirms at paragraph 8 of his expert report at page 986 of the electronic bundle that this is, his exact wording is a bit odd, but he confirms that this is Dr. Shetty's signature. So the very first financing agreement that's entered into between NMC and ICICI, the experts are addendum that Dr. Shetty signed it. That is squarely contrary, against what Dr. Shetty says, that he wasn't aware of the NMC and ICICI financing arrangements that were in place. As I mentioned, the first facility initially wasn't supported by a personal guarantee. The first facility was amended and restated on the 24th of September 2012. And if I could ask you to turn to that, that is at page 133 of the electronic bundle. And sorry, my lord, are you there?
Yeah.
And before we look at the signature page, if I could just ask you to turn to page 143 of the electronic bundle. If you look about halfway down at clause 12, general terms and conditions, you will see promoters, personal guarantors, Dr. B.R. Shetty, an individual resident of UAE bearing Indian passport number Z19-48905. I could then ask you to turn to page 148 of the electronic bundle. You will see the execution page for the supplemental and amendment agreement to the first facility. You will see there that Dr. Shetty's name is typed out as Dr. B.R. Shetty, a director of the borrower, which is NMC Healthcare. And you will see there are 3 signatures on this document and of Dr. Shetty's and a blue seal for NMC Healthcare.
Yeah.
Ms. Radley confirms at paragraph 168 of her expert report that the signatures have been appended in black non-ballpoint pen.
Page
A paragraph. Let me just.
Don't worry if you haven't got it. I can find
I don't have it immediately to hand, but I'll get you that reference afterwards. Paragraph 175 of her first expert report, which is at 960 of the electronic bundle, she confirms that there is very strong evidence to support the proposition that Dr. Shetty wrote all three of these signatures when comparing against his other examples. Mr. Albar agrees with this assessment and confirms that he believes the signatures are Dr. Shetty's. That's at paragraph 6 of his expert report, which is at page 985 of the electronic bundle.
Yeah.
Accordingly, the first time the facility agreements between NMC and ICICI envisage a personal guarantee being given by Dr. Shetty, the evidence of both experts is that this agreement was signed by Dr. Shetty. Sorry, that previous reference of where Ms. Radley confirmed that the signatures were in black ballpoint pen on this document is at page 959 of the electronic bundle.
Thank you.
Mr. Albar does raise one potential issue with this document, in that he says there is a degree of clarity. So the printing on the final page of this document, which is at page 148, is a different quality to the remainder of this to the rest of this document. So the first 15 pages of the amendment and restated facility. That's at page 976 of the bundle. Miss Radley strongly disagrees with that assessment. She points to the fact that there's a noticeable printing defect, which I think you can see from the bundle itself. On the left-hand side of the page, there's a slight lightness to the words, where it starts in witness, the lightness starts, and then it goes away whereof, and it runs down the page. And Ms. Radley says this is a noticeable on each of the pages of this document. So if you turn back to page 147 of the bundle, you'll see there's the same light line.
I can't see that.
Okay, you might not be able to see it on the electronic bundle.
That's not very helpful then, is it?
It should on the printed bundle. Yes. So it's not a line in the sense of a line drawn on the bundle. It's that the text fades in a line on the left-hand side.
Right.
I don't know if you can see that. Maybe if you turn to page 147, you'll see that the words on the left-hand side, where you get to about quarter, well, maybe less, fifth of the way into the page, there's a lightness.
Just a narrow band of lightness.
And a narrow band, yes, that runs vertically.
Going vertically. So, for example, under U, material adverse change, the word would appears.
Yes.
Pale. Is that what you're talking about?
Yes, my lord, and that's identical on each page of the document, each of the pages of the document. And Miss Radley says that's a defect in the printer. And she considers that at paragraphs 33 to 37 of her supplemental report, which is at pages 1021 to 1022 of the electronic bundle. And she says this is very strong evidence that this was one document that was executed in one go instead of.
Give me those pages again.
So that's paragraph 33 to 37 of her supplemental bundle, and that's page 1021 to 1022 of the electronic bundle.
Thank you.
This is a point that will be taken up with Mr. Albar in cross-examination. However, we would say there's no proper ground put forward to say that there should be any question to this document. So we would say that the first facility agreement, it should be common ground, was signed and executed by Dr. Shetty. That's squarely inconsistent with the evidence that he's given to this court, that he didn't sign the document, and B wasn't aware of the facilities that were in place between NMC and ICICI.
Yeah.
If we can turn to the personal guarantee that was issued in respect of the amended and restated facility, that's at page 447 of the electronic.
Yeah.
447 of the electronic bundle. So if you go to the signature at the bottom of the page.
Hang on, it hasn't come up yet. Yep.
Sorry, I'm seeing a little issue with my bundle.
What page is the signature?
So it's 447 we're going to.
Yeah, I've got that.
So this is the first personal guarantee that's in question. And then if you go down to page 460, the electronic bundle.
Yeah.
We'll say there is the execution page. It is said to be executed as a deed by Dr. B.R. Shetty.
Yeah.
It is signed by Dr. Shetty on the right-hand side, and then it's witnessed by two witnesses, Mr. Prashant Mangat, who is the CEO, so not the CEO, senior manager at NMC, and Mr. Kumar, who is the CFO. Both experts agree that the signature of Dr. Shetty on this document is an electronic signature, and both experts agree that the signature of the first witness, Mr. Mangat, is an electronic signature, and the final signature of witness number 2, Miss Radley confirms is a wetting signature that
Yes,
was
Mr.
signed by
Mr. Kumar. Is that Mr. Kumar? Is that Mr. Kumar you're referring to?
Yeah, Mr. Suresh Kumar, who was, I believe, CFO of of NMC.
Yeah.
So that's 60. Miss Radley has confirmed that this document has been signed electronically. Those confirmations are at paragraph 55 of her expert report and page 9. Her first expert report, yes, which is at page 938 of the electronic bundle. It's worth noting here that this electronic signature used by Mr. Shetty in this document is identical to the one that was used many years later for the modular guarantee. So that's the final guarantee that we will come to. And on that basis, Miss Radley says that this can't have just been a photocopy of his signature, which was then subsequently signed by Mr. Kumar. It must have been an electronic signature that was added to the document and was then subsequently signed by Mr. Kumar and Penn. As for the signature itself, Miss Radley confirms there is very strong evidence that the original signature, i.e. the signature that was used to create the electronic signature, was that of Dr. Shetty. That's at page 944 of the electronic bundle.
So give me page again.
944 of the electronic bundle. Mr. Albar makes a very, very significant leap in his conclusions on this document. Paragraph 17 of his first expert report at page 993, he says that this is clear evidence that there's a forgery has taken place. Now, this point will be addressed with Mr. Albar in cross-examination. The claimant's position is that it's entirely normal for documents to be signed electronically, and it is not indicative of fraud. That is also Miss Radley's opinion, which appears at several places in both her first expert report and her second expert report. I signed a number of documents this morning for Stevenson Harwood electronically. I'm sure everybody on this call, at this hearing, has signed documents electronically. It is not indicative of fraud. And for Mr. Albar, who is supposed to be the expert in this matter and impartial with his duties to the court, to immediately say that this shows that the document is forged severely impacts upon his credibility as an independent expert witness. Importantly, there are subsequent documents that were signed in respect of the first facility and the personal guarantee in question that the experts have considered and have confirmed are signed by Dr. Shetty. Now, pages 149 to 190 of the electronic bundle, we have 6 letters of amendment to the first facility. The experts have only considered 3 of these, given they were the ones the bank was able to locate. These are dated the 26th of November 2013, the 14th of August 2016,
Hold on a
and the
second. Go through those dates again.
The 26th of November 2013, the 14th of August 2016,
Yeah.
and the 25th of July 2017. So I'll restrict my remarks to the ones the experts have actually looked at. If I could ask you to turn to page 150 of the electronic bundle. Sorry, I should probably ask you to turn to page 149 first.
Yeah.
This is an amendment agreement to the first facility.
Wait for it to come up.
Oh, apologies.
Yep. 150.
But if you could go to 149 first.
Yep.
This is a letter of amendment to the first facility agreement. You can see that from the first line, which mentions the 29 December facility. This letter of amendment was entered into on the 26th of November 2013. If I could ask you to turn over the page. Page 150 of the bundle, at the bottom, you'll see Dr. Shetty's signature and typed out Dr. B.R. Shetty, authorized signatory of NMC Healthcare. Ms. Radley confirms at paragraph 177 of her expert report, which is at page 906 of the electronic bundle, that the signature has been applied in non-ballpoint black ink and the date has been appended in black ballpoint ink. You can see there's a handwritten date just below Dr. Shetty's signature there. At paragraph 182 of Ms. Radley's expert report, which is at page 961 of the electronic bundle, she states there is strong evidence to support the proposition that this is Dr. Shetty's signature. Mr. Albar confirms at paragraph 20 of his expert report, which is at page 995 of the electronic bundle, that he considers this to be Dr. Shetty's signature. Importantly, if we move on to page 153 of this document, this is still within the amendment letter
Yeah.
Halfway down the page, you will see there's a definition of personal guarantee.
Yeah.
And also a definition of personal guarantor, which means Dr. B.R. Shetty. So this amendment agreement post dates the personal guarantee in respect to the first facility that is being questioned by Dr. Shetty. However, it does mention a personal guarantee is being granted for this facility and defines himself as the personal guarantor. The position is identical for the other two letters of amendment. They're very similar letters of amendment. They update the definition of personal guarantor. If I maybe instead of taking you to each of them, I'll just give you the references in the interest of time. So the 14th of August amendment letters at page 178 of the bundle. Page 179, again, is Dr. Shetty's signature. Again, both experts are of the view that this is a wet ink signature, and there's strong evidence that, and Ms. Radley says it's strong evidence that it's Dr. Shetty's. Again, there's a definition of personal guarantee and personal guarantor. That's at page 181 of the electronic bundle that defines Dr. Shetty as the personal guarantor. The 25th of July 27 amendment letter is at page 183 of the electronic bundle. At page 84 of the electronic bundle is Dr. Shetty's signature. And again, both experts are of the view that this is a wet ink signature and that there is strong evidence that it is Dr. Shetty's. I am using a bit of shorthand here in that when I say the strong evidence that it is Dr. Shetty's, that is Ms. Radley's terminology. Mr. Albar just seems to presume that it is Dr. Shetty's signature. He doesn't specifically say it in terms. Again, in the 25th of July 2017 amendment letter, page 185 of the electronic bundle is a definition of personal guarantor and personal guarantee, and Dr. Shetty is again defined as the personal guarantor.
Mm-hmm.
Turning, if I could ask you to turn this next document up, that at page 463 of the electronic bundle. Do you have that, my lord?
It's coming. I'm afraid that for some reason it takes a bit of I've got it. Yeah.
This is a document entitled Continuation of Guarantees to the Facility. Now, this might take a little bit of explaining. You'll see that initially, so this continuation of guarantees is dated 25th of October 2014. The first paragraph, it refers to the master facility agreement dated 24th of December 2013. That's the second facility agreement we haven't come to yet in these documents. That appears to be a mistake, because then if you look further down, paragraph 2, it says, I further refer to the personal guarantee dated 20 December 2012. That's the personal guarantee that Dr. Shetty gave in respect to the first facility agreement. And then if you look down at paragraph 2B of that document, it describes a facility for $25 million. Again, that is the first facility, not the second facility. So we would say this document is actually in reference to the first guarantee, not the second guarantee. If you turn over to page 464 of the bundle,
Mm-hmm.
you will see there's a signature, typed Dr. B.R. Shetty, and a signature of above that at paragraph 184 of Miss Radley's report. She confirms this document has been signed in blue non-ballpoint ink, and that's at page 961 of the electronic bundle. A point just to flag here, Mr. Albar makes a couple of generic points that, well, these documents I say that have been signed in pen could have been swapped in and out, and different documents put in their stead. This doesn't seem to make a lot of sense. I'll explore this with him in cross-examination, but this is quite an important document because at paragraph 186 of her expert report, Miss Radley confirmed she carried out an ESDA analysis on this document. This is an analysis that can gather the impressions from other pages of a document in order to see if writings have carried through.
Yeah.
And she's carried that out on this document, and she says that an ESDA impression for the sticker that was next to the signature page saying original removal PG, which is appended to indicate where Dr. Shetty should have signed. She's got ESDA impressions of that from both this second page of the amendment letter and the first page of the amendment letter, showing that they were signed, that he signed the second page on the first page. Mr. Albar, Ms. Radley's carried out an analysis of this signature at paragraph 199 of her expert report, which is at page 964 of the electronic bundle. She confirms that after an analysis of Dr. Shetty's signature, there is strong evidence that this signature is Dr. Shetty's in this document. Mr. Albar appears to agree with this. At page 993 of the electronic bundle, a paragraph 16 of his expert report.
Page what? 995.
Page 993 of the electronic bundle,
No,
paragraph 16 of Albar 1. Accordingly, there is overwhelming evidence that Dr. Shetty signed the first facility in 2011. There is overwhelming evidence that he signed the amendment and restatement agreement that was signed in 2012. There is strong evidence that he signed the personal guarantee. And as we've seen, there are a number of subsequent documents, both experts agree, have been signed by Dr. Shetty that refer to the fact that the 2012 facility was personally guaranteed by Dr. Shetty.
Mm-hmm.
Moving on to the second facility, that's at page 191 of the bundle, electronic bundle. There doesn't appear to have been an original signed copy of this facility agreement. If we turn to page 230 of the electronic bundle. Sorry, 229 of the electronic bundle. So this isn't one of the documents the experts looked at because the original wasn't located by the claimant.
You've got to give me a second again for loading. While this is taking time to come up, can I just mention time? I mean, you've both agreed a timetable, which allowed you to have an hour for opening. We've gone a bit beyond that, and I imagine you're going to be at least another quarter of an hour, 20 minutes. We've got to do something about this because we've only got limited time. One solution to think about would be to ditch the oral closings and have a fairly short timescale for written closings. But I leave you to think about that.
That might be. I should hope to be only another 5 or 10 minutes.
Okay.
The documentation's left. The first facility has a lot of documents. The second and third, decreasingly so. So I hope not to be too much longer, but that may well be, depending on how we get along. That may well be a good solution. So
page 191, 230 you want.
So if you could go back one page to 229, you'll see that the second facility agreement has been signed by Dr. Shetty and a seal of NMC Healthcare added there. On page 230, again, signed by Dr. Shetty with his name set out there. Like I said, this hasn't been considered by the experts because the original agreement couldn't be found. But luckily, the personal guarantee for the second facility do have an original. So if I could ask you to go, before I turn on to that point, it's worth noting that there are various, as with the first facility, the second facility was a very long running facility and there were various letters of amendment to that facility. They are at pages 231 to 259 of the electronic bundle. Again, the original 231 to 259 of the electronic bundle. Again, the originals.
The second facility agreement is the one dated 24th December or not?
Second facility agreement is the one that's dated 24th of December 2013. Yes. And
yeah,
at pages 231 to
258, you said 259.
259 of the electronic bundle, you have a number of letters of amendment to that facility. Again, the claimant wasn't able to locate the original copies of those letters of amendment, so the experts haven't been asked to consider them. One point just to note, though, a number of them also, like the first facility, make reference to personal guarantees having been issued by Dr. Shetty. An example of that is at page 244 of the electronic bundle, which refers to a personal guarantee having been issued by Dr. Shetty.
Page what?
That was at page 244 of the electronic bundle.
Yeah.
Turning to the personal guarantee itself for the second facility agreement, this is at page 470 of the electronic bundle.
Yeah.
This is the second guarantee that's been put into question by the defendant. If you turn to
the personal guarantee of the second facility.
Yes, that's the one. So if you turn to page 483 of the electronic bundle, you'll see at the top of the document it is said to be executed as a deed by Dr. B.R. Shetty, and again in the presence of two witnesses. First witness is a Mr. Kumar. I think this is a different Mr. Kumar to the first one, and I haven't been able to decipher the name at the bottom of the second witness. Ms. Radley has considered this document at paragraph 91 of her first expert report. That's at page 944 of the electronic bundle. She confirms that Dr. Shetty's signature was added to this document in black ballpoint pen ink. Ms. Radley goes on to confirm, following a detailed analysis of this signature, that I should mention there's two signatures of Dr. Shetty on this document. The first on the right-hand side, and there's a further signature where the name of the first witness should have been inserted in that document. Yeah. So Ms. Radley confirms that those signatures were added in black ballpoint pen ink. She goes on to confirm that there is strong evidence, after a comparative analysis of the examples of Dr. Shetty's signature, that there is strong evidence that Dr. Shetty wrote the signature that's at page 483 of the bundle. Ms. Radley's comments on that are at page 947 of the electronic bundle. Mr. Albar agrees that the signature of Dr. Shetty is consistent with the samples analysed. That's at page 991 of the electronic bundle. He does, however, raise a concern that the printing quality on the last page is noticeably different to the rest of the document. At page 992 of the electronic bundle, he provides two pictures which he says demonstrate.
Page what?
Page 992 of the electronic bundle.
Yeah.
So there he's provided two pictures that he says show there's different printing quality on the signature page of the personal guarantee and the rest of the document. And he therefore says that it may have been subject to a forgery on this basis. That isn't credible. Even if it was true, it's very common for a signature page to be printed off separately from the rest of the document and then to be appended to it. The signature page clearly runs on from the preceding 13 pages in the personal guarantee. However, Mr. Albar is wrong that the quality of the page and the printout at page 483 of the electronic bundle is different from the rest of the personal guarantee. Ms. Radley has considered this in her supplemental report, and she goes through this at page 1029 of the electronic bundle. She sets out a number of photographic examples, two photographic examples, one of page 1 and one of page 14 of the second guarantee, which she says demonstrates that they are of the same printing quality and that there is no differences in printing quality. The claimant therefore says, in light of this, there can be no possible dispute that the second guarantee was signed by Dr. Shetty, and Dr. Shetty's evidence that he did not sign it is clearly untrue. Right. Move on to the third NMC facility. I'll move on to the third NMC facility, and then I'll leave it there for the opening. The third NMC facility is at page 260 of the electronic bundle.
You want me to turn it up? Yeah, sorry, no, it's not yet.
So this is the third facility, NMC facility, under which the claimant says money is borrowed. Just to give a little bit of background, which might not be clear from the skeleton, there were a number of, this is a term loan facility. Alongside the two facilities we looked at, there were long-term facilities that were amended. The claimant made a number of individual term loans that were repayable within a year. I understand 4 or 5 of them were made. There's not much evidence of them in the bundle, but we can go to that if necessary later on. And those term loans were individually repaid. So the first term loan was for 10 million. I believe that was in 2012, and so on and so on. This was the final. This was a kind of chunky cash drawdown facility where the NMC would draw all of the cash down on that facility in one go and then would repay it over the course of a year, as opposed to the other two facilities that were more kind of working capital, where individual drawdowns were made and then the parts of the facility were repaid. So this facility does have some background in terms of various other facilities that have been agreed and had been repaid. And this facility was for $50 million. And if we turn to page 270 of the electronic bundle, About 2/3 of the way down, you will see a definition of personal guarantee. And below that is a definition of personal guarantor. And that confirms that it's Mr. Bavaguthu Shetty who will be the personal guarantor of this facility. If we go to page 509, sorry, if we go to page 349 first, it's important to note that this facility wasn't signed by Dr. Shetty. So the experts looked at this document, but they didn't do any further analysis, given it wasn't actually signed by Dr. Shetty. You'll see at the top of page 349, it was signed by Mr. Kumar, the CFO. And then if we turn to the personal guarantee that guaranteed this facility, that's at page 509 of the electronic bundle.
Sorry.
Have we met? Is it
It's still loading.
still loading?
Got it. Okay.
So this document, the experts confirm, I don't have the references here actually, but they confirm that the first page of 509, the date has been added in pen and ink. And at 525, again, the date has been added in pen and ink. And then at 527, there is Mr. Shetty's signature. The experts are agreed that this is an electronic signature. And I don't have the references to hand, but it's identical to two or three other documents the experts examined. One of them was a utilization request. So it's common ground that this was an electronic signature that was added to the third personal guarantee.
Mm-hmm.
I'll leave it there in terms of the documents. We might go through the modular ones later. But we would say, in light of having looked through the documents, in light of having looked at where the experts have got to, the evidence is overwhelming that, at least in respect to the first facility and the second facility, that Dr. Shetty signed those documents, that he signed the personal guarantees, that he signed subsequent documents which clearly refer to the personal guarantees and continue the facilities. If you accept that, then Dr. Shetty's evidence must be dismissed. He clearly was aware that NMC was borrowing money from ICICI. He signed most of the documents himself, and both of the experts agree that's the case. So his evidence on that front is clearly not to be believed. This will be tested with him in cross-examination. The evidence that he signed the personal guarantees is overwhelming. Not a single one of the signatures themselves has been called into question in respect of whether it's Dr. Shetty's signature. None of Mr. Alvar has not said any of them are not his signature. They all conform with how Dr. Shetty writes his signature. The only point taken is that some of the documents have been signed electronically, and that is not a sound ground for calling into question the documents themselves. We all know documents are at times signed electronically, and given the vast number of documents that have actually been signed by Dr. Shetty in pen, and the experts have confirmed he has signed them in pen and confirmed that they are his signatures. On no basis can Dr. Shetty's case be accepted that he did not sign the personal guarantees and that he was not aware of the financing facilities that NMC had been given by ICICI.
Your case, very simply, is that if you can establish a few of them, then that's enough to get you over the burden of probabilities that essentially denies all of them. If you establish a few.
Absolutely, that's how it must work. Because if we can establish that, if I could have established that even one of the facilities and one of the personal guarantees were signed by Dr. Shetty, then he clearly he's been giving evidence to the court that's untrue.
Yes,
and the rest of what he says about not having signed the documents should not be believed. He has said every single document he did not sign. The hundreds and hundreds of financing documents that are relevant to these facilities he did not sign, and the evidence is conclusive that he did sign.
Yeah. Very well. Is that you finished?
That's me finished.
Mr. Shaheen, do you want to present your opening?
My turn now, right?
Your turn now, yeah.
Your audio is not clear, sir.
I cannot help it, Your Lordship, and I don't want to be disturbed like this. And with all due respect to Madam, transcription is important, but my presentation is more important to the court. So
yes,
please help.
All the transcriber is suggesting is if you're careful to make sure you're speaking towards your microphone, I think.
I've kept two on both my sides, Your Lordship, and I'm talking to that.
Okay.
So, Your Lordship, as my learned friend put it, there are hundreds and hundreds of documents pertaining to this facility is what he said. That's how we concluded and wish to start from there. But out of which, when total denial was there was not a single document that I remember to have signed for this facility or for the personal guarantee is a definite contention raised by the defendant. Despite that, only 13 documents were submitted for examination by the experts. Only 13 documents. And the experts have examined those documents in light of documents produced by both sides. And mostly—
Sorry to interrupt, sir. With all due respect to you, I also have a job to do the transcript. Did you say you have two microphones, one each side at the moment?
Yes, madam.
Okay. And as you move the paper on top of one of the microphones, I lost all your words then. I'm trying to speed things up, even though it doesn't seem that way. Is there a way you can use your laptop audio? Because that would be clearer, I think, than the external microphone.
No, madam, we tried it several times. It's not working that way. And
Your
even if my transcription is going bad, I take the risk, Your Lordship. Please allow me to submit my case.
Mr. Shaheen, no one's trying to stop you submitting your case, except it's important if this matter goes further, for example, that we know what your submissions have been. And the transcriber is doing her best. It's not easy with these virtual hearings with microphones and everything, but if you could try to make sure you keep the paper off the microphone, do your best.
Paper, it's not on the microphone, Your Lordship. It's separate. Paper is in the middle.
Okay.
And Your Lordship, everybody else is able to hear it properly. I don't see any problem. And anyway, video recording is there. So that is why I don't give too much importance to transcription, but it's important that I be able to maintain my flow and submit my case properly before Your Lordship in an attempt to help Your Honor to arrive at the right conclusion. So I prefer not to be interrupted. If there is a problem with the transcription, I would rather take that risk, Your Lordship. It's my submission end of the day.
Right,
so,
I'm sure the transcriber will do her best, but I think if you want to take the risk, so be it. But are you happy with that, Madam Transcriber? I'm not happy with it, obviously, but
well, I can hear other parties clearly. Usually the laptop microphone works better than the external microphones, and I'm not catching every word that he's saying. With all due respect, sir, my job is to produce the transcript, Mr. Shaheen. So and I'm very professional in my job, and I would like to get every word you're saying. I don't want to keep interrupting you. So that's why I was hoping that the laptop microphone could be used, because I'm pretty sure that would be better than the external microphones, and not very clear.
Thank you very much, madam. I appreciate it. But 4 or 5 times I repeated, we tried that, is not working.
Do you
So
have
that's
another
why-
laptop you could use potentially? Because
We did.
this is a 3-day hearing. You tried another laptop?
We can try it for day after tomorrow, but not today.
Well, that's why I was asking earlier. Maybe we could have resolved something in the lunchtime. It would have made for a smoother proceedings. If I can't hear, I have to put in audible. It's not something I very much like to do, and the transcript is very important, and this is my job.
Let it miss in the transcript, madam. Please don't interrupt me. It hurts me a lot. I have to do my job.
Mr. Shaheen, that came over, but I'm sure he didn't mean it to be rude, but it came over slightly rudely. So if we can recognise that each is trying to do his job, his or her job, and maybe if when you're talking you can slow down a fraction, that might help the transcriber. But I'm afraid there will be interruptions sometimes, and you'll have to bear with me. We'll bear with the transcriber and allow her to interrupt when it becomes impossible for her. Anyway.
I understand, Your Lordship. I'll try to be slow, but when you get into the arguments, Your Lordship knows how it goes.
I know you get excited. We all get excited and talk fast.
Yes, that happens.
Okay, do your best.
Things like this, where we are almost becoming like Sherlock Holmes. So, Your Lordship, may please bear with me. So, Your Lordship, when we say hundreds and hundreds of documents were involved in the whole transaction, only 13 of them were produced for examination by the experts. So I'm restricting my case to those 13 documents because there is a total denial. And unlike what my learned friend tried to put it, the burden of proof heavily remains on the claimant. Negative cannot be proven, Your Lordship. If I say that I did not meet XYZ in my life, I cannot produce any evidence for that. I can only deny. If XYZ is saying that, yes, Shaheen has seen XYZ, then XYZ has to produce an evidence confirming that I have seen that person. Negative cannot be proven. So burden of proof is always on the person who is asserting a fact. Denying a fact, whether it's existing or not existing, it's impossible for the denier to prove it, Your Lordship. My humble submission is, please don't ask anybody to prove the negative. So the burden of proof being on the claimant, I'm only looking into those 13 documents in this case. But before getting into the expert report, I would like to quickly go through the the skeleton argument submitted by the claimant. In paragraph 3, Your Lordship, the claimant attempts to put it in a very simple, straightforward case. The claimant's claims are straightforward. The debts that are owed by NMC to the claimant are not contested. It's not so straightforward, Your Lordship. When 4 personal guarantees are produced, out of which 3 are electronically copy-pasted signature, which the claimant's expert also agrees anybody could have done that. And it's a very simple process using any software. Sorry.
You just be slower. You're getting excited. A bit slower, please.
This is the strongest point in the case, Your Lordship. So, and I have to raise my voice also because she's not able to hear. It's not that I'm being rude, but unfortunately that's the way it is.
Okay.
So it's not straightforward, Your Lordship, when there are 4 personal guarantees relied upon, and out of which 3 are electronically copy-pasted signature, that too only on the last page. The only other one, the 2013 personal guarantee also, the signature on the last page. Printing is different. I'll take Your Lordship through the expert report, the claimant's expert first report, after I go through the pleading, the skeleton arguments presented by the claimant. Then it stated that the debts that are owed by NMC to the claimant are not contested. That's the second sentence. Are not contested. Who has to contest, Your Lordship? The borrower has to contest. The personal guarantors will have no means to contest this. It's a common ground that after the year 2017, the defendant had not been involved in the management of the companies because the defendant stepped down from his position as CEO from 2017. The defendant is neither in a position to say whether it is correct nor in a position to say if it is wrong. It's up to the claimant to prove its case And if at all somebody has to contest, it is the borrower who should have contested. When the claimant approached the Dubai court with this case, it was dismissed, but was for want of jurisdiction. I'm 100% sure nothing was admitted. Everything was contested by the borrower also. So after that, what steps did the claimant take to prove the liability of the borrower? What are they trying to extract claim from the personal guarantor? Only the amount which is due from the borrower. A simple statement of account, self-serving document is insufficient, Your Lordship. In a claim of $130 million, that to two different companies which have no connection. And then they are trying to show only the statement of account and saying that this is proven not contested. They say in their document, further in the same paragraph or another place, they submitted a proof of debt to the ADGM administrative authorities. What happened after that? Was any amount recovered from that? We have no idea. And as a personal guarantor, defendant who has no access to these documents cannot be asked to prove these matters, Your Lordship.
Well, can I interrupt you for a second? Looking at the case memorandum, the case memorandum, the issues of fact in dispute do not include any issue about the amount claimed, the amount due from NMC under the various agreements.
Now, I'm looking at a statement in the skeleton argument where saying it is not contested. And I'm only explaining who has to contest that.
No, my point is that the case memorandum identifies the issues of fact in dispute. And one of the, nowhere is there an issue about the amount owing under the various finance documents.
Please bear with me, Your Lordship. I'll be going through those issues on fact one by one. It's coming.
Okay.
Second thing, the terms of the personal guarantees by which the defendant guaranteed immediate repayment of NMC and modular's debts are clear, and it is not contested that if they are valid documents, they would require defendant to make payment of the sums claimed if they are valid documents. Still, we had contested the legal grounds. Some of the legal grounds which we contested today, which we raised, has been struck off for the time being. This is a different issue, but it is contested, Your Lordship. Now, the principal defense raised by the defendant is that his signatures were forged by an unknown individual that is not therefore bound by the personal guarantee. This is true. It is forged by unknown individuals, and we have also stated the possibility of someone from the borrower's office itself forging it cannot be ruled out. We are not saying that the bank has forged it. The bank has definitely facilitated it, which I will establish while I cross-examine the witnesses of the bank, I mean the claimant's witnesses. They did not follow the compliance. They did not follow the procedures. They did not insist on original signatures. They did not verify the signatures. They facilitated the fraud, definitely. But the fraud could have been committed by anybody, and the fraud, we are not in a position to prove the fraud. I can only say that these documents are forged, as we have raised that contention, Your Lordship. So it is stated that defense is neither supported in fact, evidence, nor the evidence, expert evidence, and should be dismissed. I can explain it very clearly, how it is supported in evidence, how it is supported by the expert testimony. I will take Your Lordships through that. I'll only refer to one expert report. That's the claimant's expert report, which is the first one, after I skim through the skeleton arguments of the claimant, Your Lordship. Now, paragraph number 7, Your Lordship. It is common ground that the defendant was the founder and held the position of CEO of the NMC Group until 2017. So only until 2017. After 2017, the claimant has admitted that the defendant stepped down from that position and is not holding that position anymore. Paragraph 9, Your Lordship. It refers to modular facility agreement. There is absolutely no connection between modular as a company and NMC. I don't understand why these two cases are clubbed into one and pleaded before the court in one case. When they approached the Dubai court, these were two different cases. Now they have been combined in one case. I don't know what is the reason. No explanation is given for that. Plus, only connection which is stated is that one individual, Mr. Kukkinadi Pradeep Kumar, who is a relative of the defendant. Just by being a relative, is that enough to combine the two cases? I don't understand. Plus, there is no connection, there is no common shareholding. No shareholder of NMC is a shareholder in Modula. There is no other connection, nothing is even pleaded. Forget about being proven. And in paragraph 10, in addition to the personal guarantees, the borrower's obligations under the NMC facility agreements were guaranteed by certain subsidiaries of NMC, as set out in Annex 1 of the particulars of claim. No evidence, nothing has been produced before the expert. If they wanted to prove the signature of the defendant, they should have produced these documents for verification before the expert. Again, I repeat, the burden of proof is heavily on them. They should have taken that step. The claimant should have taken that step. The defendant can only deny. The claimant, paragraph number 12, Your Lordship, second sentence, the claimant requested payment from NMC on multiple occasions and issued formal notices to the claimant and the defendant. To the claimant and the defendant may be wrong, maybe to the borrowers and the defendant. On 11th February 2020, 27th February 2020, and 17th March 2021, requesting payment. It has come out in the evidence, the witness testimony of the claimant's people, that they were very well aware that the defendant was not in the country at that moment, he was in India. So serving those papers in an address where he is not...
Which paragraph were you referring to?
Paragraph 12, Your Lordship.
12.
The dates are in the...
Sorry, yes, I've got it, okay. Thank you, sorry.
Yes, Your Lordship. So those letters or notices, whatever they call it as formal notices, were never received by the defendant. Here they say that on 27 September 2020, Richard Fleming and Ben Cairns of Alvarez Marcel were appointed as joint administrators over certain NMC group companies, including NMC and the corporate guarantors in the Abu Dhabi global market. The claimant submitted its proof of debt against NMC and the corporate guarantors in the administration. The outstanding debts have not been satisfied through the administration, and the defendant is not subject to the administration. Here it is a denial, has not been satisfied. But this is a denial which I can ask for proof, because they can bring a document confirming that the debt has not been satisfied from the ADGM administrators, where the defendant has no access. The defendant is not managing the company. So they should have taken that steps to show that what was the proof of debt submitted and what was the outcome. Even if it's, as a matter of argument, 1 dirham difference also, it makes a difference, Your Lordship. Any personal guarantor is liable to pay to the lender only that amount which is strictly outstanding from the borrower, nothing more, not a penny more than that. So proving the debt, I don't even have to plead. It's a basic requirement that they should have met. Now, NMC made various drawdowns under NMC facility agreement and is indebted to the claimant and to the NMC facility agreements in the principal amount of $24 million owed under the 2012. It goes on, 30 million under 2030, 50 million under 2019. No proofs, Your Lordship. It's all just statements. No proof has been adduced to prove. They could have got an expert appointed, a banking expert, accounting expert appointed to prove that these are the amounts outstanding and due from NMC. If at all they wanted to avoid completely suing NMC or Modula and catch the personal guarantor alone, they had this duty heavily on them. They should have taken independent expert witness to prove what is the outstanding amount when they very well knew that the personal guarantor, the defendant herein, is no more in control of affairs of the borrower since 2017. We are talking about 7 years back. So they should have first taken the step. It's common sense that first prove the borrower's liability before you go against the guarantor, unless you are suing the borrower and the guarantor together. Then we can say borrowers and guarantors liability is joint and several. If the borrower is unable to dispute or discredit the claim made against the borrower, the personal guarantor may also suffer. But here, choosing not to sue the borrower and choosing to sue only the personal guarantor, making him a scapegoat, then they had the duty to first prove the liabilities of the borrower. Here it is stated that on this paragraph number 15, Your Lordship, The claimant sent Modular and the defendant notices on 11th March 2020, 31st March 2020, 3rd June 2020. None of them were received because the defendant was not residing in UAE. This is a fact well known to the claimant, and the claimant's man, Mr. Vikas Sharma, had met the defendant in Bangalore at Taj Hotel in March 2020. So they were very well aware of it. And then sending notices in an address which is all closed, there's no point at all. They know that these notices will not be served. Again, about Modular, paragraph 16, the indebted to the claimant in the sum of $11.8 million. No independent evidence produced, no independent evidence, no expert report, no accounting expert's report presented before the Honorable Court. Then paragraph 17 says, it is not in dispute that NMC and Modular are indebted to the claimant pursuant to the NMC facility agreements and Modular facility agreement. It's all in dispute. The claimant, the defendant had clearly stated, I'm not even aware of any facilities being granted to these companies. What more? Is not just denying what is the outstanding. I'm not even aware of any facilities being granted to these companies is the clear statement in the statement of defense and also in the witness statement of the defendant himself. This is paragraph 17, Your Lordship.
Yes.
Paragraph 18. They just state the defendant is liable pursuant to the NMC personal guarantees and the Modular personal guarantee to immediately repay the above sum. No, only if it is proven what exactly is the outstanding liability of the borrower and then prove that the personal guarantees are properly signed, executed, accepted by the defendant, then only, not just being liable like that. The defendant is further liable to indemnify the claimant for his costs, losses, liabilities suffered only if the signatures are proven and it is confirmed that he has willingly accepted to be a personal guarantor. Indeed, the defendant directly and expressly acknowledged his liabilities under the personal guarantees to Mr. Sharma of the claimant in March 2020. It is denied by the defendant in the witness statement and he is subject to cross-examination. Only thing which Mr. Sharma said was there was about something like 48 million outstanding from NMC and the defendant made a phone call to one Mr. Suresh Kumar in NMC asking him what is this, if there is any outstanding, why are you not doing something about it? That's
Could
all.
you please slow down a little bit, Sarah? I can't catch all your words. Thank you.
You're getting faster and faster.
Sorry, I'll take some water. Sorry, madam. So this is Mr. Vikas Sharma's testimony is the only thing which they are producing. Absolutely no documentary evidence. This was a lunch meeting at Taj Hotel in Bangalore. The meeting the defendant is not hiding from. It happened in Taj. And there he said there are amounts outstanding and due from NMC to ICICI. The defendant made a phone call to the CFO, who is Mr. Suresh Kumar. Though he was not in management, he was not in control, he was not the CEO anymore. It was just a courtesy meeting and a courtesy call. And afterwards, they are saying that by a WhatsApp message, it was nothing is stated in the WhatsApp message which they produced. Who was the person who accompanied you? And when you came to discuss the NMC account, that's all. Nothing about the master facility agreement, not a word about the personal guarantee. It's all overstretching it beyond any imagination. Now, coming to NMC Personal Guarantee 1, I'll be going a little more detail when I'm taking your lordship through the first expert report of Ms. Radley, the claimant's expert. Here, this document is clearly stated that it is a copy-paste signature. No documents have been produced.
Sorry, I missed the beginning. Which document are you talking about now?
NMC Personal Guarantee 1. This is paragraph 19.
Of the skeleton.
Skeleton arguments, you know.
Yeah, okay.
So this document, it's a copy-paste signature. There is no document, no evidence produced by the claimant to say that the defendant had accepted for giving or using electronic signatures. It never happened. So even the expert has stated that anybody could have copied and pasted. It's very simple. So that's not the way. This is where the compliance issues also come, which I reserve for cross-examining the bank's officers. What was the compliance procedure they did? Normally, I've been a banker's lawyer. I've represented 17 banks continuously for 20 years. I've never seen a personal guarantee, especially to this magnitude, where the signature is not verified by a bank's officer. signature on all pages, stamp on all pages, sometimes letterhead also used, and at least on the last page, a round stamp is put by the bank's officer with his reference number verified, signed before me. This is how documents are properly executed. If they have not done this, even the compliance procedure which they narrated, the witnesses have narrated in their witness testimony, that has not been followed. The fraud, I don't know where it happened. Even if it has happened in NMC's offices, this failure to comply with the due procedure, it facilitated the fraud. That's the submission there, Your Lordship. So personal guarantee 1 cannot even be looked into. I will take Your Lordship to the expert report after submitting about the claimant skeleton arguments. Personal guarantee 2, again, the same situation, Your Lordship. Copy-paste signature. Anybody could have done it. As a matter of fact, Your Lordship, even the specimen signature for opening the account, this is C12 in the documents between the expert examined. Even that document was a copy-paste signature, Your Lordship. What is the purpose of having a specimen signature in the bank? It should be signed specifically by the defendant himself if his signature is kept as a specimen signature, and most preferably at the bank's office in front of the manager, or the concerned manager visits the person in his office and he verifies the signature just by copy pasting, putting a signature there. And then the 2012 guarantee and the 2019 guarantee, identical signatures, Your Lordship. Identical signatures, 7 years, because it's a copy paste everywhere. Now, NMC Personal Guarantee 3, this is the 2019, again the same issue, copy paste signature. There is only one personal guarantee, which is a 2013 personal guarantee, which carries a signature in pen and ink. And I will explain that, Your Lordship, when I come through the expert report. And if we say paragraph 23, and this is where, Your Lordship, paragraph 22, it is stated, sorry, I'm going one step above. The NMC personal guarantees are to remain in full force and effect until full performance of payment. And if Your Lordship look at the NMC personal guarantees, there is a reference to Article 1092 of UAE Federal Law number 5 of 1985 concerning civil transactions. All the 3 NMC personal guarantees contains a reference to Article 1092. This particular reference and clause which says that this particular guarantee is issued for a commercial purpose, and hence Article 1092, which is referred there, is not applicable in terms of limitation period is stated in those personal guarantees. Why I am raising this as an issue is that the Dubai Court of Cassation and Abu Dhabi Supreme Court has time and again decided that if at all this reference to Article 1092 and confirming that since this being a commercial document, Article 1092 is not applicable there, then the claim against the guarantor is barred by the period of limitation 6 months from the date when the amount becomes due for payment. So NMC guarantees contain that saving clause. Modular guarantee does not contain that clause. So this is why I was referring that legal issue in the skeleton argument. I did not import Article 1092 from nowhere, Your Lordship. It is the governing law of the guarantee. It is in the guarantee that article is referred to. So I cannot even consider this as a foreign law. So limitation period applies here. And we give a judgment in accordance with UAE law, the governing law. We cannot go illegal, Your Lordship.
Mr. Shaheen, I've already ruled that you can't run that point.
No, I'm not pressing that. I have to bring it back again. Here, the reference to 1092 is in this guarantees is what I'm saying.
Which paragraph is this?
This is paragraph number 22 says, are to remain in full force and effect until performance, all the NMC personal guarantees. This is the problem because if it has to remain, this article 1092 reference should be there in the guarantee, which is there in the NMC personal guarantees, but conspicuously missing in the modular guarantee. This is what I'm raising here, Your Lordship. Now, breach of NMC.
It's my fault. I don't understand this. If you can't raise these issues on time bar, what does it matter whether there's a reference there or not?
See, I'm only saying they have raised an assertion saying that it is to remain in full force and effect. It is in their pleadings, sir.
Yes,
Since in their pleadings, I have a right to examine whether what they're saying is correct or not. This is in the skeleton argument.
of course.
So this remaining in full force and effect is based on Article 1092. They are saying only about NMC personal guarantees here in paragraph 22. They did not mention this here. Modular is not referred to. So I'm giving the explanation to what they have stated. The modular guarantee does not contain that saving clause.
Yeah.
Again, paragraph 23.
So, sorry, what is the relevance of that? I'm trying to get my head around this. What is the relevance of the fact that the modular guarantee does not contain that clause?
It is the Supreme Court of UAE in interpreting Article 102 and UAE law have time and again decided that if you don't have the saving clause in the body of the guarantee itself, the guarantee will be invalid after 6 months.
Yes, so you are trying to say the modular guarantee is invalid after 6 months.
Modular guarantee is barred by limitation is the inference from what they have stated here.
Well, I've ruled that you can't run that point because it's not pleaded. So
it's a question of law. I'm going by what they have stated. I'm examining the veracity of their statements in their skeleton arguments, Your Lordship.
Okay, but all I can say is that I've ruled on this point. You need to amend. You can't amend, and you can't run a time bar.
I respect that decision, and as of today, the defendant is in that stage, doesn't have that financial liquidity in order to support a deposit or a personal guarantee. So okay. I'm denied that opportunity because of that. Now, breach of the NMC personal guarantee. In breach of the NMC personal guarantee, the defendant failed to pay the outstanding sums due owing under the NMC facility agreements. These statements would stand good only if those liabilities are proven and the NMC guarantees are valid and enforceable. Questions are plenty of questions. Now, paragraph number 24 refers to modular personal guarantee. My submission is it's a forged document. It's a copy paste. Nobody signed it physically. Breach of the modular, same argument, failed to pay. First, there should be an obligation to pay. And obligation to pay depends on the borrower being liable, proven liable or admittedly liable. Neither of the cases here. First, the borrower's liability either admitted or proven, nothing happened. And second, the personal guarantee remaining valid. The questions are all out. So there is no failure when there is no obligation. Here it is stated that paragraph 27, the claimant commenced proceedings against NMC, the NMC corporate guarantors, and the defendant in Dubai Court of First Instance in April 2020. Next paragraph, paragraph 28 of the skeleton, is page number 10.
Sir, I kindly request you slow down a little bit because the audio is unclear. I need you to speak a little bit more slowly, please. Thank you.
Thank you, madam. The claimant commenced proceedings against NMC, the NMC corporate guarantors, and the defendant in Dubai Court of First Instance in April 2020. The case number is also given in paragraph 27. A separate case was filed in June 2020 at a different time, and the case number is 718 of 2020, whereas the previous one was 20 of 2020. Both the claims were dismissed for lack of jurisdiction. At that time, the choice was to sue the borrowers and the guarantor together. Afterwards, they have chosen to sue only the guarantor here. That is why I say they should have proven the liability of the borrower before choosing to sue the guarantor alone, which they have failed to do. Now coming to the issues of fact in dispute, Your Lordship. Paragraph number 29.
Hold on a second.
My lord, I don't know if I can just interject. I don't want to interrupt Mr. Shaheen at all. I feel bad for doing so, but he's repeatedly saying that the claimant has to prove the amounts are due from NMC. But ground 8, which you have ruled he's shut out from pursuing, is this argument.
Which is ground 8?
Ground 8 is so paragraph 55 to 57 of my learned friend's skeleton argument, which you ruled he was not allowed to pursue.
Well, what I was meaning to rule out was that basically what I ruled was that he couldn't amend in respect of the paragraphs of the matters covered by articles by defences as a rule you couldn't amend in respect of the matters covered by ground 5 to 10. Now, if he has a challenge in his pleadings to the amount of the debt, then it's there. If he doesn't have one, it's not there.
He doesn't, and it was common ground that the amounts under the list of common issues were lent, and the claimant's claim is what it is.
Where
And
was
there's no
that?
dispute on the pleadings as to the amount claimed.
Where was the wait? Sorry, where was the? Can you give me a reference to it being common ground?
So the list of issues of common ground is at 778 bundle.
Yeah. Hold on a second. Sorry, Mr. Shaheen, I'm just going to hear this point and then I'll come back to you. 778.
So the bottom of the page, the common ground between the parties.
Hold on. So many bits of paper. This was the case management order, was it?
Yes, I think for some reason only the draft list of common ground and issues been included in the bundle. I believe this was reflective of the final one that was agreed. And in respect to the facility agreements, it's common ground that paragraphs 9 to 11, the facility agreements were entered into, and the claimant's claims are a total of 104 million and 11 million under the modular and NMC facilities, and then issues of fact in dispute. There's nothing in there as to what is owed by NMC to the claimant, so it's not an issue of fact and dispute.
May I submit, Your Lordship?
In a moment, Mr. Shaheen, I just want to hear this and then I'll hear you. Is there anything anywhere saying it's not in dispute, as opposed to not saying it's in dispute?
I'd have to specifically in their defense that says that we do not dispute the debt that's owed.
That's right, is it? In the defense?
I'd have to double check exactly what's said in the defense.
Right. Do you want to do that and come back to me?
Yes.
Do you want to do it now? If someone got the reference for you? It's useful to know where we stand on this. Statement of defense.
To continue in the meantime, Your Lordship?
Just give me 1 second, Mr. Shaheen. Otherwise, I'll be thinking of. I won't be listening to you properly if I'm still thinking of this one.
The defense is at 53. Of the
Yeah,
bundle.
I've got the defense.
I think paragraph 5 of the particulars of claim sets out the various facility agreements. And the response to that is at paragraph 15 of the defense. There he says allegations pleaded at 5.1 are against NMC, therefore contents are not admitted and are merely noted.
Yeah. That's the closest you get, is it?
It's, yeah, and it's not when the issue of facts, and I've already taken to you the issues of common ground and the indebtedness to NMC is one of those issues.
But where is the issue? Where is it said to be common ground?
The common ground is that the facility agreements were entered into, and that is the claimant's claims under them.
Yeah.
But anyway, in specific to, it's not an issue of fact and dispute. It's something that they've noted. It's never been a point, as I say, is that this was the new ground 8 that was advanced that Mr. Shaheen's been told he cannot advance.
Yes. Well, I think you've got to be careful about my ruling this morning. My ruling this morning was that he couldn't amend. Anything further was a gloss on that. And if it turns out that he doesn't need to amend, then he can run the point there. My focus of my point was he couldn't run the points of UAE law in 5 to 10. If I wasn't meaning to say that if he's already allowed to run a certain point, then I deny him that opportunity. I'm not going to do that.
Understood, my lord. We would have a number of submissions to be honest, but
of course, yeah.
Carry on.
Mr. Shaheen, sorry to interrupt your flow.
I'm also sorry to interrupt, but we've gone to over 90 minutes, and I need to request at least a 5-minute break to get a glass of water.
You want 10 minutes?
That would be great. Thank you very much.
We'll have 10 minutes.
Can I just start this point and go to the next one, because since we are on the point of this one, whether this liability of the borrower has been admitted or not, and my learned friend saying it's a common ground, can I just show it's not common ground?
Let's do that when the transcriber comes back.
Yes, sir.
Thank you. 10 minutes. Are we all here?
Yes, your lordship.
Is the transcriber here?
Yes, sir.
Yes, yeah. Okay, Mr. Shaheen.
Yes, your lordship. First of all, the common ground, the page number 779, your lordship.
Yeah.
The reference made to facility agreements and paragraph 9. The claimant and NMC entered into the NMC facility agreements, pursuant to which the claimant claims. The wording uses the claimant claims, not that the defendant admits. Okay, yes. A total of this amount plus interest. Again, paragraph 10, the same language, claimant claims. These are not admissions, your lordship. It's just noting what is the claim. And coming to the statement of defense submitted before the Honorable Court, in reply to the claimant's particulars of claim of 10th May, it is stated in paragraph 4.3. What is the case when my learned friend?
Hold on.
Page number 54.
Sorry. Yeah.
Even my learned friend during his submission mentioned that the case of Dr. Shetty is completely unaware of the facilities. So where is the question of admitted liabilities then? The facilities itself he is saying he is unaware, and is pleaded 4.3 for page number 54 in the hearing bundle. Further, at the time of this defense, Mr. Shetty is unable to plead as to the authenticity and veracity of the NMC facility agreements and modular facility agreement, and also as to how and where the money is drawn down from the facilities were applied. Safe to say that to the best of Mr. Shetty's knowledge and understanding, he was not involved vis-a-vis any such facilities monies, and those monies were not misapplied by or at the direction of Mr. Shetty. Then on paragraph number 5, Mr. Shetty was completely unaware of the current claim. So he has clearly disputed that this claim, he is not aware of anything. Then background to the NMC facility agreements, paragraph 15 in page number 56, which my learned friend cited, allegations pleaded in paragraph 5.1. 5.1 in the state particulars of claim is related to the facility agreements outstanding claim what was given. Paragraph 5.1 are against NMC, therefore the contents are not admitted and are merely noted. Because we are not in a position to dispute or admit it, we can only note it because we are not the borrowers. Now, paragraph number 25 in page number 57, NMC facility agreements is a title 2012 working capital financing. The last three paragraphs. Therefore, Mr. Shetty shall neither be bound by the terms of the above mentioned document nor be bound by the terms of the NMC personal guarantor. Hence, Mr. Shetty is not liable for the relief that the claimant seeks in this claim. Then paragraph number 28, the contents of paragraph 25 to 28 are against NMC. The same are not accepted and merely noted. Paragraph number 30, the contents of paragraphs 31 to 33 are against NMC and are not accepted and merely noted. Paragraph number 31 concludes, therefore, Mr. Shetty cannot be bound by the terms of the facilities available by every word there is a denial, Your Lordship. And paragraph 41 regarding modular also. The contents in paragraph 46 and 47 are against modular and therefore not accepted and merely noted. Then paragraph number 42, the contents of paragraph 48 are denied. Then paragraph number 45, page number 60, the contents of paragraph 50 are against modular. The same is not accepted and is merely noted. Paragraph number 47, the contents of paragraph 52 to 55 are against modular. The same are not accepted.
Yes.
Paragraph number 49, the same thing, Your Lordship. So time and again, several times it has been denied. So it's definitely in dispute. What is the amount due from the borrower? What is the amount sanctioned to the borrower? How the money was utilized by the borrower? How does Dr. Shetty be liable, even assuming without admitting that there is one personal guarantee, without the borrower's liability being proven? No steps were taken by the claimant. That's my humble submission, Your Lordship. Now, issues of fact in dispute. Paragraph 29 of the skeleton arguments presented by the claimant. 29.1. Whether the signatures of the defendant on the NMC personal guarantees and the modular personal guarantee and or any other document on which the claimant relies are genuine and authentic signatures of the defendant, or whether the signatures were forged by an individual other than the defendant. The definite case of the defendant that it is forged, and at least 3 out of 4 personal guarantees have been proven, copy pasted. Even the claimant's expert has stated that it could have been done by anybody else. And St. Petersburg case we have produced saying that it's not for the defendant to prove that it is indeed forged. The basics are established. Now 29.2, whether Mr. Shetty's signature has been digitally copied and pasted. No statement about electronic signatures was ever there, Your Lordship. Whether it is copied and pasted, that was our contention, might have been copied and pasted. And their contention was it was all genuine signature. Now it is proven beyond any doubt and it's admitted they are digitally copied and pasted majority of the documents. 29.3, whether if the signatures are found not to be the defendant's authentic signature, not to be of defendant's authentic signature. Authentic signature here means in pen and ink, authentic signature. Did the defendant authorize another individual to sign on his behalf? No, admittedly no. No evidence has been forthcoming before this honorable court to show that the defendant authorized somebody to copy and paste his signature. Nothing has been produced before the honorable court. 29.4. Who allegedly forged the signatures on the NMC personal guarantees and modular personal guarantee? It is not for the defendant to prove. The defendant can only deny. Suppose I say this is a judgment issued by your lordship, and if the judgment was not issued by your lordship, is it the obligation of your lordship to prove who signed, who put the signature of your lordship on that paper? It's never. Somebody might have put. Your lordship can only say, I did not sign this judgment. It is not mine.
You're getting faster and faster.
Sorry. So if I deny my signature on a document, I cannot prove out of the 8 billion people in this world who signed, who forged my signature. I can only say, your lordship, it's not mine. I did not sign. So that question 29.4 issue doesn't arise for consideration. It's not for the defendant to prove. If it's a criminal case, the prosecutor will have to take steps to prove it. 29.5, when did the defendant become aware of the claimant's claim for repayment under the NMC personal guarantees and the modular personal guarantee? It's not a very material point, but what the defendant says is that only when he received the particulars of claim from this honorable court in April 2023. This is his statement. I'm only repeating his statement here. Whether the defendant received the demand letters issued by the claimant on 11 February 2020, 27 February 2020, 31 March 2020, the answer is a denial. No, nothing has been produced to prove that it was indeed delivered to him. 29.7. Whether Mr. Shetty was involved in the day-to-day management of the NMC Group and Modular between 2017 and February 2020. It's an admitted fact now. Beyond 2017, Dr. Shetty was never involved in the day-to-day management of NMC. And Modular is coming in between here. Modular, he doesn't even know what is this company, no connection at all. He's never been involved.
My lord, that isn't an admitted fact.
I didn't get you.
Sorry, what's not an admitted fact?
It isn't an admitted fact that Mr. Shetty had nothing to do with NMC from 2017 onwards. It's an agreed fact that Mr. Shetty stood down as CEO in 2017, but as we'll see in the evidence, Mr. Shetty continued to be heavily involved in the group from 2017.
It's not that the wording is day-to-day management. He was never involved in the day-to-day management after 2017. I can take the witness statements given by the claimant himself.
You can deal with this in evidence.
I will handle it at the cross-examination stage. Whether any individual from the claimant verified the signature of the defendant on the NMC personal guarantees and modular personal guarantees. This was a requirement, a verification. Such fraud would not have happened. Failing to verify. Nobody ever stated that it is verified. There are some signatures here and there. Those people are not even examined as witnesses before the Honorable Court. No witness statement is produced by people like Seema Singh and other people. I've seen some names on those guarantees. None of them are examined. Even those witnesses like Prashant Mangad or Suresh Kumar, who signed as witnesses, are not cited as witnesses there to prove why Dr. Shetty signed there. So no steps have been taken. Who negotiated the NMC facility agreements, the modular facility agreement, the NMC personal guarantees, and the modular personal guarantee on behalf of NMC and modular? We have 4 or 5 witness statements coming from the claimant. Nobody ever said it was Mr. Shetty, the defendant, who negotiated any of these documents. Even the email correspondence requiring Mr. Shetty's signature on a personal guarantee supposed to have been given by him. No email is even copied to him. Forget about being addressed to him. He is not in CC. They write to 10, 15 other people, but never to Dr. Shetty. Then 29.11, 29.10, who negotiated the NMC facility agreements, the modular facility agreement, the personal guarantees, and the modular personal guarantee on same issue? Nobody. Not Dr. Shetty, somebody else. Dr. Shetty doesn't know. He's not aware.
It says on behalf of the claimant.
Yes, on behalf of the claimant, we don't know, because the defendant said he's not aware. So who negotiated on behalf of the claimant? The witness statements are saying, but they negotiated with somebody else, not with the defendant, never with the defendant. And that's also admitted in the witness statement. 29.11, whether Mr. Shetty knows who negotiated the alleged NMC facility agreements and modular facility agreements. No, he doesn't know. He has stated he has no idea about these facilities. 29.12, whether Mr. Shetty knows how and where money is drawn down from the NMC facility agreements or modular facility agreements were applied. He has clearly stated in the statement of defense that he doesn't know. No steps were taken to prove that he was aware, or no steps were taken to prove where it was applied. Where did this money go? No steps were taken by the claimant. 29.13, whether any meetings took place in person between any representatives of the claimant and the defendant with regards to the NMC personal guarantees and modular personal guarantee. The answer is never. One meeting Mr. Vikas Sharma had with Dr. Shetty in March 2020 in a hotel, a courtesy meeting. No mention about personal guarantee is what the defendant has mentioned in his own witness statement. Now the last two, 29.14, whether Mr. Shetty was aware of these proceedings prior to being served with the particulars of claim on 19 April 2023. There is a clear denial by Dr. Shetty. He said, I was aware of it only in April 2023 when I received the particulars of claim from the court. 29.15, what compliance steps did the claimant take in respect of the drawdowns made by NMC and Modular? I would say completely failed, no compliance, absolutely negligent, facilitated wrongdoings by others. This is what happened in the case, which I will bring out during the cross-examination of the witnesses cited by the claimant. Now, about the disclosure, the statement that the claimant produced 500 documents and defendant did not produce any documents, I don't buy it, Your Lordship. There are documents produced by the defendant also in this case. And even if 500 or 5,000, when the signature are denied, the execution is denied, they ought to have produced those documents, whatever they want to rely on, to the experts, two experts, claimant's expert and the defendant's expert. Only 13 documents were produced, so we can only rely on those 13 documents depending on the findings of the expert, which I'll take Your Lordship through. Now here, the defendant objected to each of the claimant's requests, paragraph number 31, in the Redfern schedule, all of which relate directly to the facts and issue in dispute, including following requests. Just to bring your attention to Your Lordship, what is the nature of these requests, Your Lordship? Request 2, documentation and or correspondence evidencing the defendant's whereabouts on the dates the personal guarantees and their respective letters of continuation were signed. How does it help, Your Lordship? Even if the defendant was somewhere else in the world, does it mean that he could not have signed? So it's not a criminal case of alibi defense which is being taken. It's not that I'm saying I was elsewhere. There's no such defense taken. Why is this documents required? Why am I asked to produce these documents? Absolutely irrelevant. No adverse inference, nothing is possible based on, even if it is produced, it's not helpful in the case. It's just a waste of time, Your Lordship. So request 3, 31.1.2, Your Lordship. All correspondence.
Sir, could you slow down a little bit, please, so I can get what you're saying?
31.1.2, request 3. All correspondence in the defendant's personal or work mailboxes, including but not limited to the mailboxes, 2 mailboxes are mentioned, relating to the claimant, the NMC facility agreements, the modular facility agreement, and or the personal guarantees from the calendar months during which the personal guarantees and continuation letters were issued. If at all the claimant has a case that something the claimant has sent it to the defendant, the claimant ought to have produced it. It's not obliging the other party to prove your case. This is not a reasonable request at all. All correspondence already stated, I don't know. I am not aware of these facilities. I have not received any communication until April 2023. How do they expect me to produce all the correspondence? There are no correspondence copied. Nothing is produced before the Honorable Court by the claimant either. Request 4, any documents correspondence evidencing the defendant's involvement in the management of the NMC group between 2017 and February 2020. Here, Your Lordship, if at all they had a proof, if at all they could establish that beyond 2017, the defendant was involved in the management, day-to-day management of NMC, why should they ask this question to me? It was their duty to prove if they are alleging that. 2017, he stepped down from the position of CEO. He stopped getting involved in the day-to-day management. He stopped signing any documents. It's specifically pleaded. You're asking
a bit slower, please.
Yes, sir. So the claimant is asking, in a way, self-incriminating evidence because of the claimant's failure to prove its case. It's expects the defendant to prove the claimant's case, which is obnoxious to common sense. I don't accept this kind of a request coming from anybody. So that is why the objections were raised. It's not that they asked for 500 documents and we failed to produce. This is the nature. I'm taking this from the claimant's skeleton arguments, Your Lordship, not my submissions. This is the nature of requests made. Now, again, the paragraph number 31.2, the defendant's disclosed documents do not prove one way or other whether the defendant signed the personal guarantee. Is it for the defendant to prove? The burden of proof is heavily on the claimant. It doesn't, how can I prove the negative? Again, I'm repeating the same question, Your Lordship. Now coming to paragraph 32, the lawyer's letter, 4th April 2024. There was a discussion, 150,000 emails, who's going to scrutinize all that and why should the defendant do that even? It's not for the defendant to prove the claimant's case. But we tried to cooperate with them. Submissions, we were taking some days, but the trial was fixed during July, and then it did not happen. Finally, the parties did not, paragraph number 33, claimant skeleton argument. The parties did not agree any alternative scope of timetable for the defendant to disclose additional documents, and the defendant therefore filed the objections on 5th April 2024. Whatever I had to say, it's already stated there, Your Lordship. Paragraph 34. Considering
Mr. Shaheen, if we go through each paragraph of this document, you reading it and then commenting on it, we're going to be here all afternoon without getting any witnesses.
I have to at least be allowed to plead my case, Your Lordship.
Yes,
several
please.
of my defenses have been struck off. So
as I've said, hold on. As I've said already to Mr. Lakin, you both agreed that 1 hour would be enough for each of your openings. He has been longer than that. You're going to be longer than that.
I will try to be as short as possible, Your Lordship. I don't want to tit for tat, but I'll try my best to be as brief as possible.
But we might have to cut down the witness evidence if you're too long.
I'll try to cut it short, Your Lordship.
Okay.
Paragraph 35, I skipped one paragraph or two in between. So here about the claimant's solicitors writing to administrators, solicitors, they did not give the documents. They said to identify whether there was any evidence from the defendant's email inboxes to confirm that the defendant executed the personal guarantees and the continuation amendment letters thereto. So if the claimant had proof to show that the defendant indeed executed the personal guarantee and the amendments thereto, why are they asking somebody else for these documents? So they have not produced any documents to prove this, and they could not get any of these documents from them. They also answered 11,900 documents with families. This is what they found, and they did not produce anything. Now, the fact witness evidence, Your Lordship, Mr. Vikas Sharma, he's the only person who claimed to have met Dr. Shetty as a person. None of the other witnesses. Nobody, including Vikas Sharma, nobody says that I saw him signing. Nobody is stating that. Only thing which is denied in Mr. Vikas Sharma's testimony are 2 points. One is he was meeting Mr. Shetty regularly every year. Mr. Shetty denied that. No evidence. See, for a person like Mr. Shetty at that time, running an empire of $12.5 billion of turnover, to take an appointment, how many emails would have been required? Nothing, not to fix the meeting, no minutes of meeting, nothing has been produced. It's just an allegation and it is denied. Again, the person who's asserting, he has the burden of proof, he has to prove it. Mr. Sharma did meet once, that is Dr. Shetty, in Bangalore, a courtesy meeting. In between, when Mr. Shetty was having social meetings or gatherings with the CEO of the bank, who happened to be his friend, no discussions were about business or anything else there. Dinner meeting, maybe Mr. Sharma was present in one of those gatherings. Other than that, Mr. Shetty said he has never met Mr. Vikas Sharma. No telephone call, nothing other than that. So the two assertions made by Mr. Vikas Sharma that Mr. Shetty confirmed that the claimant would receive the money that it was owed by NMC. No, he never did that. He only called the CFO and checked, what is this? Please look into it. That's all. Second thing, he confirmed that he had provided the personal guarantees. No, it is denied. There is no proof. All that is produced is a WhatsApp message. And the WhatsApp message is only about a slip of amount with respect to NMC account. It doesn't talk about MFA, doesn't talk about personal guarantee, doesn't talk about acknowledging a liability, nothing of that. So that's the only evidence produced. Then afterwards, if you look at the evidence of all the other people, Gaurav Juneja, Rohit Gupta, Nikhil Parekh, they are not testifying anything of their personal knowledge. He might have done, he would have known. There is no reason for me to believe that he may not know. These are all hearsay evidences, nothing concrete. They are not evidencing anything. Their witness testimony, even if I say no cross, it will be over. So nothing is proven in those witness statements, so I don't want to elaborate on all that. And expert report, Your Lordship, that's the only document which I may take a little time.
Yeah.
Before going into that, there are allegations that Mr. Shetty is accused in a case before ADGM. Even if he is accused, I don't know, I have not verified it. Even if he was accused, it's only an accusation. Everybody is presumed to be innocent until guilt is proven beyond any reasonable doubt. So it doesn't prove anything. Conspiracy alongside Mr. Prashant Mankad and Bank of Baroda. They're alleging, this is in paragraph number 55, Your Lordship. The claimant is alleging a conspiracy with other bank also, Bank of Baroda, and Mr. Prashant Mankad. There are a lot of criminal cases filed by Mr. Shetty against Mr. Prashant Mankad, who is at large, who is not in the country, who has fled from the country, his whereabouts are not known. So, here is one statement at the end of paragraph 55. It is in any event not necessary for the DIFC courts to make a finding one way or another as to whether a fraud took place within NMC and who perpetrated it, but simply to rule on whether the defendant is bound by and liable to repay the claimant pursuant to the personal guarantee. This I accept, Your Lordship. This is what I'm saying. It's neither for me nor for the Honorable Court to prove who perpetrated the fraud. Whoever has done it has done it.
I need you to slow down. I can't get your words.
Whoever has done it, and the bank was not diligent enough to prevent such forgery or fraud. That's the case here. And everywhere it is saying it is simply not plausible that he was unaware of NMC's main sources of finance and the significant liabilities. Some of the witnesses are saying, first of all, main sources of finance. It's too much to imagine that $130 million is a main source of finance for a company which has a turnover of $12.5 billion per year. Second thing, significant liabilities. No, this is not the significant liabilities. Even according to the Muddy Waters report, which the claimant produced, the liability was in billions. So 130 million will not constitute a significant liability or finance. It's not true. And they have mentioned about the Barclays Bank case, Your Lordship. First of all, these cases, Barclays Bank, and Your Lordship may remember we had the Bank of Baroda case and another case also. So only in Your Lordship's judgment in Bank of Baroda, it was stated that the signature falsification.
I'm sorry, sir, I can't carry on transcribing it. With the audio is, the quality is low that I can't hear what you're saying at this speed.
Mr. Shaheen, could you?
I'll be louder.
No.
It's not about the volume; it's the quality of the audio.
Even if Mr. Shaheen talks more slowly, is that possible?
Slowly is more possible, and I would very strongly request that we can get a new laptop for the next part of the hearing after the submission, after the opening statement. Thank you. But please slow down, sir, because I want to get the transcript.
Please bear with me. So these cases of Barclays Bank, Bank of Baroda, and other cases were by Punjab National Bank, where immediate judgments were given, Your Lordship. That's not something to be taken as a judicial precedent in a proper trial, because there was no proper trial conducted in any of those cases. It was for immediate judgment, first of all. And only in Your Lordship's judgment in Bank of Baroda, if I remember it right, it was clearly decided that the signature has not been admitted and there was an expert report. It has to go for trial. That was the case. And Barclays Bank case, initially there was a denial, but afterwards, maybe because of an expert report or something was confronted to Dr. Shetty, I did not handle this case. I inherited other cases, not this one. There, Dr. Shetty accepted his signature. If he is convinced that this was his signature, he was magnanimous enough to accept it. He never denied the truth. And that is why the judgment is given. But here he is vehemently denying. I did not sign any of these papers. He has stated that very clearly. And he is coming as a witness before the Honorable Court. And I hope he stays with that statement too. So I'm stopping the claimant's skeleton arguments, Your Lordship. Now, coming to the claimant's expert report, the first one. I'm not going to the second one. I'll only take Your Lordship through the important findings in the first one. If we look at page number 925, Your Lordship.
925.
Yes, Your Lordship.
Yeah.
Here there are question documents Q1 to Q13, Your Lordship.
Can I just interrupt for a moment? We've now got to the position that, according to the timetable, we should be halfway through the last witness today. That's Mr. Sharma, who was meant to start at 2 o'clock UK time. Are we going to get on to him?
He's waiting and ready to join.
Yes, but in practice, how long are you going to be, Mr. Shaheen?
For this arguments to conclude, Your Lordship?
Yes.
Maximum half an hour.
But this is hopeless. Sorry, it's not your fault entirely, because Mr. Lakin was exceeded his time as well. But what is the point of agreeing a document like this if it's unrealistic?
I didn't get the question, Your Lordship.
What is the point of agreeing that you will take 1 hour for opening submissions, and the same applies to the other side, if this is not realistic?
Two points I will say here, Your Lordship. Now the half an hour delay, it was not in my account, Your Lordship. That was the other side. Second, when I started, almost 15 to 25 minutes were gone. I was not talking at all. There were issues raised, other issues, and I was interrupted for 15 to 25 minutes at that time.
All right.
Sorry for that inconvenience, Your Lordship, but not intentional. So the Q1 to Q13 are the question documents, Your Lordship, and C1 to C14 are the documents presented by the claimant, and D1 to D16 are the documents produced by the defendant for examination. Yes. So D1 to D16, whatever is presented by the defendant, contain the admitted real signature. So if at all an expert wanted to verify the admitted signature, that is where she should have gone. Instead of going there, she depended mostly on C1 to C14. And among the C1 to C14, majority of the documents were copy-paste signature. So the surprise in this case is, Your Lordship, C12 Director's Certificate, which is actually a specimen signature to be kept in the bank for further verification. That itself is a copy-paste. So this is why Dr. Shetty is saying that I am not aware of these facilities. Even account opening at that stage, he was not involved. Somebody copy-pasted is the inference. So from Q1 to Q13, Your Lordship, Q1, they have noted it as noticed, but that is the personal guarantee in 2012. It's a copy-paste signature. So I'm discarding that document. Anybody could have copy-pasted. Dr. Shetty did not sign it. Second one, personal guarantee 2013, which I will elaborate, which is analyzed by the expert and which is analyzed by the defendant's expert also. I may say a few words about it. Q3, notice to guarantor, which is again the personal guarantee 2019. 2019 guarantee and 2012 guarantee contains the same copy-paste signature. And only thing that the claimant's expert is saying is about copy-paste signature. It appears that it is copied from a genuine signature of Dr. Shetty and pasted here. How does it add value, Your Lordship? Signatures are everywhere these days. We sign documents, we circulate documents. Anybody can copy my genuine signature and put it on another document. That doesn't bind me in any way at all, doesn't add any value. This finding, I don't know why it is even written there in the expert's report. The fact of the matter is it's copy pasted, anybody could have done it. Once a person denies that he did not do it, then it's up to the claimant relying on a copy paste signature to prove that it was indeed the defendant who did it. Or if they call it electronic signature, they have to prove that how does this qualify to be an electronic signature? Who did it? Not a single email produced, such documents originating from the defendant. Not a single email produced show that such emails were even copied to the defendant. So this is the state of affairs here. Starting from the specimen signature for opening the account, all these documents copy paste. And some documents in between, there are few documents, 5 or 6 documents are there, which bears the ink, pen and ink signature of Dr. Shetty. Some are continuation of guarantee, some are amendment to facility. These are 1 page, 2 pages document. Some of them don't even refer to the guarantee. Some refers, but I will explain all this after the
Please, I need
cross-examination.
you to slow down, sir. It's impossible to get everything you're saying with the bad quality audio and the speed of your speaking.
Okay, madam.
Keep it
So I will explain all this, the other documents which contains pen and ink signature after the cross-examination of the expert and the relevant witnesses. I don't want to disclose all those points now. There are shortcomings in those documents as well. The only personal guarantee which is said to be signed in pen and ink is the 2013 guarantee. And 2013 guarantee, the last page, page number 16, is in a different print. It's a security printing. I will take your lordship to that page in the expert reports finding. Then the facility agreement, master facility agreement, which is 52 pages. The claimant's expert has noted that the page number 52 on which the signature is printed, it's printed twice. There are two page number 52, which clearly points at tampering. Why there are two page number 52 in a document? And that's the only document which contains the signature. There are other documents like personal guarantee where there are initials at the bottom of the page. Initials at the bottom of the page, none of the initials, I mean the short version of the signature. And the claimant's expert stated none of these could be verified. There was nothing given to the claimant's expert to verify them, and it was inconvenient and so ignored it completely. So none of those pages are proven. Every document stapled, removed, stapled multiple times. And this is the nature of the document. Last page signature printing is always doubtful. And two pages with the same number. And one document, which is a crucial document, if I remember it right, is one of the personal guarantees. Some pages, the short signature, the initial is in pen and ink. Other pages, it is copy paste. How is this possible, your lordship? When you are executing a document, will anybody copy paste short initials on two pages and sign physically on other pages? So tampering, forgery, fraudulent attempt to make an innocent person liable for somebody's obligations has happened. Who did it is not more for me to prove, your lordship. So this is the nature of the documents which are produced by the claimant to prove their case. So when the major documents, which are the personal guarantees and the facility agreements, the quality of the documents are like this, completely unacceptable. Everything else produced afterwards to validate it also cannot be swallowed without a pinch of salt. This is very difficult to accept. Where should the benefit of doubt go? When I am alleging my signatures have been fraudulently copy pasted and my expert says it is forged. This is forgery means any manipulation according to Black's Law Dictionary. This is the meaning of forgery which is given. So in that context, when the major documents are like this, other documents which contain my signature, 1 page, 2 pages here and there, I could have been tricked also. When I'm at the helm of affairs till 2017, hundreds or thousands of documents being signed everybody, somebody could have planted one paper here and I could have signed it. But that's not the way to hold me liable for a $130 million facility afterwards. It was the bank's duty to be careful. It was the bank's duty to ensure compliance with their established procedures, which I will be cross-examining those witnesses, and then we can bring all that to light. So here, paragraph number 38, page number 934, the claimant's expert report. With respect to the comparison documents provided by the claimant, I understand that Dr. Shetty has not confirmed whether he accepts that he wrote all of these signatures. I am instructed to use these signatures in the comparison process. How is it possible, your lordship? You need an admitted signature, and the admission should come from the person who signed it and who is instructing otherwise. And Q1 document, which is the personal guarantee, towards the end of, in the middle of page number 938, paragraph 55. The question signature in the name of Dr. Shetty on page 14 has not been appended in pen and ink. It's admitted fact. And then it's referring to two persons who have signed this document physically. And these are the persons against whom Dr. Shetty has filed criminal cases. And they have not been cited as witnesses here also. So they are the real culprits, is the allegation from the defendant. And page number 14 is security printed. It is stated. And page number 14 of this guarantee, Q1. Only one page is security printed. So the copy of the photo, enlarged version of it is shown in page number 939. Why only one page is security printed? Why the other pages are not? So it's printed with two different instruments or in a two different way at different times. How can we attribute even the copy paste signature to a document which was not printed in one shot? Now, paragraph number 58, when examining a copy signature appearing on document, it does not necessarily follow that a signature was ever applied to an original version of the document. This is a finding. In that format in pen and ink. It is an easy process. It is an easy process to transpose a genuine signature from one document onto another. I'm reading the claimant's expert's report, Your Lordship. Using scanning and reprinting processes or basic computer software, how easily this can be manipulated. If undertaken with a modicum of care, such a transposition would only be likely to be detected if another identical signature could be found, so as no individual signs in exactly the same way twice. Even that has been found. 2012, 2019 guarantees are signed at the same time. I'm noting the presence of Mr. Vikas Sharma here.
Yes, you mentioned Mr. Sharma.
Good evening.
I just noted his presence, that's all. Yes. I didn't mean more. And paragraph number 61, the signature appears in a horizontal position related to the writing baseline on the page, while this is occasionally found in the known writings presented. Normally, C11.5, C11.8. In the vast majority of the known signatures of Dr. Shetty, the signatures are written at a distinct
Sir, please slow down.
Striking similarities.
I'm sorry to interrupt. Mr. Sharma, can you please turn your camera off? Thank you.
And in page number 940, Your Lordship, three signatures are shown. The photos of three signatures are shown. One is Q1, the 2012. One is 2012 guarantee. One is 2019 guarantee. And it is superimposed and taken another one, identical signature. 7 years gap, identical signature. Copy pasted on two guarantees. This is the situation. And it's confirmed that it's identical at the end of the page. Q2 document, again, the various vacant staple holes, all these anomalies are noted. Two witness signatures are there, paragraph number 93, page number 945, with associated details. Arun Kumar, Rajesh VV identified, but none of them are being examined as witnesses in an attempt to prove that Dr. Shetty did indeed sign this document knowingly to personally guarantee the liabilities of NMC to ICICI. If the claimant bank has not taken that step, is not the defendant to be blamed for that. Q3, 27 March 2019, same problem. And here, my learned friend was submitting about the toner, the printing, there was one shade on the left side, all that. I believe it was the same document. Here, paragraph number 115 of the claimant's expert's first report. The laydown of the toner on pages 1 and 17 is different relative to the precisely printed content of the other pages of the document. Consequently, all pages of Q3 as presented have not emanated from a single printer in a single print run. So it's not even a document printed together. Pages are printed at different times and attached together. Big photographs are given. But the expert did say something different, contradicting this statement in the supplemental expert report that is for cross-examination. Now, there is a handwriting, paragraph number 116, handwritten date March 27, 2019. In a disputed document, everything matters, Your Lordship. When somebody has handwritten, any attempt made to prove whose handwriting is this? Even persons whose name and address are given are not cited as witnesses. Even the bank's officers whose names are written in those disputed documents are not cited as witnesses. No one from the bank comes forward to say that I saw Dr. Shetty signing, I met Dr. Shetty, I communicated with, other than Mr. Vikas Sharma, which is an overstatement in a courtesy meeting in Bangalore. And photographs of the printed writing on page 1 and example linked writing from page 2 are shown over the page. Page number 950, supposed to be the short version of the signature, or what we call the initials. Plain eyes, your lordship, 950 page number. It looks entirely different. There is no similarity at all in this one. It's totally different the two-way. These writings have not currently been examined, and the claimant's expert did not examine this one. It is stated in paragraph 119. Then paragraph number 121. This signature has not been appended in pen and ink. It's clearly stated there. Copy paste signature again. It has been printed with a document with a colored toner. This page only of the document also bears security printing. The last page where the signature is there, always different. It's a security printing, and it is shown the enlarged version, photograph of Q3 taken under high magnification, showing that it has been printed on the document. And you can see the shades, the different colors, the yellow, blue shades there. And identical signatures I already submitted, 952. And 142 paragraph, even about copy paste signatures, the expert is stating that paragraph 142, page number 954, I am of the opinion that there is very strong evidence to support the proposition that Dr. Shetty wrote the signature which appears on Q3 and Q7 and C12. Q3 is the personal guarantee of 2019, which she stated that this is a printed signature, and this is a conclusion drawn, completely contradicting herself. The finding, what she made, and the conclusion she's drawing is opposite. Now, coming to paragraph 145.
So where do you say it's opposite to her earlier conclusion? Where is her earlier conclusion? What paragraph?
The paragraph, the Q3 is what referred there. And yes. Q3, if you look at the beginning of the expert report, first is Q1 and Q4.
Yeah. You say what she says here is contrary to what she said earlier.
Yes, Your Lordship, paragraph number 12.
Paragraph 12 of her earlier report.
Her own report, same report, not different. Article, this is page number 929. The question signature in the name of Dr. Shetty on Q3 has not been appended in pen and ink on this document, but has been printed with toner. This is paragraph 12 on page 929. When we reach number 954, paragraph 142, she says, I am of the opinion that there is very strong evidence to support the proposition that Dr. Shetty wrote the signature which appears on Q3. I consider the alternative position that it is a stimulation of his signature or genuine signature style by another person, individual, to be highly unlike. How is it possible? It's a printed signature she has found. So this is the serious contradiction here. And Q4, again the personal guarantee, June 2019. Paragraph 145 says, the printed content of the document has been appended in toner. The cover page, the page bearing the printed page number, page 8, and the first page, 10, bear security printing. Each page bears colored printed entries. Only 2 pages security printing, other pages normal printing. The question signature in the name of Dr. Shetty has been appended on the first page 10. The signatures have been addressed earlier in this report, it being identical to that on Q1, copy paste signature. Q1 2012 guarantee.
Could you slow down a bit?
Yes, sorry for that. The signature on 2012 guarantee and the signature on 2019 guarantee identical, copy pasted, and different printing for the same document. Security printing for some pages, normal printing for other pages. So this is the quality of document. And general comment regarding Q5 to Q12. It is stated in paragraph 1.
Remind me what security printing is.
To be honest, I don't know, but it's a different printing is what I understand, Your Lordship. This is what she has. We can ask the expert when she comes.
You can ask her, yeah.
I'll ask her. I understand. This is paragraph number 153, Your Lordship. I understand from those instructing me that the salient documents in this matter are Q1 to Q4. Q1 to Q4 are the important documents. Those are the personal guarantees, 4 personal guarantees, out of which 3 are copy-paste. Another one, the Q3 has several other issues. Now, consequently, these documents have been addressed in full details. With respect to the other question documents, full details of the features observed in all of these signatures have not currently been detailed due to this being a time-consuming and repetitive process. So she has spent time, effort, energy only on those 4 documents, Your Lordship. Other documents have not been examined in detail. This is what she's saying in paragraph number 153. And Q5, Master Facility Agreement 2011, Your Lordship. 154. Q5 comprises 53 pages. And out of 50, there being 2 pages bearing a footer number of 52. This is impossible. How will a footer, which is automatically entered the number, have 2 numbers 52 in the same document? And it is on that 52 page number that the defendant's signature is appearing on behalf of NMC, not as a personal guarantor. So even that document is absolutely questionable. Now, all pages of the document are currently held together with a metal clip in the top left-hand corner. There is also rust mold in this top left-hand corner of the document. That is stated as a separate thing, but currently held together. So why 2 pages with the same page number? We all know how the footer number comes. We just insert page number, the page number goes automatic to all the pages. How can there be 2 page number 52?
Sir, I'm sorry, you're not slowing down even when requested. I know it's hard to change the speed of your speaking, but it is very fast, and I really need to think about slowing down so that I don't have to keep interrupting.
I understand. There is a natural style, plus your Lordship has told me to cut down the time. Can't take more also. Sorry for that. I'll still try.
Do you want to repeat that last point you made, because it was possibly quite important?
In a document where there runs into more than 50 pages, Your Lordship, signature appears only on 1 page, which is page number 52. And if we look at the page numbers in sequence, page number 52 is coming twice in that document.
Yeah.
Which is impossible if it is an automatic process. So somebody has planted a document there, and he made a mistake, an error or oversight to change the number. This is my inference about it. The 52 is appearing twice.
Okay.
Paragraph number 1.
I don't want to interrupt, but there are 2 pages of there are 2 execution pages.
It's my time.
You can deal with this with a witness.
So it's an execution page. I agree. Execution page only says that this deed is executed, and that is why it was easy to insert the doc paper there, because it doesn't talk anything about anything else. It's just few lines there, name details, and another person's signature. That person is not cited as a witness here. Now, the main body of the document has been printed with toner. The laydown of the toner on the second page 52, which bears, this is paragraph 156, Your Lordship, which bears the question signature, is different relative to other pages of the document. It's very crucial, as there are areas in which the toner is failing to adhere to the surface of the paper. So it's printed separately, completely different document. Whilst the font of entries on all pages has not been examined in detail, it is noted that the first page 52, signed in the name of the bank, has been appended in a differing font relative to other pages of the document. So pages have been inserted, pages have been added on, numbers are wrong, then many of the signatures in other documents are also copy pasted. Other pages are also, there are some short initials which has not been examined, which was not sufficient. It looks so different even to naked eyes. 157, illegible handwritings have been appended at the foot of pages 1 to 51. Somebody's handwriting is there. And the second page 52 in blue ballpoint pen ink. These writings have not currently been examined with respect to authorship due to a lack of comparison material in suitable form presented. No examination is done on these papers. Example of these writings, there is another short signature which we just saw two other signatures on another. This looks completely different from that. Naked eyes, I'm telling your lordship. 159, paragraph number on page 957. The question signature in the name of Dr. Shetty has been appended on the second page 52 in black non-ballpoint pen ink. Adjacent to the signature is a blue hand stamp impression in the name of NMC Healthcare LLC. Next paragraph, this document has also been signed in the name of Ms. Seema Singh in blue ballpoint pen ink. Adjacent to this signature is blue hand stamp impression in the name of ICICI Bank Limited. These multiple 52 pages, this is where the document is signed. Even Ms. Seema Singh is not being cited as a witness here. If she was signing on behalf of ICICI Bank, definitely she could have thrown some light on who signed, when it was signed, why it was signed, whether this 52 page was actually part of the document. She could have said that, but she is not examined as a witness here. Same issue with supplementary and mandatory agreement to master agreement dated 24 September 2012. Again, Ms. Seema Singh is a signatory to that. Paragraph number 170 in page number 959. And she is writing something about 172, which we'll have to ask her on cross-examination. Some slightly unusual features are observed in the second half of these signatures. It is noted that there is a tear in the paper in the area of the second half of Q63, and I'm unable to determine whether the cause of this tear had an impact upon the execution of the signature. I don't know what is the significance. I've just noted, brought to the attention of your lordship. We will ask her on cross-examination. Now coming back to page number 959.
So you've become, I'd say, doubly fast. I really must implore that you slow down.
Coming back to page number 959 of the hearing bundle, paragraph number 171. There are three signatures, your lordship, Q61, Q62, Q63. If we look at that photograph, plain eyes, it looks so different to me. But this is a question to the expert. We'll ask her later. Again, Q7 document, paragraph number 178. The document has also been signed in the name of Mr. Harpreet Glennie in blue non-ballpoint pen ink, and adjacent to this is a blue hand stamp in the name of ICICI Bank Limited, not cited as a witness. If they wanted to prove the document, he should have been cited as a witness. Page number 962, your lordship, there is a signature in blue color. And if we compare it naked eyes with other signatures, there's a big difference. But just because it is blue and it is in pen and ink, we cannot say that it is definitely attributed to one person. I'll have to ask the expert these questions.
You're going fast again.
I'll have some more.
Yes.
Yes, your lordship. Q11. Q11 is the document which is letter of amendment. It's in page number 968. Here, paragraph number is 227. As stated previously, the question signatures on Q11 have been appended in particularly abbreviated styles. This restricts the examination. While some signatures of some features of similarity are observed with respect to the first two signatures on this document, there are also features of difference. I have had difficulty in determining the reason for these differences. That is, whether Dr. Shetty wrote these signatures in a particularly abbreviated style not found in the known writings or whether they may be of differing authorship. So no conclusive proof there. I have taken what I consider a cautious approach to these signatures, and I'm of opinion that on the documentation before me, the evidence has to be regarded as inconclusive as to whether Dr. Shetty wrote the first two signatures in Q11. Inconclusive is the word used. I am of the opinion that there is moderate evidence to support the proposition that Dr. Shetty wrote the third signature in his name on Q11. So why is all these anomalies? And inconclusive is the final word. Then there are some information given regarding page number 969, 232.1, 233.2, how the pens are used. The same pen has been used for these and different pens containing same ink. I'm not taking into. Finally, 235, I'm unable to determine which of these possibilities is the most likely one. So that's again, I would say inconclusive that way. See, and again, in page number 970, 245, the claimant's expert states, no significant impressions were raised on page 5 of Q12. This she's saying because if page 5 was below Q12 with that document, some impression would have been left there. It is not there. And this is pointed out by the defendant's expert also. And paragraph 244 is referring to some erased writings in pencil on page 1. Q13, facility agreement dated 27 March 2019. This document does not bear a signature in the name of Dr. Shetty. Dr. Shetty has not signed the document. There's no allegation to that effect as well. So we can completely brush aside that possibility. So overall, if you look at it, Your Lordship, the quality of documents produced before Your Lordship, even this expert has opined that there is one witness statement given by the legal advisor of the claimant. He also stated that most important documents are the personal guarantees. 3 out of 4 are, I would use the word forged, copy pasted without anybody's authority. It cannot be equated to electronic signature by any means. It did not originate from the defendant. It was never even sent by email to the defendant. Defendant never acknowledged that. This is the situation. So only one document, there again, the execution page where the signature is coming is a different printing. So the completely brushing aside the possibility. Even the facility agreement, the original one, 51 pages, initials could not be verified. 52 page number 52 coming twice. So very questionable there, the execution of it. It only says signed by, nothing else on the page number 52. And printing is different on one page 52. All this is stated in the expert report, claimant's expert report. I did not even take Your Lordship to the defendant's expert report. There is a lot more there, which I will bring in during the cross-examination and afterwards during the closing submissions. And about the compliance procedures which the bank was obliged to follow, even according to the bank's own managers who are going to testify before the Honorable Court, who have submitted witness statement, there are umpteen number of questions to be asked on that. Why did you do this way? And finally, Your Lordship, from the only one point, that's the Petersburg case, Your Lordship, yep, which says the Court of Appeal disagreed. Page number, this is paragraph number 23 of the defendant skeleton.
Sorry?
Paragraph number 23 of the defendant skeleton.
Give me a second.
Sure.
Paragraph 23.
Yes, Your Lordship. The last sentence in paragraph 23. The
Hold
Court
on,
of...
Hold on.
Sure.
Yeah. Of the defendant's skeleton.
Defendant skeleton, Your Lordship.
Right. What does it say?
The Court of Appeal disagreed, affirming that even in fraud cases, the test is...
My paragraph 23 of the defendant's skeleton.
Yes, Your Lordship.
Begins furthermore.
Oh, then there were two St. Petersburg case numbers.
Have I got the wrong number?
Defendant skeleton, in my document, it is paragraph number 23, what I'm looking at. 2.3.
2.3. My paragraph 2.3 begins with the word net furthermore.
Oh my God. Something wrong.
The discussion of the Petersburg case starts at paragraph 30.
How many pages in the document your lordship is looking into?
A lot.
Because initially we submitted 39 pages. The claimant objected. We reduced it to 24 pages. I'm looking at
I've
24
got 45 pages.
That is not the one, your lordship. That was not allowed. We submitted.
It got into the bundle.
I don't know. I did not prepare the bundle. So
No, it was emailed to me by the court staff. So I can discard that, can I?
my preference is to have it. I have put all the arguments there, but if your lordship decides to discard it, I can't object.
Well, I can't take account of something that's not part of the case.
We submitted 39 pages initially, objected. So we had to rephrase it, cut it short, put 24 pages. Now half of it has been discarded again.
Is there some limit to the length you're allowed?
Yes, your lordship.
What is that limit?
25 pages.
Oh, I see. Right. Then I will have to.
So even if your lordship is not looking into the paper, your lordship, I can read. It's one small sentence only.
Yeah.
The Court of Appeal disagreed, affirming that even in fraud cases, the test is whether there is a reasonable basis for the allegation. There is no requirement to prove fraud beyond all doubt or to prefer an innocent explanation over a dishonest one. This is exactly what is stated. So my understanding is that there is no need to prove it beyond any reasonable doubt as we would expect in a criminal trial. Some basis, some reasonable basis for the allegation of forgery is enough. Fraud is enough. This is the case. And paragraph 25 again stated, the correct test is whether the allegation has a reasonable basis in support of the allegation. So that's all, your lordship. I hope I have not taken a lot of long time than what was expected. I tried my best to restrict it.
Well,
Thank you very much.
I'm sure you've tried your best. Thank you very much. We are now 4 hours behind schedule. We are now at the stage where the proceedings for the day should come to an end. Now, I think the transcriber will need to stop soon. I'm not sure how long she can go on. Can I ask you, Madam Transcriber, if we wanted to try to fit another hour in, is that too long for you? If you had a break?
I definitely need a break. Yes, no, I haven't got a problem sitting longer hours at all. I would once again request that we can change the laptop, please, for Mr. Shaheen, because I think that will improve the audio and make everything smoother. But I haven't got a problem sitting longer hours now.
Right, thank you. Can we just be realistic for a moment and look at the timetable? Have you got a copy? By this time on the first, I know we had an hour and a half or so at the beginning of the day discussing amendments and so on. But we are now where we should have been at 10 o'clock this morning. How is it practical to finish this case in the time set out in the agreed timetable? And if we got rid of oral closing submissions at the end, that would save 2 hours. But at the present rate, I mean, is it listening to Mr. Shaheen, and also I think it's fair to say your Mr. Aiken's points as well. Cross-examination of the experts is going to take more than 2 hours each, isn't it?
Likely, your lordship.
Why have we agreed 2 hours if it's going to take more than that?
Because the supplemental expert reports were not there at the moment.
My lord, I do think we can take 2 hours extra if we remove oral closings. There was provision to start a bit earlier on the on the third day, maybe at 8 a.m. UK time, which is 11 a.m.
We've assumed that. And that's
So
for the
that would
second.
give us
That's
3 hours.
that's already for the second hour of the cross-examination of the defendant's expert.
So if we were able to get through Mr. Sharma this evening, I do think we can then move the claimant's remaining witnesses, as long as Mr. Shaheen keeps to his 1 hour each, to the first half of day 2. We can then have Mr. Shetty in the second half of day 2 and start the cross-examination of Ms. Radley on day 2, with Ms. Radley being finished on day 3 and Mr. Albar cross-examined on day 3. So we do think it's still achievable at the moment.
Right.
It's not I mean, apologies from the claimant side for, I think I ran 20 minutes over in my openings, but we would say the rest has arisen due to
Well, I'm leaving out of the calculation the time spent before we started, but okay. How long do you think you'll be with Mr. Sharma? Presumably he'll just give evidence by adopt his statement and that's it, in chief.
Yes, precisely, Lord.
Right. What do you say, Mr. Shaheen, about how long you're going to be with Mr. Sharma?
If it's a little bit, please bear with me.
So you're inaudible at the moment.
I can't hear you either.
Sorry. I'll try my best to finish it in 1 hour. If it gets a little that side, please bear with me, Your Lordship. That's all.
Well, can Mr. Sharma split his evidence between today and tomorrow? Is he here in person or?
No, he's in Canada.
Therefore, wouldn't want to start in the morning.
I don't think he'd be able to continue on Wednesday morning because that would be his
About 2 in the morning or something, yeah.
Yes, it would be quite challenging. If we can get through Mr. Sharma today, I think
we won't. If it takes an hour for Mr. Sharma, we can't go on. We've sat since 8 o'clock this morning, UK time. It's now after 3 o'clock. That's a long time. We'll need at least 1/4 hour for the transcriber to have a break before we continue. Is there a shorter witness we can take now and do Mr. Sharma tomorrow afternoon? What about going back to Mr. Gupta? Is he going to be long? Mr. Shaheen, how long are you going to be with Mr. Gupta?
Your Lordship, maybe a little less. Maybe a little less than Mr. Vikas Sharma.
Which witness would you be shortest with?
That I can't definitely say. Depends on the access.
Well, I'm willing if the transcriber is willing, if we have a break now of say 15 minutes, I'm willing to sit for 45 minutes after that, but no more than that because I lose concentration. It's a long day. I think what I'm going to do is leave. I'm going to break for 1/4 hour now. And when I come back, I expect you two, between you, to have decided what you're going to do in terms of which witness to call, on the basis that we'll only sit for 45 minutes after we come back. Would that be all right with you, Madam Councillor?
Yes, I don't mind extending time. That's fine.
Thank you very much. Okay, we'll work on that basis and come back at about just before 25 past. Okay, and between you, can you decide which witness you're calling It shouldn't be Mr. Sharma if he's going to be interrupted, unless you want to take him in two chunks.
I just said taking Mr. Sharma in two chunks is going to be difficult. He isn't available on Wednesday at all. He's traveling, flying. He will be available on Thursday.
But not in the morning.
But we only have the morning.
Well,
So, I mean, maybe we would have to take him at 8 a.m. It would just have to be late for him.
be very late. Well, I'm going to have to do. I can't case manage it for you. Between you, you're going to have to work out which witness you're taking now, on the basis that he will probably run over into Wednesday. So we'll stop now. I'll come back at 25 past.
Thank you.
Right, are we all here?
Yes, Your Lordship, I can hear.
Madam Transcriber, are you here? I can't tell.
Yes, we're all here, my lord, and we've come up with a plan.
Is the transcriber here? I can't tell from
Yes,
my
sir.
screen. You are.
Yes,
Thank
I'm
you.
here.
Thank you very much. You've come up with a plan, have you?
So we think the witness who will take the least amount of time in cross-examination is Nikhil Parekh. He was relationship manager between 2014 and 2018. Mr. Shaheen thinks he can be done with him relatively quickly. He should be joining.
I don't like the word relatively. Anyway.
I'll let Mr. Shaheen say exactly how long. He should be joining any moment.
Right. Mr. Shaheen, how long are you going to be with him?
The agreed time of 1 hour, I'll try to reduce, Your Lordship.
All right.
It's not problematic if Mr. Parekh goes he's interposed over into Wednesday. He's based in China, so the time difference will work in our favor if he's the first witness to be called on Wednesday morning.
Yes, but it may be not problematic from that point of view, but it's problematic in terms of progress.
Yes.
Yeah, very well. I have his statement, and you can take it. I've read it. Do you want the witnesses sworn? Or do you, I probably better administer the oath or affirmation?
All of the witnesses for ICICI have confirmed that they would like to affirm their evidence.
Yeah, very well.
Just admitting Mr. Parekh now.
Good afternoon. Are you Mr. Parekh?
Yes, sir. Hi. Good afternoon, sir.
Good afternoon. Are you Mr. Parekh? Hello? Can you hear me? That's not very satisfactory. We have Alia, is that you?
Yes, Your Honor, I'm ready to affirm the witness when he is ready.
But at the moment, whenever I say anything, it echoes back through the system. That's better. Do you want to affirm the witness?
Yes, I'm ready to. However, I believe that he is frozen right now.
Can someone try and unfreeze Mr. Parekh?
I believe he's rejoining.
Hello.
Hello, Mr. Perek.
Thank you, Your Honor. May I proceed with the affirmation?
Yes, of course.
Yes.
Mr. Parag, can you please confirm your name and occupation for the court's record?
Yes. Myself is Nikhil Mahendra Parekh, and I work with ICICI Bank Limited.
Thank you. Please repeat after me. I affirm that I will say nothing but the truth.
I affirm that I will say nothing but the truth.
Thank you. Thank you, Your Honor.
Thank you very much. Mr. Lakin.
Mr. Parekh, you should have access to the electronic bundle of documents for this case. Could you please open that?
Sorry, Mark. Unfortunately, I am not able to kind of access that since I'm logging in from my mobile system. So I'm just carrying my the witness statement and the other details essentially right now.
Right.
Is the registry able to put on the screen the hearing bundle? I understand that is common.
Alia, are you there?
Yes, Your Honor. I'm just sorting that out. One moment, please.
Thank you.
Thank you.
What do you want on the screen? Mr. Lakin, what document do you want?
I was just going to take him to his witness statement to confirm it's
I
his.
think if you tell the court what page you want to, probably be
Yes,
helpful.
it's page 870 of the main electronic bundle.
Do you want it only for the purpose of identifying it, in which case maybe the witness could hold up his copy in front of his camera?
If the court's happy with that, we would be.
Any objection to that, Mr. Shaheen? If the witness simply holds up his copy and says it's his witness statement?
Even that is fine, Your Lordship. If he has the witness statement in his hand, it's fine for me.
Right. Should we proceed on that basis?
I have the witness statement. Yeah.
Can you turn to the back page of your witness statement? Page 6.
Surely. Yeah. Just a moment.
Can you confirm to the court that that is your signature?
Yeah. Just a moment, Mark. Yeah. So page 6 of the witness statement, I'm just holding. I confirm that this is my signature on the witness statement.
And can you confirm that you read this statement and you confirm the content is true?
Yes, Mark, I have read my witness statement and I confirm that the contents that are mentioned in the witness statement are true.
Thank you. Mr. Shaheen will have some questions for you now.
Mr. Shaheen.
Your Lordship, 6:34 I start. So, Mr. Parekh, you were the senior relationship manager between 2014 and 2018 in the IFC branch of ICICI.
Yes, sir. Yes, sir. From October 2014 until July 2018.
Yes.
I was posted with ICICI Bank at the IFC branch as a senior relationship manager.
You are aware of the facts and circumstances of this case.
Yes, sir.
Was any personal guarantee executed during your period, 2014 to 2018?
Yes, sir. There were personal guarantees which were executed from the period 2015 until 2018, sir. Because I started managing the NMC relationship from somewhere around May, June 2015 until July 2018, when I took up my next assignment with ICICI Bank. So during that period, there were for some of the borrowings that NMC Healthcare did, for which there were personal guarantees which were executed.
None of the personal guarantees executed between 2015 to 18 have been produced before the Honorable Court. None of those personal guarantees have been produced. You can say yes, you can say no, you can say I don't know. But please be brief. I have very limited time.
Yeah. Sir, I need to check on that specific aspect, because not being produced, I just need to check internally and come back to you on that specific point.
So you don't know whether any of the personal guarantees executed during 2015 to 2018, if any of them are produced before the court or not, you don't know.
Yes, I can say I don't know whether they have been produced before the court or not. Yes.
Okay. In your witness statement, as part of your job profile, you have stated that directing and supervising the relationship with existing clients of the bank, including building up rapport with senior individuals within the client institution. You have stated that. 7.1.1.
Yes, sir.
Who was the senior most individual in the client's institution in the case of NMC?
Sir, the senior most individual would anyways be the ultimate beneficial owner. But me being the senior relationship manager, so I was kind of managing the relationship primarily with people engaging in the day-to-day business affairs. So primarily people from the finance department, as well as the banking and the operations department. So that is where I was primarily managing the overall relationship. Obviously, I had superiors within the bank who were then responsible for kind of managing the relationship at a senior level at the client's end, essentially.
So you were meeting all those persons who were involved in the day-to-day management of NMC.
Primarily, yes, sir.
Yes. Now you were responsible for overseeing client acceptance, 7.3. Onboarding procedures such as conducting due diligence and reviewing documentation requirements. What
Yes,
is the
sir.
kind of due diligence you were doing?
Sir, essentially, for any credit proposal which would kind of come in from the customer side, so we would undertake the credit due diligence on the customer. Once the credit due diligence is completed, there would be an internal sanction process as per the bank framework with regards to credit sanctioning process. And post the approval of the credit sanctioning process, we would undertake the relevant legal documentation as required by the laws of the respective regulation where we operate. And based on the completion of documentation and other relevant aspects which are outlined, then we would ultimately disburse any credit facility to a customer. So in terms of due diligence, obviously, as I told you, credit due diligence is the most important part, being the relationship manager. And post that, when the credit due diligence and the sanction process is completed, uh, we would take help from our legal team in terms of drafting the documents, in terms of what are the different execution requirements from a legal standpoint of view are required. So that is where our legal team would provide us with the respective assistance and guidance. And post that, these documents would then be submitted to our loan operations department, who would then kind of review the documents in line with the sanctioned approval, and then go ahead and disburse the credit facilities. So this is the kind of broad outline, sir.
Reviewing the documentation requirements was also part of your job.
So your audio has
Correct.
got very low.
Reviewing the documentation requirements was also part of your job.
Yes, sir. So in terms of, we would get the kind of requirements from the legal team as to what are the documents that would be required for the credit facilities, and based on the list or the details provided by our legal team, we would ensure that the documents are executed and completed. And once the documents are executed and completed, we would submit it to our loan operations team. So we would ensure that, because our loan operations team would ensure the prescribed guidelines by our legal team are followed. So we were ensuring that whatever our legal team had prescribed is kind of done and meticulously, and is submitted to our loan operations department.
You said you are part of the onboarding procedures also. So taking the specimen signature of the client is also part of the onboarding procedures.
Yes, sir.
What is the
Yes, sir.
purpose of the specimen signature?
So specimen signature is essentially to verify whether the documents are indeed executed by the person who is signing the respective documents. So kind of
How is,
verifying whether the signatory is the same person or not. Yes.
how is a specimen signature taken? What is the process?
Such specimen signatures we generally take where the person would sign in person, and we would then verify it, one of the ID documents of the person. It could be a kind of a passport, or it could be, let's say, a verification provided by some other banker, essentially outside banker, confirming that yes, this is indeed the person who is signing the this is indeed Mr. ABC, or this is indeed Mr. Nikhil Parekh who is signing the document, essentially. So these are a couple of ways in which we verify the specimen signatures.
So one requirement is the concerned person has to sign the document, right? The specimen signature.
Correct.
Yes. And then it is verified. Is it necessary that it has to be signed before a bank's official for verification? He's signing, witnessing.
Sir, yes. So when we put it in record for the first time, it has to be signed within the in the presence of a bank official.
Okay. So now, paragraph 9 of your witness statement, you can look into it. See,
Yeah.
towards the end, you stated in the middle, NMC Healthcare LLC, at the time known as NMC Healthcare Limited. Okay.
Yes, sir.
Do you mean that there was a status change, the company changed? The company NMC changed its legal status?
NMC healthcare facilities at that time. I just need to check on this particular aspect, sir. It was NMC Healthcare LLC because that was the legal name for the company in UAE. But I just need to check on this particular aspect at the time known as NMC Healthcare Limited.
So anyway, from your witness statement, it is clear that there was a change in the company because it was earlier NMC Healthcare Limited and later it became NMC Healthcare LLC. This is what you stated. There is a change.
On this particular point, sir, I would need to just reconfirm and maybe come back to you on this particular point with regards to the change, since it is a bit dated in terms of my leaving the NMC responsibility and taking over other roles. So in terms of me clearly telling you whether there was a change in status, I just need to look into the records and come back to you, sir, on this particular point.
As of now, you don't know what was that change.
Yes, yes. As of now, I cannot give you a kind of a clear answer on that point. Yeah.
Now, the last sentence in that paragraph, I took on responsibility for the NMC relationship from Ajay Goyal, another ICICI employee. Okay. So
Yes,
where
sir.
is Ajay Goyal now?
Sir, he had resigned from ICICI Bank in 2015. So when I took over from him, so he's moved outside ICICI Bank since 2015, sir.
How long did he serve ICICI DIFC branch?
Mr. Ajay Goel?
Yes.
Uh, Sir, he would have been there with ICICI DIFC branch maybe for a year approximately. I don't exactly remember, but with ICICI Bank, he was almost for 10 plus years with ICICI Bank. But with DIFC branch, he should be for a year. But I need to exactly check on his HR records to confirm that for how long was he with the DIFC branch. He moved from our office in Bahrain, sir. He used to be part of our office in Bahrain. So Ajay had moved from our office in Bahrain to the DIFC branch. So I just need to check exactly as to what period he was there at the DIFC branch.
When was the DIFC branch established?
So DIFC branch, we started somewhere around in 2011, and then we got a kind of a full license as a Cat 1 somewhere in 2012.
Okay. Now in paragraph 11 of your witness statement, okay, you have named the persons whom you were meeting regularly, senior management. Prashant
Yes, sir.
Mangat, Suresh Krishnamurthy, Uday Kumar, Prabhakaran Nair, Praveen Kumar, Prajesh Veerachan, etc. These are the people you were meeting regularly, right?
Yes, sir.
And you said the meetings would concern the documentation for the credit facilities, right?
Yes, sir. Documentation, KYC, and other aspects. Yeah.
Why were these meetings required every quarter?
Uh, Sir, some of the meetings in terms of like we had to complete some of the reviews from time to time. So there would be requirements to complete KYC updations. At times, there would be new credit sanctions that would have got processed. So in terms of say kind of executing the documents and other aspects, we would be meeting them, or also maybe just to take stock in terms of how the business is, or to kind of get an overall overview in terms of what is happening or what are the new growth plans. So these were the main agenda points that we covered during the meeting, sir.
Okay, let's try to be brief, please, because very limited time we have. We are already running late. So, paragraph 12,
Okay.
you have stated you
Mhm.
never personally met with the defendant, Dr. Shetty. That's correct, right?
Yes, sir. That's right.
Now, you said you were the person arranging meetings for Mr. Vikas Sharma.
Yes, sir.
Have you produced any evidence before the court to show that you were arranging meetings for Mr. Vikas Sharma with Dr. Shetty?
Sir, there were a couple of email communications that we would have sent to the secretarial team for Dr. Shetty's time schedule for some of the meetings from time to time. Some of the emails we have shared essentially.
Have you produced any emails before the court regarding these appointments?
Unfortunately, sir, I'm not having access to the list of documents or submissions which have been made, so I'm not able to exactly point out whether those are part of the overall submissions. I just need to check on that particular point and let you know, sir. Because unfortunately, I'm not having access to the list of documents which have been submitted.
Paragraph 13. You said
Yeah.
the checks issued as payment obligations under the NMC facility agreements were signed by Dr. Shetty. Have you
Yes, sir.
seen those checks?
Yes, sir. We had those original checks with us, signed by Dr. Shetty. Yeah.
Has it been produced before the court?
So I need to check in terms of the documents which have been submitted to the court, sir. I am not having access to the documents right now.
So you don't know.
Sorry for yes, sir, sorry for that, but I can't give you a firm answer on that point.
Paragraph 14. Second line, you're saying that Dr. Shetty was very familiar with ICICI and its relationship with NMC. You never met Dr. Shetty, so it is just your assumption.
Sir, so generally it's not an assumption because Dr. Shetty was a kind of a key management personnel of the NMC business, and he was the person who was kind of driving the overall business. So that is where it would be natural that he would know about the ICICI relationship. Yes, I
You
have
have
not met Dr. Shetty in person. That I completely agree with you on that particular point. But being one of the key management personnel of NMC, from that perspective, I would assume that yes, he would be aware of the banking relationships.
Yes,
Yeah,
that's all I asked. You assume that you would
yeah,
be aware.
yeah.
Then, towards the end of that paragraph 14, you are saying that we never received during my period, acting as a senior relationship manager, any communications from Dr. Shetty or others within the NMC group asking about or expressing concerns about the existence or validity of the NMC personal guarantee. That's correct, right?
Yes, sir. That's right.
In paragraph 15, the language that you have used in the third line is this process would have been adhered to, meaning you are not sure. You assume that it would have been adhered to. Am I correct? Because you started by saying we followed a specific procedure for finalizing and obtaining executed versions of important documentations from our corporate clients. Then you say this process would have been adhered to.
Yeah.
Yes. So in the
Yes, sir.
procedure which you are explaining, 15.3,
Yeah.
you are saying that
Yes.
NMC would send scanned copies of the executed documents for your review. First step, right? 15.3.
Yeah. Yeah.
Then a junior relationship manager will collect the original executed documents. 15.4.
Yes, sir.
What do you mean by original document?
Sir, original document would essentially mean with the documents with the wet signatures. So the original signatures. So that would I mean as original documents essentially.
When you say wet signature signed with a pen and ink, right?
Yes, sir.
These are the
Yeah.
original documents.
Yeah.
And 15.5 says, on arrival at ICICI offices, a further verification process would then be completed by our Credit Middle East office group, right? What
Yeah.
is
The
that?
credit middle office group. Yeah.
What are they
So
verifying?
sir, essentially, this is the loan operations group I was mentioning, sir. So loan operations group would take the executed documents and they would verify whether the documents have been kind of executed as prescribed by our legal team. Because as business, we are kind of a interested party. So the loan middle office or the credit middle office group, what we call within the bank, so they are responsible for doing this independent check on the execution of documents and then confirming that yes, the documents are indeed as per the legal prescribed standards, and then the next process with regards to disbursement would commence within the bank.
So they will verify whether these documents are original or not, right?
Yes, sir. Original as well as the signatures. Yes, they would verify.
And when you say original, you reconfirm that it's signed with pen and ink, physically signed by the concerned person.
Yes, sir. Yeah.
You have stated in paragraph 16, during the period that I was responsible for the NMC relationship with the bank, Dr. Shetty signed various extensions to the NMC personal guarantee. Have you seen Dr. Shetty signing any of these documents?
No, sir. Never signed in my presence, sir.
Never signed in your presence.
Yes, sir.
Paragraph 17, you are referring to an email dated 27 March 2018 from Nitin Babu, right? He's a junior relationship manager at the bank, to one Mr. Sandosh Shankar Narayan. He's also a colleague at the bank. His position was customer service manager.
Yes, sir.
And attached to the 2018 email is a scanned copy of a personal guarantee dated 25th March 2018, personally signed by Dr. Shetty. So you're referring to a personal guarantee which is dated 25th March 2018.
Yes, sir.
Has this document been produced before the court?
Sir, I'll just need to reconfirm. As I told you, sir, I'm not having access to the list of documents. So unfortunately, whether this has been part of the submissions to the court, I need to check and confirm on that point, sir.
You don't know the same answer as the previous document. Yeah.
Yes, sir.
So,
Same answer on that.
I say such a document was never presented to the experts appointed by the claimant and defendant in this case. I say the 2018 guarantee was never presented for verification by the claimant's expert or the defendant's expert. What do you say?
Sir, I can't confirm to you on that point because I am not aware whether the document is part of the list of submissions. So I need to check and come back to you on that point, sir.
And you said Nitin Babu personally collected the document from NMC, right?
Yeah. Yeah.
Where is he now, Mr. Nitin Babu?
Sir, I'm not sure. I need to check whether he's still with ICICI Bank or he's moved outside ICICI Bank. I need to check on Mr. Babu's current status. Yeah.
And you are saying that he would have verified the signature against defendant's passport signature, right?
They personally signed an MSA against the defendant's passport signature, verified signature on the written. Yeah, he would have just checked whether the signatures are as per the signatures that we have on records, and based on that, then he would collect the originals and send it to our office in DIFC, sir.
So it was Mr. Nitin Babu's responsibility to do the first verification, right? Whether it is real signature or not.
Yes, sir. So since he's the person who is collecting the original documents, yes.
And he is not being examined as a witness before the court.
Sir, with regards to Mr. Nitin Babu's current status, I need to check, sir, whether he's still with the bank or he's moved outside the bank.
So you don't know?
I don't know Mr. Nitin Babu's current status, sir.
This email dated 27 March 2018, was it addressed to or copied to Dr. Shetty?
No, sir. It would not have been addressed or copied to Dr. Shetty.
Okay. Then in your paragraph 18, we are coming to the end. Paragraph 18, a copy of another email dated 2nd July 2018, which my colleague Sandosh Shankaranarayanan sent to Praveen Kumar and Vishnu Nair of NMC, with Uday Nair of NMC and other ICICI colleagues, including me, in copy. Were he directly asked them to arrange for Dr. Shetty to sign various documents relating to the renewal of the 2013 Master Facility Agreement, including a renewal of the NMC personal guarantee, right? This is what you are stating, 2nd July 2018. This email was also not addressed or copied to Dr. Shetty.
Yes, sir.
By saying yes, you mean it was not addressed or copied, right? Just for clarification.
Yes, sir. Yes, sir. Confirm.
Okay. That's all, Your Lordship.
Thank you very much.
I've concluded 30 minutes.
Mr. Lakin, any re-examination?
No re-examination.
Well, thank you very much, Mr. Parekh. That's the end of your evidence, and thank you for coming. You're free to go now.
Thank you. Thank you. Yeah, thank you, Your Honor. Thank you, everyone. Thank you.
Thank you very much, Mr. Parekh. Thank you.
Thank you. Thank you.
Right. I think probably that's time to stop. Can you tell me, just before we disappear, what order you're going to do the other witnesses in, or do you know yet? Perhaps when you thought about it, you could email the registry and ask them to pass it on to me.
We will. I think, roughly speaking, Mr. Juneja and Mr. Rohit will be able to go first on Wednesday morning. Mr. Sharma said he will be able to dial in at 7 a.m. from Canada to join the hearing.
Our time or his time?
His time, which will mean 5 p.m. So unfortunately, we'll have the remainder of the claimants, two of the claimants' witnesses. I presume we will then start with Dr. Shetty, and then we will then have to either start with the expert witnesses and then have Mr. Sharma, or perhaps we'll.
And you're both, you've discussed this, and we'll make it work somehow.
Yes, we'll discuss it tomorrow and see what we can do. Would it be possible to ask whether the court and the transcribers would be able to extend time a little bit again tomorrow, on Wednesday? I know you have a hard deadline, don't you, my lord, on Thursday. You have a flight.
I can at the moment you've got me down as sitting till 11 UK time. I could probably manage 12, but no later.
Thank you. And on Wednesday, similarly, would we be able to sit a little bit longer as well?
I'll ask the transcriber. Transcriber, are you there?
Yes, sir. So at the moment it's scheduled to sit UK time 8 until 3. Is that correct? And you're
Would you be able to carry on till 4 if necessary?
Yes. Yes, I will.
I think probably 4 is the latest, or 4:15 the latest, because everyone gets tired at the end of a long day.
Yeah, and I know at the risk of sounding like a broken record, what's made it very challenging for me is the audio. If we can please
perhaps
try another
can,
laptop for
perhaps someone
Mr.
can
Shaheen.
perhaps someone can have a go at Mr. Shaheen's laptop and see if he can use another one.
Because that will make things much easier for me to last the longer day. But yes, I can stay later.
Right, very well. We'll adjourn now until Wednesday at 8 o'clock UK time, 11 o'clock UAE time. Thank you very much.
Thank you, madam.
Wednesday, we will start with the examination of the claimant's witnesses, right, Your Lordship?
That's what I understand it. On Wednesday, yes.
That will be Mr. Rohit Gupta, Mr. Gaurav Janeja, and Mr. Vikas Sharma, 3 people.
Mr. Sharma won't be able to attend till 5 o'clock, was it? UK time?
5 o'clock Dubai time, 7 a.m. Canada time. That'll be 2 p.m. UK time.
2 p.m. So if we can try and work around it, if necessary, starting Mr. Shetty's evidence and interrupting it for Mr. Sharma, would that be possible?
Ideally, the defendant should be giving evidence after the claimant closes the witnesses.
Of course he should. But I'm asking whether it's possible to adjust that in these circumstances where Mr. Sharma is in Canada.
I leave it to your lordship, whatever.
Well, no,
is
it's a matter. You can insist that the defendant only goes after the claimant's witnesses, but I'm asking you whether you would mind allowing Mr. Ketty, to start, if necessary, before Mr. Sharma.
Yes, your lordship. I leave it to your lordship's decision.
Okay. We'll do that if it comes to it. We'll go. We'll start with Mr. Shetty after the other witnesses, if there is a gap, and then interrupt him to hear Mr. Sharma. Okay.
So we'll have two other witnesses from the claimant in the morning, and after the two witnesses from the claimant, Dr. Shetty, and then Mr. Vikas Sharma.
Well, yes, but we may interrupt Dr. Shetty when at 5 o'clock UAE time, when Mr. Sharma becomes available.
Yes, your lordship, understood.
Yeah. I thought he was flying on Wednesday. You told me that before.
Oh, he left?
He didn't want to answer the question. Well, I'm not sure what happened there. Let's resume on Wednesday at 8 o'clock, and perhaps you can discuss it with Mr. Lakin in the meantime.
I will call him, your lordship.
Thank you very much. Okay.
Thank you very much.
Right, see you Wednesday.
See you on Wednesday.